আমি বুঝতে পারছি না। হ্যাঁ, ও সত্যিই বলছে। ও ওখানে ওই লিঙ্কে আপনি ওনাকে জয়েন করতে বলবেন, আইটেম নাম্বার 2 আছে তো। আমার 20 ওখানে জয়েন করবে, আর উনি ওখানেতেই লিখে দেবেন আইটেম নাম্বার 20, তারপরে স্ল্যাশ দিয়ে ওনার নামটা দেবেন, মানে পিটিশনার না রেসপন্ডেন্ট স্ল্যাশ দিয়ে তারপর ওনার নামটা, তাহলে আমরা এখান থেকে জয়েন করে দেবো। ঠিক আছে, এটা বলে দেবেন, এটা লিখে দিতে অবশ্যই, নাহলে আমরাও বুঝতে পারবো না কে ব্যক্তি জয়েন করছে। ঠিক আছে।
It should be done.
My lord, may I have your lordship's leave to mention one matter with notice? This is item number 572. My lord, the urgency is that
this
my lord,
court?
572 of
Of this court?
Yeah.
Yes.
My lord, I have let out my warehouse to Food Corporation of India and Food Supply Department of the government.
Yes.
Now, my lord, I am carrying on that business for the public, my lord, purpose. Now, my lord, there are adjacent land which is a vested land. My lord, I have asked for permission, which is in the process from the government, so that all the cars can be, my lord, parked over there for the government public park.
In the vested land.
In the vested. My lord, government is in the process of doing. What happened, your losses? In the meantime, local panchayat had started the constructions without any permission of any authorities and occupying that land. If that is, my lord, done, my purpose will be
You're
frustrated.
mentioning upon notice?
Upon notice.
Give the number.
My lord, I am mentioning upon notice, my lord. My lordships heard this.
Since I've started group, court number 10's matters, please mention court
Lord,
number
your
10
lordship-
matters first.
Lordship, code number
Please do it.
code number 10, my lord.
Yes.
My lord,
My lord, I-
take it up tomorrow, your lordships, because
It will appear in the list. Let me see.
it is in the list.
Lordships heard this matter previously. What happened, my lord? One need was issued, notice inviting tender.
Is it a hearing matter?
No, for extending the road, my lord. But in the PW road, some persons occupied their land. I have already served notice as per your lordship's direction. The matter is appearing as item number 275. As a result, the road is not widening. The work has been stopped. PW road has been
You're
occupied.
mentioning upon notice?
Yes, my lord.
Give the
State, I have noticed 275.
My lord,
My
may I
lord,
permit you
let
to
it be
mention
taken up on
upon
day after tomorrow. My lord, only.
Let me see.
Let it be taken up day after
Let
tomorrow.
it appear. Let me see.
My lord, the matter is appearing 275 item number.
Mention matter আছে.
Item number 2. No, it's a mention matter.
Mention matter.
My lord, may I permit you to mention my
Grateful, my lord.
Upon notice for correction. Your
Correction, yes.
With your lordship.
my lord,
Correction.
Under
My lord-
completing circumstances, I am mentioning one matter. The petitioners who are running their business the side of the statewide highway since 25 years. We got license from the Panchayat Authority and also Electricity Authority, my lord. Suddenly, my lord, one notice was issued by the Assistant Engineer, HON'BLE Division, to vacate the structure. And my lord, I challenged it before honorable this honorable court. That notice was stayed. During the pendency of the my lord writ petition, my lord, another notice was issued by the assistant engineer, my lord, under section my lord 10(1) of the my lord Highway Act. My lord, we objected. But without hearing my objection, my lord, matter was heard. We prefer appeal before the appellate authority, the district magistrate, my lord. Well, we, despite of our request, my lord, the district magistrate did not fix any date of hearing, my lord. They are not taking steps to remove the all structure, my 300.
Mentioning upon notice.
No, I am filing it, my lord. Let it appear Thursday or Friday. Otherwise, my
File
structure
and
will.
please file and give the number. I'll consider.
my lord,
With your
I will
lordship.
give the number.
File and give the number. I'll see. I'll
Yes,
consider.
my lord.
With your
If your lordship kindly, my lord.
Please
Sure.
file and give the number.
Yeah,
I'll
I'm giving
consider.
the number.
I'll consider. Yes.
my lord, may I permit you to mention my lord court 10's matter that 5 years lease mining lease has been taken, but it representation has still now not considered
Upon notice.
upon notice. And one contempt application, which one?
with your lordship's kind sanction.
Matter was taken up on 3rd January out of term. I can remember, my lord, in the name of my lord, excavation of my lord, the water body. When parliamentary interest a private individual who are claiming to be the owner. A portion of the my lord, residential plot has been earmarked and was about to be demolished. Now, lordship directed my lord to state government as well as the parliament to submit a report. And have to take any step in the matter to verbally directed. But it has been made returnable today. Matter has appeared to the 496. Now, we are no report has been filed. In the meantime, my lord, a development has taken place. We have come across my lord, a porcha in respect of a plot of land, my lord. Actually, my lord, that is based in my lord, long back to the state. It's not the any individual property. My lord, so my parliament cannot my lord, interest any individual property, my lord, to work on a my lord, government land. So my lord, it is returnable, my lord. I know my lord, all it directed. If my lord, it has come.
It's already appearing today.
But 490.
And you need to come back with a supplementary affidavit, I think, on this.
Only my lord.
And annex for annex.
Mention matter, my lord, any day. My lord,
You're mentioning upon notice.
Well, it was about to appear my lord today, but I do not know, my lord. I was of the impression that it will appear my lord in the higher side, but it's 496. I will serve notice, my lord. Let the matter
It's
appear.
not in the mentioned matters.
No, it let matter appear in the mentioned matter.
496 mentioned matters. Sorry.
Let the matter appear.
Please mention upon notice.
Let it appear tomorrow, my lord, upon news.
My lord, may I
Your lordship's kind sanction.
One matter, my lord, it is appearing as 511 of your lordship's monthly list. And my lord, urgency is this, the private respondents are making unauthorized construction
Are you
over.
mentioning upon notice?
Yes, my lord. Yes,
My lord,
my lord.
item number 536 of the monthly list, my lord. The petitioner made an application under section 10 of the Highways Act, but without permission of the authority, the other side made construction, my lord. Upon notice, I have
Notice.
mentioned. Yes,
Give
my
the
lord.
number.
My lord,
Yes.
Item number 600. My lord, urgency is this, my lord. I am suffering from order of injunction. My lord.
This is this is court number 19's matter.
Yes, Lord.
Please wait.
My lord,
My lord, upon
my
mentioning,
lord,
I'm
with your
compelled to
lordship,
mention this.
kindly, my lord, this is the matter relating to item number 515 of today's list. Your
Yes.
lordship, I am mentioning on notice. The local BDO is constructing a structure over my private property without following any norms, without serving any prior
number.
notice.
The number.
My lord, upon
I am
notice, I'm
serving on
mentioning
notice.
this matter, my lord. My lord,
Restoration upon notice. Give the fresh content. Give the number.
my lord, upon notice, I'm mentioning this matter, my lord. My lord, this matter has been released from the list of courtroom number 9, my lord, due to want of want of determination, my lord. I'm mentioning this matter before this court. Upon notice, my lord.
upon notice, I am mentioning, my lord, item number, my lord, 429. My lord, for upgradation, my lord. And my land has been, my lord, acquired by the government, my lord, award has been passed against the private opposite party, not from me, my lord.
My lord, I am mentioning for inclusion in my lord's.
Upon notice.
My lord, I am for the respondent here. The matter has been filed at.
All the more it should be upon notice.
May I have your lordship?
Matter.
May I have your lordship leave to mention one matter, my lord? My lord, this matter is appearing as item number 21 before my lord's list. My lord, my lord, the interim order has been expired, my lord.
This court.
Yes, my lord. I'm mentioning upon notice, my lord, for extension of interim order.
Order.
Yes, my lord.
Extension of interim order.
My lord, may I permit?
When
to
is it
mention-
expiring?
My lord, it expired yesterday, my lord. The matter was not taken.
May I permit to mention, my lord, one arbitration matter. Mailing list item number 457, my lord. The respondent, my lord, legally encroached the land, my lord,
You're
petitioner's
mentioning upon
land.
notice.
Yes, my
Give
lord.
the number.
Plus, there is another one, my lords, that is also on the same matter, almost same urgency.
Upon notice.
Yes, my lord.
Give the
it's upon-
numbers. Yes.
This is relating to court number 9.
19, please wait. I'll just finish with court number 10 and then I'll take up.
Your lordship,
Yes.
permitted to mention, your lordship. Your lordship, yesterday I've mentioned the matter, your lordship, and it was duly accepted by my lordships. But we got to know that the requisition is in mandamus and our file is lying in the RD section, your lordship. So I may I be permitted to mention again today, your lordship.
This court's matter?
Lordship, the matter is wrongly appearing in the list under residuary determination. So I'm praying for releasing of the matter.
Release. To be mentioned, release. So we are done with court number 10. Yes, court number 19 matters.
My lord, 19 matters, my lord, compelling circumstances, my lord, I am saying this to mention 665. In this matter, my lord, matter relates to, my lord, on unauthorized construction. My lord, I am suffering from the order of injunction. My lord, I am the landowner. My lord, actually, the unauthorized part obstructed my light and air. That's why I initially filed an application before the municipal authority. Municipality actually passed an order for demolition, and challenging this order, my lord, the developer filed two suit. One is the title suit and another is the municipal appeal. In both the cases, my lord, the interim order had been refused, and thereafter the developer filed an appeal before the appellate forum and obtain an order of injunction behind my knowledge, behind my back. My lord, Lordship kindly take it up at any day at 3 p.m. before Friday. Actually, next Friday is the date of extension. My lord, unless Lordship interfere in this matter, my lord, they will get in.
Are you mentioning upon notice?
Yes, yes,
Upon notice?
yes.
Give the number, let me see.
My lord, may I be permitted to mention this matter? It is relating to court number 19, my lord, item number 1345, my lord. My lord, the learned court below fixed the date for issuance of warrant of arrest on 2nd February, my lord. Let it be taken up before prior to that, because it is a execution case where I have paid the more than the asking money.
Bench is coming back much before that, sir, so there's no urgency.
My lord, if your lordship.
Like, I am in charge
Lord.
till 22nd, so there's no urgency. Please wait for the regular bench.
My lord,
Yes,
may I come back on? My lord. Otherwise,
next Monday will be the last day. Me dealing with that, those matters.
May I have your lordship?
Regular bench.
Well, yesterday I already mentioned with notice, my lord. Your lordship's matter is urgent on 18 January. Day after my lord. Well, the matter will be taken up by the learned court below for delivery of the judge. Now, the against the plaintiffs has already filed the tribunal application. Interim order has already been expired. Thereafter, the matter was fixed on 9 January 2024 by my lord Justice Court number 19. Now, after that, my lord, due to out of court, my lord,
You're mentioning upon notice?
yes, yesterday I
number,
already
let me
mentioned.
see.
My lord, did it appear?
Give the
May I
number.
have your lordship, may I have your lordship's kind leave to mention this matter? This is item number 659 of today's list, your lordship. I am mentioning upon notice. The urgency is that they have started constructing on my property. Any day my tenant shop will be demolished, your lordship. I have mentioned it.
Upon notice?
Yes, your lordship. Kindly.
Upon notice?
File.
When is the next date before the trial court?
Next is, March 2024, but the matter is that Justice and the wife and the husband is agreeing with that. During the stay period, they are approaching for an expiry order. And they are imposed first upon me.
The next date is 5th March, you say. So you can wait till the regular bench comes back, isn't it? Regular bench will be back by on 22nd.
I'm waiting for this. We are fighting the audit with the opposition, but they are approaching with that court option.
Yes, but the next date before that court is 5th March, you said. So you have sufficient time with you. Wait for the regular bench, please. No urgency.
Your
Yes.
Lordship, may I be permitted to mention two analogous matters for extension of interim order? The interim order is expiring on 31st of January
The
2024.
regular bench will be back before that, madam. You can wait.
My lord, may I have your leave to mention one matter under the heading new motion? My lord, this is a matter in which the petitioner is preferred an application under section 7.1 and 7.2, which was earlier rejected. My lord, the opposite parties preferred another application under 7.3. My lord, they are praying for striking of the defense of the petitioner. My lord, the next date is fixed on 18 January 2024.
You know,
Obliged, my lord.
extension of interim order is still 30. You said it's still 31st January.
Obliged.
So why do you need to?
New motion.
Yes. You have said it is still 31st January. I have just asked you and you said the interim order is still.
The matter is that court is of 5th March 2024. But the extension is
Extension of what?
of interim order.
What is the interim order in a section 24 application?
The state of
Please show me the interim order.
can see that order structure.
Where are the orders?
এটা তোমার তোমার এটা 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 তো আমার এটা অপশন আছে না না এই দুটো না ওটা ওটা আপনার এটা তো তোমার আপনার
Have you seen when the interim order expired? When did the interim order expire? Sometime in May 2023. After that, there was no extension. So what is your urgency now in January 2024? You can wait till the regular bench, please. It has expired sometime in May 2023. So in any case, in this way, it cannot be extended. You have to file an application.
May I seek your lordship's kind indulgence to mention an item which is appearing in today's list
Yes.
as item number 41, that Mausami Bodua versus State of Assam. My lord, we have come all the way from Delhi. Lordship may kindly keep it in the top of the board because 12:30 possibly after that it may not reach. So
Is item number?
41.
This matter, there is an oncoming situation in this. What has happened is the last occasion, the matter was taken up on 28th of November 2023. Subsequently, my lord, the private respondents got the matter listed before your lordship without putting us to list. We are the petitioners. They got an order, they got the date modified. That also, they have not commented us to the order.
The date?
Yes. And the date of initially the order of 20th of November was scheduled for yesterday, 15th. So we were there in the subsequently suppressed. When we come across this order of 4th of December, when we find that we have not been able to mention after listed the matter under to be mentioned, they got the order. And that order has not already.
May I clarify your lordship?
Say that you what do you actually want to say? You are not ready today for the hearing.
No. I think my
lordship may recall.
may I clarify? May I clarify what has happened? My learned friend is not aware of it.
Yes.
No, you don't require to be
It
put
was
on
fixed
notice.
for 16th.
No, you do not.
It was fixed
Your
for
lordship,
16th.
your lordship's order was subject.
Was not communicated to us.
Can I make my submissions, please, before you start?
Yes, your junior friend has made this submission, sir.
He's making the same. No, there's no consent. Your lordship will recall of the instance of my learned friends here. Your lordship had fixed the matter on 6th.
16th.
By 16th, I'm sorry. By error in the order, it went down to 15th. That is the only thing I got corrected.
Yes, my lord.
Nothing else.
Nothing beyond that.
What was it? How is he prejudiced by it?
And they were very much present in the court. They were
present in court.
They were knowing very well. With their consent only, the date has been
It was fixed on 16th.
That's right. That's all I got corrected.
Mistake. It came down. It went down as 15th.
No, I'm sorry.
My lord,
Kindly see the second order. It was at his instance that the matter was fixed on 16th.
These are all very petty matters.
I don't understand how he's prejudiced by 15th or 16th.
my lord, with their consent only, the date has been fixed.
Only the date has been corrected. That's all. Your lordship has recorded that. That's it.
They cannot get a better.
It's not a question of getting it listed. It's a matter of getting an order corrected. A date which has wrongly gone down in the order was corrected. No, sir, please keep no. I'm sorry, I defer. I'm sorry, I defer with you. What is mentioned? Please see the order. Please see the order. No, it doesn't have to be put to notice on this.
This was a typewriter.
That's right. That's all I got corrected.
On the part of the court.
On the part of the court. Why do you need to be put on notice for it?
Made a wrong type.
And my lord,
typing. So
Unnecessary noise they make about silly things.
I mean.
No, of course it is acceptable. An error of the court is being rectified. What notice do you require?
Let us not waste further time on this very.
I don't understand why he is making a noise on this. Trivial issues he raises.
Let me call the matters. If I'm not able to hear it today, I'll fix it tomorrow early. Yes, you are there.
tomorrow we have matter in Supreme Court. One matter is already there. That's why we thought any date.
Lengthy matters, you've come only for the day.
It is our submissions who has to start. My lord, Mr. Mitra is now going to begin his arguments on this, if your lordship recalls.
In fact, my lord, with their consent only, we have fixed up the date so that this can be finished up to the once.
Can it be finished in a day? You have come for a day, you say. That's what I'm asking.
The Mr. Mitra's
Anyway,
submission
we'll
will be
leave it
over
to
in
your
a day, and he will take just the simple one, whatever your lordship fixes the time, he would finish his submissions.
Will you come at 12?
Very well. We'll come at 12.
This is about Shumadan.
Oblige.
Ask it list. 41.
At 12 o'clock. Grateful.
Yes, call the days list.
Stupid things they keep raising all the time.
We have finished our arguments this matter.
Is that matter?
Is that
Very-
I'm hearing.
Nothing 22nd. Let me extend it for a limited period.
My lord will extend.
I'm being
But
led
I'm
to
also appearing.
Mukherjee is appearing virtually, Your Lordship.
I'm sorry, I'm unable to appear online physically today, my lord.
Hearing matters will be taken up from 23rd onwards.
23rd onwards. My lord, any day we just have to conclude, my lord. In reply, my lord, we won't take more than 15 minutes, my
It will
lord.
take a,
we have completed their reply.
so it will take a day, I think.
Yes, my lord. 15 minutes, 15 to 20 minutes will take us, my lord. Any day.
Heard learned counsels for the parties. Since the interim order granted earlier has expired on 15 January 2024, the said order be extended till let it be 16th February. 16th February 2024 or until further orders, whichever is early.
And my lord, will lordship fix it? Oh, matter is fixed on 16th February.
No, the
My lord,
interim
your
order
lordship.
16th February. It will automatically
will you-
appear in the list. 23rd,
Okay, my
it will automatically appear.
My lord, instead of 23rd, my lord, I have some personal difficulty on 23rd only.
Let it appear because I'm not fixing hearing matters. No, let me
Okay,
see.
I'm obliged, my lord.
Grateful, Your Lordship.
Yes.
Possibly
yes.
23rd will not be because hearing matters Monday and
23rd is a holiday, by the way.
It's
January is a holiday.
Sorry, my lord. Yes, my lord.
automatically.
Yes, my lord. I also forgot. Yes, my lord.
Yes, next. Huh? Hearing matter list automatically. Next.
Lordship,
2 days for extension of interim order. Right?
Lordship, the interim order has already expired on 15th December 2023.
You are the petitioner.
My Lord, we have all. They have already served the affidavit. I have received.
Application for extension of interim order.
Kindly submit. On
Have come with the formal application for extension.
Let me submit. Kindly submit.
Yes.
The order has already expired on 15th December 2023. Now, my Lord, this entire things has to be completed by 15th December 2023. Now, on 8th December, I suffered a serious accident. And as a matter of fact, on the advice of the doctor, I took complete bed rest for 15 days. Now, unable to come before this court and take proper steps. And this is not the willful default. Though they have already served the affidavit
You are Mr. Bishash.
on behalf of petitioner.
Petitioner. Another learned counsel was appearing for the petitioner. Why didn't he take steps?
No. I am appearing on behalf of the petitioner.
Yes.
Shamoli Hajra versus State Board of Inspection and others. They have already served the affidavit and our reply is also ready. Next week, we will also file the report. The reply. So,
Are you Nirmal Vishwas?
no, I'm Ashok Hajra.
You are not Nirmal.
No, I'm Ashok Hajra.
You suffered.
Yes. I'm an advocate on record. So kindly, in this meantime, kindly extend the interim order. By this time, I'll file the report.
Yes.
Not there should have been. He should have come with a formal application.
There should be an application because it has expired
Without
before 1
application,
month.
not you want the extension of
If
interim
it
order,
is
not-
before
What
expiry,
is the issue in this prayer now?
This is your kindly submit because this is your extraordinary power. You can,
Long ago,
if you
Lord,
cannot.
it should have come in
extraordinary
the
power is
system.
not beyond law, sir. If it would have been within the
Because
expiry date,
my reply is always ready. I can file by next week.
But extension of interim order, I joined the issue.
please file an application for extension of interim order. Affidavit and opposition submitted on behalf of the
Reply that.
respondent numbers 2 and 3 is taken on record. Paragraph learned counsel for the petitioner seeks to seeks accommodation to file the affidavit in reply. Paragraph, let the matter appear under the heading, this is hearing matter.
Hearing.
Group 1 hearing.
Those
On 7 February.
Second last page is the of my affidavit of service is the postal receipt, and last one is the track report, my lord.
Yes, it is served.
My lord. My lord,
Is there appearance
this
for the contender? No.
no, my lord.
Order complied?
No, my lord. My lord, the order was that, my lord, kindly take up the impugn order, my lord. My lord, having considered
The
second,
representation was
my lord,
directed to be
yes, my lord,
considered.
considered within a specified period of time, that without considering that, the concerned BLNLO is trying to
Difficulties in the writ petition, I find Mr. Roy and Mr. Guchait appearing. They are no longer in the panel.
my lord. My lord, I've personally served upon the means in the name of the
Yes, I've
alleged
seen that.
contender,
Yes.
my lord.
Mr. De, in the writ petition, Mr. Guchait and Mr. Roy were,
District Howrah.
I'm issuing, contender has been served. I'm issuing a notice as to why rule shall not be issued. So, will you appear in this matter? Because I cannot regularize your appointment in this matter. Let me record his submission.
My lord.
Affidavit of service. Paragraph. On prayer of the alleged contemner, the matter is adjourned. Paragraph. Let the matter appear under the same heading on 12th February.
My lord.
Next. Huh? This is the number. Huh? Oh, you regularize have an appointment. Emily number. Contempt. Yes.
Can you see your lordship's last order? Third para. The second page, my lord.
Yes, has the order been complied with?
Lord, we are filing an affidavit of compliance, Lord, for your lordship's consideration. So this is by the MD of Lord, this highway corporation.
What does the affidavit say? Has it been complied with?
Lord, so far as Lord, the MD is concerned, Lord, he has done his job, Lord. Now, Lord, it is to be executed, Lord, by the SDO. Notice 29th hearing. Now, the SDO, Lord, has sent a notice, and Lord, the hearing is on 29th of January. But if your lordship may kindly, my lord, have a look to my lord's order, against which my lord contempt has been alleged. This my lord will find my lord at page 15.
The second respondent was directed to take steps. What is the second respondent?
That is the MD, managing director. My lord, the second page of the order, in view of the above, this court is inclined to hold that since the encroachment upon government land has been found by the authority, the concerned authority being the second respondent herein is directed to take steps. Second respondent means MD. For removal of such encroachment within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all interested persons, including the petition in accordance with law. Now, my lord, this was the direction of my lord, on 12th of June 2023.
Yes.
Now, my lord, I'll just give you a lordship of the sequence of facts. My lord, then my lord, all these documents, my lord, are annexed. Now, my lord, this was on 12th of June, my lord had passed this order. My lord, on 28th of June, my lord, a hearing notice was given to the encroachers. Then, my lord, hearing dates were fixed, my lord, on 11th of July. Then nobody appeared. Then 14th of August, my lord, another hearing notice was given. My lord, that notice was also refused, but my lord, on 29th of August, 13 of the encroachers, my lord, they had attended the hearing. Then, my lord, the notice of removal within 14 days was given on 29th of August, 2023. 7th of September, my lord, a notice under Section 10(1) of West Bengal Highways Act was given. And the project director, my lord, thereafter, my lord, approached the SDO for removing the encroachment. Now, my lord, what happened is, my lord, all these were, my lord, between the SDO, BLRO and all that, my lord, without realizing that, my lord, your lordship's direction was on the MD. Therefore, my lord, the MD, my lord, gave a hearing notice, my lord, on 11th of October 2023. All are, my lord, on record, my lord. I'll
It's passed an order on 29th November. Have you seen that?
Yes.
That is recorded in the earlier order.
Yes, yes. Now, my lord,
Encroachers.
yes, my lord, we are not supporting, my lord. Now, my lord, it has to be executed by the SDO. But so far as we are, I mean, my lord, the MD is concerned, my lord, he has, my lord, passed his order, he has directed. Now the execution is only left, my lord. If your lordship may kindly direct, my lord, the SDO, or my lord, we can come back, my lord, after some time by the, by this time, my lord, I believe, my lord,
Where is the order of the MD?
my lord, the MD's order.
41 capital, 41 capital.
Judge Saab ko na hai? My lord, if your lordship may kindly take, my lord, page 41A, which is 29th of November 2020. Yes, yes. Now, but this has to be executed. But in the second page, penultimate paragraph, kindly have a look, my lord. In view of the above facts and circumstances, it may be inferred that the land belongs to the government. The petitioner is in no way has any entitlement. There is sufficient space for the petitioner to enter into the land. No public interest litigation has been filed, as it appears that the petitioner does not have any locus standi. WBHDCL at present is not.
Dealt with in the earlier
Therefore, now, therefore, after taking into consideration all the facts and reports available on record, it is ordered that the SDO is hereby directed to complete the procedure communicated to him with a memo dated 21st of September under Section 10 of the Act. 61. Then the Highway Department sent it to the SDO. Yes. Now kindly take me at page number 61.
The plan to be finalized to the PLRO, particularly it is given by the SDO.
But I believe, my lord, within a month, my lord, the execution will be over, my lord. Now, my lord, we don't want to, my lord, disobey the court's order, my lord.
You have already disobeyed the court's order. Have you seen the earlier order? Your MD was supposed to be personally present before this court today. Where is he?
My lord,
When that issue rule, let him come and reply.
my lord, could I say this, my lord, with utmost respect, my lord? My lord, there has been some delay, my lord. I don't say, my lord, that there's.
Earlier order, has it been complied with?
My lord, today, my lord, so far as, my lord, I am concerned.
December?
Yes. 5th January, the SDO notice.
There was a very clear direction in this order which has not been complied with.
My lord, please take my.
Present in court today personally. Where is he?
My lord, may I very humbly submit this, my lord. But so far as the MD is concerned, my lord, if your lordship may, kindly, my lord, with all, my lord, humility, my lord, I am submitting this, my lord. My lord, the order of my lord was on the MD. Now, the MD, my lord, in my very humble submission, my lord, has done, my lord, whatever was to be done by the MD. Now, my lord, the execution, my lord, is to be done by the SDO. Please consider this, my lord.
Observation in this earlier order.
Yes.
Do you think that the SDO is going to comply with this order?
No, that will he has to comply with it, my lord. But the court's order has to be complied with.
The order very clearly says that it is not, if it is not complied in its entirety, the MD has to be present in court. This is a second violation.
But kindly, my lord, give us a month's time, my lord. It will be complied with. My lord,
Otherwise, rule.
My lord, obliged, my lord.
my lord, 29th, my lord, is the hearing, my lord. Please post it, my lord, after 20.
No hearing, no further hearing is necessary.
My lord.
Very.
Obliged, my lord.
But kindly observe that, my lord.
Rule will be issued on the next day. I can guarantee you that.
My lord, obliged, my lord.
Affidavit in compliance submitted on behalf of the alleged contender is taken on record. Paragraph, it appears from the affidavit that the order under contempt has not been complied with till date in its entirety. Stop. The alleged contender is also not present before this court to submit an explanation to that effect as required by the order passed on 13th December 2023. Stop. This amounts to a second violation of the order passed by this court. Paragraph, however, comma, on prayer of the alleged contempt, on prayer made on behalf of the alleged contender, comma, another week's accommodation is granted to the alleged contender for compliance of the order in its entirety. Paragraph, let the matter appear under the same heading on
The act is just not under.
24th January 2024. Stop. It is made clear that in the event the order under contempt is not complied with in its entirety, comma, rule will be
My lord. My lord, on last hearing, one original copy was placed before your lordship. Can it be replaced with a Xerox one, photocopy one? Order of managing director dated 7th November 2020.
Yes, next matter.
Obliged, my lord.
I'm grateful.
Item 5.
Please, Your Lordship, my lord. But I appear for the applicant, my lord, on
Sir.
served, my lord. On 8th, my lord, Your Lordship had taken up, my lord, my contempt application because the writ petition was fixed on the 11th as well.
I am appearing on behalf of the respondent number 7 and 8, my lord. I have filed Wakalatnama, my lord.
Contempt not 2-3. এই মামলাটা স্যার contempt not 3.
My lord, in this matter, my lord, contender number, that is he. Only
They are appearing.
Your lordship will see the contempt application page 5, my lord.
Who is the contender? Let me just find it.
Inner, my lord, Indrajit Malik, block land and land reforms officer. He is not the block land and land reforms officer.
This is not the mind actually.
My lord, if your lordship will see the contempt application, it's the page 5. Everything is, my lord,
Wrong.
not in order.
When is the order passed? The
My
order
lord, the initial order, my lord, Your Lordship was at, my lord, on
taken.
the third, my lord,
Not find the order under contempt
my lord, page number 23 of Your Lordship's brief, my lord, page number 23
of the contempt application.
of the contempt application, my lord. This is, my lord, CPAN 1627 of 2023, my lord.
Yes. Page number 20.
Page number 24, my lord. That is the first, my lord, order that Your Lordship had passed. My lord, Your Lordship will kindly take up page number 25, which is the interim order. No further steps, including raising of construction, be taken in respect of the plot in question by the state respondents till 30th of June, 2023, my lord. My lord, this interim order, my lord, was subsequently extended from time to time and is still subsisting. My lord, what had happened, my lord? Pursuant to passing of this order, my lord, we had communicated to the concerned authorities that, you know what, look here, this order has been passed. You were represented on that particular. Absolutely, my lord, absolutely. Now, my lord, this was despite all of that, we had communicated it. Now, my lord, in flouting this particular direction, my lord, the construction was raised. We have photographs annexed to the contempt application, which indicates, my lord, that the particular establishment which was sought to be raised, my lord, which Your Lordship would find, my lord, at page number 60 of Your Lordship's brief. Well, they're continuing with the constructions even yesterday.
60.
Page number 60, yes, madam. And my lord, on occasions, my lord, the block land and land reforms of the block development officer had personally visited the site, instigating the workers to expedite the construction work process. My lord, your lordship would find from page number 60 that construction is going on. Even yesterday, my lord, I have photographs which has been sent by my client that electrical wirings have been, my lord, sought to be installed.
Yes, let me hear the respondents and then let rule be issued.
My lord, your
They
lordship
are so
will see.
desperate.
There is no, my lord, I appeared on behalf of the state, my lord.
Yes.
That is contempt, but the contemptor, my lord, Indrajit Malik is not the BLRO.
All the respondents were directed.
All the
All the
respondents,
state
but in
respondents were directed.
contempt, my lord, he only 1, 2 and 3, my lord. If your lordship will see the contempt application.
Is a video.
Who is raising the construction account?
My lord, may I just indicate, my lord, respondent number 2 and 3 are, my lord, the Gram Pradhan and the executive officer. My lord, they are the issuing authority. It is under their, my lord, blessings that the construction is being raised. Now, my lord, this particular tender, which is for construction of a solid waste management plant,
Department of Panchayat and Rural Development.
my lord, he is not a contempt, my lord. I have not alleged. My lord, kindly takes up page number 5, my lord, I'll just indicate. My lord, page number 5 of my contempt application, I've implemented 3 persons as the alleged contemptor, which is the block land and land reforms officer, my lord, the Gram Pradhan, as well as the executive officer. Now, my lord, the Gram Pradhan and the executive officer are jointly, my lord, raising the construction by way of a tender. And my lord, the respondent number 1 is a supervising authority.
So these 3 persons are in contempt.
Absolutely, my lord, yes. And both 3 of them have been served. And the Gram Pradhan, my lord, on each occasion, my lord, has refused my intimation. I have those.
Now, my lord, if your lordship will see contemptor number 1, Indrajit Malik.
My lord, Mr.
He is
Chatterjee.
not the BLRO. How the notice was served?
He is not the BLLR.
Yes, my lord, he is the executive officer BDO.
BDO.
His designation is BLRO, my lord. Now, my lord, if your lordship will see Onno Datta Mundo. My lord, এটা ঠিক আছে, এটা গ্রাম পঞ্চায়েত প্রধান। Now, my lord, third, my lord, Monica Bain Sarkar, executive officer of the working as for gain of he is not the working
Executive officer.
Well, this is what has been informed by my client. If he supplies the names, if he supplies the name, my lord, I'll correct it during the course of the day itself and serve my lord.
This way they are flouting the order.
Who are the persons?
My lord, that is the Indrajit Malik is the BDO, block development officer.
Who is the BLLR?
BLRO is the, my lord, BLRO is Nitish Das Mundal.
Nitish Das Mundal, click.
And
Allows us to
the
correct the cost.
executive officer Katwa 1?
That is the Indrajit Malik. Monani, my lord, the third, that is the Monica Bain Sarkar is not the executive officer.
He is Sabapati.
Executive officer.
Executive officer Indrajit Malik.
Oh, Indrajit Malik, who has been edited
As a block land.
Yeah. So, my lord, in any event, my lord, he is aware of it. If the executive officer, my lord, I have sent letter to Indrajit Malik. No, I'll correct the cost item, my lord, during the course of the day.
And Mr. De, please ensure that there is no further because
My lord,
construction
no
is going
construction
on.
is there, my lord. My lord, I am coming before your lordship that there is no any construction. We must supply that. And my lord, we can show the petitioner's, my lord, statement in the writ petition. My lord, I also find the report in the form of the evidence, my lord, within 7 days, my lord. This is a very urgent matter, my lord. He took that thing, my lord, it is already settled to the Gram Panchayat by the authority.
Rural Development Authority.
By the authority, my lord. Now he is coming and saying that I filed one application before the authority to get the my lord long-term settlement, and for that reason.
That is on merits, Mr. De.
Yes, my lord.
There was a direction not to make any further construction.
No construction is there, my lord.
Sir, we have evidence to that.
My lord.
Yes.
Of the application.
My lord, there is a big ground, my lord. If some person is there, my lord, that is not the working.
Lord,
What photo is there, my lord?
Page 60.
Yes, my lord. What is that photo?
16.
My lord, man is standing. And what was done, my lord? There is a construction that is a minute. That is the construction is there, my lord, allegation is there. If the person is, my lord, with a jhata,
Interior.
61, 62, 63,
My lord, I
64.
don't understand, my lord, we are also village people, my lord, we know how, my lord, they are. They
How the
they are some
They
party,
are
my lord,
carrying
they
bricks and mortar for the page 63.
63, 64.
They are digging the ground. Is this not for construction?
62, my lord, that is the one person is. And my lord, 63, some person is going there, here and there.
Going here and there.
Not here. So they are
Yes,
carrying
my lord, some
bricks,
person
mortar.
মাথায় কিছু নিয়ে that is the my lord, in the village people, they are going to one way to another way. You need to do through that. My lord, what is working? My lord, we must file it.
But I was praying for issuance of a rule. Lord, I was really praying.
Corrections.
Yes, Lord. Kindly Bani directs that, Lord. We shall correct the cost title, Lord.
Serve a fresh.
And so fresh copies, Lord. My learned senior friend knows everything. He has copies. I may correct it in his Lord.
Contempt application.
Very well, I'll do that. There is no problem. We'll do that within the day. Yes, yes.
And one will
It's already appearing.
will file affidavit on in this regard.
No.
Because the allegation.
But they can't carry on with any sort of work, my lord, in that premises. My learned senior friend says that, my lord, it's settled, my lord, to somebody else. No, there is an order, my lord, which says that the property belongs to me.
This is not.
They have not appealed against it.
Statement is not.
The statement, my lord,
On merits.
on merits. Yes, absolutely.
Since there's an order of the court, good, bad,
Uh,
indifferent.
you
that
have
be
to.
compliant.
My lord, writ petition, my lord, annexure P11, my lord, mandates that the land was settled to the
And
rural
instead,
development.
when we take up the writ petition, I'll consider that, sir.
My lord.
Not at this stage.
My lord,
When there is an order of the court, it has to be compliant.
my lord.
But apart from that, the merit application disposed of any. Dispute application disposed of any.
See, on prayer of the petitioner, liberty is granted.
If
The cost title of for contempt application
application extension on you.
by incorporating correct names of alleged contemners and 3. 2 is correct, I think.
1 is corrected, my lord.
2 is correct. 1 and 3 should be correct.
1, yes, my
My
lord.
lord,
1 and 3.
Pradhan is
স্যারের
correct.
সঙ্গে স্যারের সঙ্গে বসে করে
The applicant petition
Pradhanটা correct আছে।
Repetition extension on you.
serve notice upon the alleged contemners, number 1 and 3, and file affidavit of service on the adjourned date. Paragraph, learned counsel for the alleged contemners seek to submit an affidavit
এক নম্বরটা আর ওইটা হবে।
to the effect that the order under contempt is being complied with and no construction is being carried on in the premises in question. Paragraph.
Construction আগেই হয়ে গেছে।
Affidavit on the next day.
Yes, madam. Yes, madam.
Read application extension on you.
Of next date
which has been
4 weeks.
which is being disputed, my lord. Can you record that as well?
Open at line, the contention of
4 weeks time.
তারাও my lord দিচ্ছে তারা তো তাড়াহুড়ো
is
করছে।
denied and disputed by the.
Read
Sir,
application.
the interim order is till the 31st of January. Kindly extends that for.
that
No,
is
no.
in the-
Writ petition is appearing today.
Then the read application be decided.
It's being
Read
heard
application
together.
be decided. Since the disputed fact of the position. Land in
it's-
question has been settled to the Panchayat authority.
No.
Panchayat authority already constructed long before filing the read application. For the respondent of container 2 and 3, along with my letter. This is my lord,
Give the order. Heard and responses for the parties. Paragraph, since the interim order expires on 31st January.
31st January.
Expires on 31st January 2024, comma, the order be, the said order be extended till 29th February 20.
then read application be decided, madam. Both the matter, both the matter.
Definitely.
Otherwise, my lord, your lordships.
No, no, we want it. I want it.
That's true.
Let it appear on the same day.
Same day তো।
We let the matter appear. It's at the motion stage.
No, yes.
Yes, interim.
WP, huh?
মোশন তো বটে।
ওটা আগেরটা তো
ওটা করতে এখন আর।
let the matter appear under the head of one motion on 1st February 2024. On the same day.
20?
1st February.
21st
February.
First February,
1st February.
ঠিক আছে, ঠিক আছে, ঠিক আছে।
on the same day.
Yes, grateful to Lordship. Extreme.
Otherwise, better decide.
Kindly allows us, my lord, to correct the cost title, my lord, in terms of.
First title
During
bill,
the
please
course
service
of-
code.
Please correct that, sir.
Certainly, you know, during the course of the day will.
First address bill is topic.
Hearing first February.
দিদি ওই
Next.
আসবে এখন নয়, ওই অ্যাডভোকেট অন রেকর্ড আসবে। অ্যাডভোকেট
হ্যাঁ,
অন রেকর্ড
দুটা ঠিক আছে,
কোথায় পাবে?
1 আর 3 ভুল আছে,
তোমার
1 3 ভুল। না না, আমাদের এফিডেভিট কপি জমা দিতে হবে।
1 ফেব্রুয়ারির আগে জমা দিতে
আগে জমা দিতে
কপি দিতে হবে।
ও
1 ফেব্রুয়ারি তোমার তো তাড়াহুড়ো চাচ্ছিলে, তাড়াহুড়ো order। 1 ফেব্রুয়ারি।
একটু লং,
না 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 লং
লং কি তুমি এক্ষুনি তাড়াহুড়ো করছিলে এখন লং?
এই তাড়াহুড়ো করছিল কি?
আরে দিদা না, ঠিক আছে,
আরে
চলো।
দিয়ে দেবো দিয়ে দেবো দিয়ে দেবো।
With WPA করে দিন। না না দরকার নেই। Sit down with WPA. With WPA করে দিন।
Yes,
Order যা আছে তাতে যাবো।
গ্রেটফুল টু Lordship.
Next.
নাম দিয়েছি না, না কোথায় আপনি কোনটা? আমি ওই তো আচ্ছা আচ্ছা। Well, in this matter, I am appearing on both the petitioner. This is my affidavit of
Sir.
Yes,
My lord, yes, my lord.
হ্যাঁ,
My lord, next date of hearing was fixed
এটা
on
কি লেখা 7-8? ও রেসপন্ড
31st. On next date of hearing. Will you notice for me? Hearing.
No notice was served, no steps was taken.
এই notice was, notice যাবে তোমাকে
No notice, no steps has been taken.
এই নাও ধরো একটু দেন না একটু দেন না।
The impugned order, page 20.
My lord, 31st January is the date for hearing, my lord. Under section 10(1) of the,
Only notice has not yet been served.
encroacher was served. দেখে নিও, it is there. হ্যাঁ
Then one has been issued.
Issued, but no notice was served.
The encroacher.
No. Encroacher notice was issued. That is the first time I have this room. But my application, no notice was served upon me. In my application, what is the direction?
Maybe, but the purpose is served.
But purpose will be served, that the date was fixed for 31st. When কোন page লেখা? Oh, 31st January to
প্যারাগ্রাফ 4, এই প্যারাগ্রাফ 5
second.
থেকে নিতে বলা আছে। হুম
31st January 2024. Right?
to remove.
Remove, yes.
Thirty-first January is the date for vacating in 10(1).
Yes, my lord, remove.
So order has been substantially complied with.
Hello, first time that was disclosed. What is the order, my lord? That is the petitioner
That's what
submitted.
purpose has been served. You are
But-
asking for
but-
removal of
yes,
encroachment,
yes.
isn't it?
Yes.
So no use keeping this pending.
So, madam, kindly keep it pending on up to 31st. Thereafter, report will be submitted. Then I will.
After 31st report will not be submitted. So you are aware of
If-
10
if-
proceedings.
10-1 proceedings, but the petitioner, the specific direction is with the reasonable opportunity of hearing to all the interested parties. If they filed any objection, I was not till
Do you
today. I
still
was
require a hearing? 10(1) has been issued. After that, 10(2), 10(3), you will be served
entry,
notice.
order will be passed.
10(3),
But
you will be served notice.
yes,
The order under contempt has been complied with substantially. There was a direction for
then again after 10-1, if it is not adjourned, again 31st, I will again come. Because
Again come কেন?
again
Remove
come
না
because
করলে
you
তো
are-
10(3) হবে।
after giving, no, that is what is the order will be passed, not in my presence. That is the specific order from the date of completion after giving reasonable opportunity of hearing to all the interested person, including the petition.
Do you still need a hearing? You will go back. 10-1 has to be stayed and a hearing given to you. Do you need that? Do you require
No,
that?
no, I not only I am praying for adjourn it.
Not necessary. It has been substantially complied with. Since the proceeding has been initiated, it will be taken to its logical.
I will kindly record that hearing will be made on 31st January
That is on
2000.
record.
Record.
This is a contempt application.
Yes, yes. That will be record.
Affidavit of service. Affidavit of service filed
Next one is
by the petitioner and affidavit of part compliance filed by the alleged contender is taken on record.
Same 31st.
Paragraph. It appears from the affidavit submitted by the alleged contender that pursuant to the order under contempt, notice under section 10 within bracket 1 of the West Bengal Highways Act 1964 has been issued upon the encroacher, directing him, it's a lady, directing her to remove the structures on PWD land and vacate the same on or before 31st January 2024. So, paragraph. The order under contempt has been substantially complied with. It is expected that the proceeding under section 10 of the Act of 1964 shall be taken to its logical conclusion at the earliest. Recipients are disposed of. There shall have been orders.
Next similar order, similar date was 31st.
You are appearing?
Yes, yes. Appearing that is my affidavit of service kept in there.
31st January?
Yes,
31st January. That is
both are the same, my lord. Same order was passed and
next.
My lord, item number 8, there is a direction for filing affidavit. My lord, I have affidavit has already been, my lord, prepared, my lord. It has been sent for the to the department for vetting, my lord. 1 week time be sufficient, my lord. 1 week time be extended, my lord.
There's a substitution application pending.
Yes. My lord, this is a land, Kolani land, my lord, plot of land. This land has already been resumed by the government. And thereafter, after 2 years of the reservation, my lord, the petitioner filed this writ application without explaining the delay in the writ application. And that has been dismissed by your lordships by an order, dismissed for default. The petitioner was not there, and they filed an application for restoration. Not only that, in the meantime, my lord, in the year 2020 and 21, 2 of the writ petitioner they have expired, and my lord, they did not make any substitution application, so entire thing has been abated. So my lord, they filed 5 applications, scan application. I want to file reply. My lord, reply is ready, my lord. Affidavit in opposition.
Applications.
Yes.
I was thinking the writ petition.
No.
The applications.
Yes.
The applications, my lord, already
Time-
they have taken
time be extended,
time
my
on
lord.
2 occasions. And my
My
urgency,
lord,
my
1
lord,
week time.
my urgency, my lord, is the land. That it has already been
Already
it has been
63 years gone. So 1963, the land was allotted to her, the lady, because they didn't make any construction. There is a clause within 5 years they have to make construction. So they took 63 years from 63 to 2023. They didn't do anything. Now it is very urgent for them.
Come back with your affidavit and please confine your affidavits to the applications and for the time.
Yes, madam.
my lord, kindly the shortest possible time, my lord.
Learned counsel for the respondents seeks further extension of time to use affidavits in opposition as sought. Paragraph, let the matter appear under the same heading on 6th February.
My lord.
Next.
Urgent time.
Lordship, my senior Mr. Shonagit Kumar Ghosh is engaged on another corruption. This matter can be fixed on the returnable data, not today. Yes,
It's a
review
review application, my lord. It's a, my lord, that is possibly I could not make myself clear to your lordship so far the calculation is concerned. That's why I made this review application about my entitlement to the interest.
It is your application.
Yes, this is my application. Last application, the plea was taken that review application not been assigned to the learned advocate. Now he has come up with another.
Let him come back. Let him come.
But kindly fix up another short date, my lord, so
I will
that-
fix it for you. On prayer of the, you are appearing for all the respondents?
Yes, sir.
On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 8th February.
Well, if I correctly understand my senior friend, Mr. Dey.
This matter, my lord, I am for the state.
My lord, Mr. Dey, but if I am incorrect, my lord, Mr. Dey will correct me, my lord, on twofold submission he has made. One is, my lord, the writ is not maintainable for want of jurisdiction. And another thing is this, my lord, that LR Porcha I could not produce. That's why, my lord, I am not entitled to have the compensation in question.
Mr. Dey says Assets Acquisition Act.
Estate Acquisition Act. That's why. Now, my lord, this is, I have not challenged any action that has been taken under the Estate Acquisition Act. Neither I have challenged the resumption order, nor I have not I have challenged any order.
Surface and subsoil.
My lord. And my lord, all along your lordship will find they have said that in compliance of the order of the court, they tried to dispose of the matter in accordance with law. Nowhere I have challenged any action taken by the authority under the West Bengal Estate Acquisition Act. Now, to meet that point, my lord, that my writ petition is not maintainable, kindly turn to page 266
Of the writ petition?
of the writ petition, 266. The last but one paragraph, my lord. It is, however, clarified that it will be open to the appellant to challenge the order dated 16 July 2009 by an independent writ petition. He shall be entitled to all points which may open to him in law. My lord, that prompted me, my lord, to move before your lordship, and your lordship passed that order. And the impugn order is arising out of the order passed by your lordship. Now, my lord, the second point is this, my lord, that my learned friend has submitted with that land has already been vested with the state, and vesting, my lord, admittedly under section 29. And to this, my lord, I have already applied, make my submission, my lord, that I have never claimed any right, title, and interest in respect of the subsoil land. Only thing I am claiming my right, title, and interest in respect of the, my lord, the subsoil land, a surface land, surface land. And I have shown to your lordship, my lord, the section 4. If there is no contrary, my lord, the contrary view, then my lord, my right, title, and interest are heritable and transferable.
Mr. Dey said surface right has also vested.
Can't be, because I tell your lordship, my lord, that is not their case. Nowhere
Nowhere they have said that my surface right has been my lord, vested. All along their case is, my lord, the section 29, that the resumption, the colliery right. Because if that would have been vested, my lord, then my record of rights would not have been there. My lord, this is an RS record of right, my lord. I shown to your lordship, my lord, that kindly have a look, my lord, the certificate that has been issued. There is a issued, my lord, the certificate has been issued. My lord, state acquisition act at the cost of repetition, my lord, I am showing to your lordship.
101, I think. 101 is your record.
Yes. My lord, all along there is a certificate, my lord, that is finally published. And I have been treated as a riot. And subsequent to this, there is no proceeding, my lord, under the West Bengal Land Acquisition, West Bengal Land Reforms Act, that I am enjoying the excess ceiling limit, so that is vested. All along case is this, my lord, that the lease, that since I have not performed the terms and condition of the lease which has been granted, because that is automatic. I was under the I was a lessee. So the moment Act 53 came into force, I became the lessee under the state. So that has been resumption is there. Now, my lord, kindly see. That's why, my lord, kindly see, my lord, the page 207, page 207. But before that, my lord, kindly turn to, my lord, 203. There cannot be, my lord, two piecemeal nature and character of the land. 203. Why I am saying this, my lord? At the last but one paragraph, my lord, in that paragraph, my lord, line starts from 6th line. The compensation for the liability land, your lordship has got it. A few lines from last but one paragraph, my lord, few lines from the bottom of that paragraph, my lord. The compensation for the royalty land is already received by them. So if that be so, my lord, this royalty land is coming from the, my lord, my choice of retention. Now, moreover, my lord, let's kindly see the impugned order passed by the authority. Yes. Kindly recollect, my lord, this is for the first time they have come up with a story that LR record is not being produced. This is for the first time. Before that, my lord, lordship, kindly see at page 315. The Honorable Court directed, page 315. This is the impugned order. The Honorable Court directed the undersigned to revisit the case in the light of observation made in the said judgment as well as the order of coordinate bench in 2000 dated such and such. Gone through the judgment of the Honorable Coordinate Bench, where Honorable Court clearly mentioned it is for the writ petitioners to establish their claim with relevant document as indicated earlier. My lord, I will show to that particular word, my lord, in what context that was done. During revisiting the case, the undersigned feels that the LR record is a relevant document to ascertain the recorded owner of the suit plot at the time of acquisition, because the said acquisition proceeding was initiated in the year 1976-1977, but the writ petitioner produced all the documents which were issued in the year 1969. After scrutiny of updated LR record received from the office of the SDLR Asansol, the status of the record as follows. 2481, 2482, 2483, 251525. The aforesaid LR record reveals that most of the LR plots against the RS plot noted above are vested to the state, except plot number 2125 corresponding to RS number, which is recorded in favor of National Highway Authority of India. So it is clear that the writ petitioner is not the owner of the suit property, in the time of acquisition. Well, I will just take few minutes time to say this thing, my lord. My lord, mere recording, I submitted it to your lordship. The mere record. My lord, mere recording in the revenue record does not confer any narrative. Neither is extinguish my title. My lord,
That's settled.
it's a settled principle law, my lord. I cited this judgment earlier also before by the Supreme Court cases, paragraph 7. পন্ডিতা এই প্যারাগ্রাফ 7টা দেখে নিন, এটা ফার্স্ট টাইম দেখাচ্ছি তো, দেখে আমাকে ফেরত দেবেন। প্যারাগ্রাফ 7, my lord.
Yes.
Next. Now, my lord, your lordship kindly recollect one. I have also claimed my right, title, and interest about my residential house. That is 2542. There is no whisper about this. While disposing of my representation pursuant to your lordship direction, no whisper about that. Meaning thereby admittedly, my lord, I am the recorded owner of that property and government has using this. Even today they are running their office without paying any compensation, my lord. And record of right, my lord, if you like to kindly turn to page 1011.
101?
101, my lord, that is my record of right.
Yes.
2542, last but one, my lord, the 25 Bastu. And in paragraph 8, page 12, I have clearly stated that
Yes.
paragraph 8, page 12, my lord, I have said that sometime in the year 1974, the then collector Bordavan forcefully took over the possession of the land mentioned in the paragraph 2 here in above measuring such and such, without initiating any proceeding whatsoever in nature and without any payment of compensation thereof, including the residential building known as Sheba City of the petitioner situated in RS Dag number 2542. And he is admitting in the impugn order, even assuming, my lord, I say that their contention is correct. Even then, most of the land is record is vested, not the entire land. So it's a, my lord, it's an afterthought just to deprive me. This is the issue. They never raised before the court of law. Any court of law, the LRD produce the LR record right. On the contrary, my lord, he has said that, my lord, that he has quoted one order that it is for the writ petitioners to establish their claim with relevant document as indicated earlier. Kindly have a look at that portion, my lord, of Justice Talukdar. Page, my lord, 206. It cannot be read in isolation.
Yes, 206.
After taking into consideration, Rasa 207, after taking into consideration of the relevant facts and materials and submission made on behalf of the writ petitioner, I find no reason as to why the present dispute has to be kept alive for such a long time. If for the purpose of construction of the flyover, the same lands have been acquired, and if the petitioner established their claim that they are the owners of the said land, it is thus acquired for the public purpose, they are required to be paid for compensation. In case the authority could not do so in lieu of non-availability or non-production of the relevant record of right, the same can be taken care of immediately, since the present writ petition has copies of the RS record of right. And all along their cases, my lord, that vested under section 29. And moreover, my lord, why I am saying this, well, I will just complete my submission here and now. Kindly turn to, my lord, the page 2021. That is their whole case. My lord, today, my lord, second paragraph, today, Then my lord kindly turn to the last portion of that paragraph. Sri Khan reported that, Lordship, I got it. Sri Khan reported that all the documents relating to the properties taken from the Sri Sunil Kumar Mukherjee, West Bengal State Acquisition, could not be found. So therefore, my lord, they are admitting that my property, whatever has been, they have taken under the West Bengal State Acquisition Act. It is not their case that the property has been vested under the West Bengal Land Reforms Act or any other act. If that has been vested, my lord, then state cannot acquire his own land for the purpose of any construction or public purpose. And I was paid for the land which they have taken. Secondly, my lord, so he has filed one letter such and such. So all I know is they don't have any documents pertaining to this. That's why Justice Talukdar, as his lordship then was directed, to proceed with the documents which I have relied upon, if they don't have any document. Now they have come up with a story that LR record. And for the purpose of LR record, I have shown to your lordship, they will not mutate my name in the LR record when they are saying that my land has been vested. So these are all, my lord. So kindly, my lord, for the ends of justice, my lord, kindly don't demand it back to I humbly request your lordship, kindly direct them to initiate a proceeding. Admittedly, my lord, my land in the so far my property residential plot is concerned, they are using. And this is the admission, my lord. There is no denial to this. Kindly direct them to initiate a proceeding for the purpose of compensation. Deep obliged to your lordship.
I also pray, my lord, your lordship, do not send back, pass the order.
Okay, thank you.
That is my.
That will give rise to another round of litigation.
Yes, my lord.
Yes, my lord. Again, my lord.
Another proceeding. my
Again,
lord,
they,
will start.
one after another, they are come up with
My
a
lord,
story.
this, with reference to that, my lord, that is not applicable to my case, my lord. That is a personal to mutation in personal name, my lord. That is not applicable in this case.
My lord, in that case, what happened, my lord, that
My
I
lord,
was the
only if
husband.
the application only for
Husband
that
and sister came to the filed a suit in, when, my lord, the stepsister claiming to be a son of a daughter of a husband, my lord, on the basis of a will, when he mutated his name.
My lord, I may not
And
want
claiming
to,
title on the basis of that mutation, that has been decided.
we
So,
do not want to take much time of the honorable courts.
deeply objective.
Resolved. Conclude the judgment.
Deeply objective.
Next.
I appear on behalf of the state, late Amazon answer model. On the last occasion, my lord, one report has been submitted on behalf of the Special Land Acquisition Officer, my lord.
Yes, my lord.
Yes.
Your lordship might kindly recall that on so many occasions this matter was taken up, and then it was. Well, the case relates to a very, very marginalized section of the society, and this is a particular person. He's a scheduled tribe. He is the owner and recorded owner of this particular land. Now we came to know that suddenly that a entire property or the land was taken away by the forest department. Since we did not know, we saw the building of the forest department there, but we didn't know whether the specifics, whether my entire land was on that or not. So what we did, we made an application under the Right to Information Act. Now, in the Right to Information Act, if your lordship kindly takes up page 26 and page 27, madam. Annexure P6, madam. It's by the learned advocate. Madam, point A, whether forest department has constructed in building structure on plot number 2055 Moza so-and-so, district Birbhum, pin number so-and-so, whether plot number 2055 Moza Chandpur, Rampura district Birbhum has been acquired
by the concerned department of government of West Bengal? If so, then mention the quantum of the said vested land. Now, the next page is the reply. It says, in reference to your application dated 2nd of May 2016 under RTI Act, this to inform you that the construction of a Pakka building of Forest Department is found lying on plot number 2055 of Moza Chandpur, jail number 20. In regard to quantum of acquisition, this is to inform you that the said particulars may be available with the Land Acquisition Department, Suri. So, my lord, we were sent from one place to another. The ball started rolling. Now we kindly comes to page 29. Again, on right to information, we make an application. Point type of information required. I say whether plot number 2055, Moza Chandpur, Khatian number so and so, police station so and so, has been acquired by the concerned department or government of West Bengal. If so, inform the LA case number and also inform the quantum of the said vested land. If required, the same has been acquired under which act, please inform me the same and also give the particulars of the proceeding number if the same has been acquired after initiating any proceeding. Now, a reply comes up. Give it to your lordship. I'm sorry, madam, taking a little bit of time.
Find the reply.
Yes, I'm trying to find it. I know it's there, but let me, Malad, for a moment, Malad. Maybe it's before this or after this. My learned junior is not well, so Malad, I'm not getting his assistance today. But I must complete it. The reply was very much there. Yes, it's page 28. Page 28, Malad. With reference to your petition dated nil, it is to inform you that your application is not a specific one for want of required LA case number.
This is the earlier reply, page 28. Because your application was made on 23rd December. The
Yes,
release date-
yes. This is the previous one. Specific one, yes. Now this one, I think they have not even replied to it. Now the point in issue is, my lord, a report is filed. My learned senior friend has filed a report. And if your lordship kindly takes up the report for a moment, page 1, I, Pradeep Haldar, son of so-and-so by faith so-and-so, do hereby solemnly affirm and say as follows, that I am the Special Land Acquisition Officer, Birbhum, and respondent number 3 of the writ petition. I am well acquainted with the facts and circumstances of the case. I am filing this report in pursuance of the order of the Honorable Court. Now, kindly comes to paragraph 3. It is stated thereafter the advocate had filed another RTI application on the 23/12 to 2016 with requisite court fees seeking the acquisition status of the aforesaid plot. But the advocate for the applicant did not mention there in the LA case number. I do not know about it, Mullah. The Office of the Special Land Acquisition Officer, Birbhum, Suri, had given information on 17/1/2017, VRAIN memo number so-and-so, which is well ahead of 30 days from the date of receipt of the application as per rules as envisaged in RTI, and requested to provide the concerned LA case number for which the Office of the Special Land Acquisition Collector Officer, Birbhum, was not in a position to provide the required information. It is stated that the writ petition instant petition alleges that sometime in 2007, the plots were requisitioned by the Forest Department, West Bengal, for the purpose of making construction of office without giving notice. But then the said department has not been included as a party in the writ petition. Since 2007 to till date, the petitioner sat idle and did not file any objection against such construction. But I never said that. It's a misconceived one. I have said that I've come to know of late. Of late does not mean that 2007, Mala. And the moment I said they were trying to show off everything out of them. Now there's a building standing on my place, and your lordship knows that the scheduled tribe, if you are going to acquisition a scheduled tribe property, is not possible, excepting in special conditions when you have to go through the entire process, which has been laid down by the central government too. Now, nothing, my lord, no process, nothing. There's a 2-story or 3-story building standing thereon.
The report is also neither here nor there.
Yes,
Here the-
yes, yes.
Lordship, according to the prayer, the
petitioner land was enjoyed by the forest department. But our
Petitioner's land was taken by the forest department.
lordship
How have you
may be
taken the
correct
land?
or not, but at this stage, forest department is not party in the writ petition. Kindly allow the, as added party, the forest.
Representing the forest department
Yes.
of West Bengal.
Sir, he is not party member.
But the special acquisition collector is the person who acquires, my lord. What has the forest department got to do about it?
You requiring body.
Yes.
It is you who has to be.
It is true, my lord, but I several times
How
contact
to
it.
fix the acquisition? Please show me the documents.
According to the RTI reply, my lord, it was held by the competent authority, the land acquisition officer. The land was acquired or not, there is no any evidence, but unfortunately that land was occupied by the forest department. So kindly, lordship, kindly direct the forest department.
You are representing the forest. That is government of West Bengal.
At present, he is not party member.
My lord, I have only to say this, my lord. The acquisition has been done or not done. He is not in a position to say that too. The acquisition officer is not in a position to say that too. So there was no acquisition proceeding also.
Please implead the forest department as a party, and because Mr. Mondal is already appearing, you
Lord, yeah.
don't need to serve a fresh notice.
My lord, he will provide me with the address because, my lord, we do not know the forest department's address and other things.
The forest officer,
Divisional forest officer,
Theory.
Shivri.
Officer Theory.
Divisional forest officer.
Please amend the cost title.
Add him as a party.
And yes, add him as a party, and no further notice is required because you will be appearing for it. Then also.
My lord, till tomorrow, your lordship will grant me time because
Now, sir,
I cannot do it, my lord. I'm not the advocate on record, my lord. My learned junior has not come to the court today. If that order may be passed by tomorrow, we'll implead him as a party, my lord. I cannot stand on his behalf. Kindly does that.
Yes, please explain your stand. How was the land taken away and utilized?
2 weeks time.
Please
2 weeks,
explain.
2 weeks.
2 weeks for what?
So I call for all records every
I call for the all records from the forest department as well as the land acquisition officer. 1 week per way. 1 week.
The land was appropriated, my lord, because it's a
You want to come back with a report? Another. He needs to file the documents.
Exactly, my lord. He's not been the department is not even concerned because he's a poor man, my lord. This is scheduled tribes. টাকা কি আমি বাড়িটা নিয়ে নেবো আমার জমির উপর বাড়ি আর কি নাকি বাড়িটা শুদ্ধ নেবো জজ সাহেবকে বলবো বাড়ি করে থাকবে
Care of the petitioners, liberty is granted to implead the divisional forest officer.
Divisional forest officer Shuri at Birbhum. That's what he said. I learned in a friend said.
As respondent number 5 in the writ petition. Paragraph, the cost title of the writ petition be amended according to paragraph 6. All the respondents are represented, further service of notice upon the added respondent is dispensed with. Paragraph, learned counsel for the respondents seeks to submit a further affidavit annexing relevant documents with regard to utilization of property belonging to the petitioners.
By tomorrow I'll do. You can, if that's not there. अरे আমার উত্তম নেই তো তো অ্যাডভোকেট অন রেকর্ড
Since further notice is not required, you can do it.
আমি ঝুলাচ্ছি
20th February.
28th.
File your report in
February would be very longish, my lord.
He has to come back with the.
He said 2 weeks, my lord.
Very well.
28th.
Let it be 13th February.
Grateful, man.
My lord, matter fixed at 12 o'clock.
Yes. The specially fixed matter at 12.
My lord, before this matter starts, my lord, I, my junior advocate on record, appeared on behalf of the added respondent number 40. But I wanted to return the brief to him and give several calls to take back the petition, and but he had not yet.
You are withdrawing from the matter.
So I did, my lord, I thank for my lord recording my diary from him.
Yes.
I'm
That on record. Have you informed me
He added
because-
respondent.
Yes, have you informed me because it is special effects at 12? Have you intimated the advocate on record?
Yes, his prayer was allowed.
No,
Now-
prayer is allowed. But the council wants to withdraw.
Yes, now he's, why you are?
So where is the advocate on record?
The last occasion. Last occasion, there was a direction by your lordship in the last paragraph of the order of the 28th of November to come up with a supplementary affidavit on behalf of the petitioner, bringing on record the subsequent events that have come into. Because yes, we have ventilated that fact. There were some pages missing that were being pointed out by the Mr. On the last occasion, that some pages were missing. We have tried to get everything that is on record because there were some graphite mistake on our part.
I don't mind, madam.
In enclosing those documents, we have brought it on. Yes, we have been served. They have been served.
Yes, 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 I have received a
All have
copy.
been-
I don't think, but these are records which are being produced. My landfill is entitled to it. I don't object.
Especially what we wanted to bring on record is an order of coordinate bench of the original side manner, which is in CCN of the civil suit. That order is on record. That was the subsequent event we wanted to bring.
My lord,
Has the partition suit been disposed of finally?
kindly,
No, my lord.
I draw your lordship attention, order dated 28/11.
Page 192 of the supplementary affidavit. Of the supplementary that has been filed, madam, page 192. Annexure P9. That is the last standing order of the civil court.
কত পাতা?
192, sir. It is Annexure P9. Survey First Commissioner has been appointed, my lord, in respect of entire property, suit property. So the suit is very much in progress. Nothing has been allotted, nothing has been separated by meets and bounds.
I shall make my submissions on this. There is no problem.
This is what we wanted to bring on record.
Yes, yes. You have done the right thing in bringing it on. You have done the right thing.
So, my lord, এই কাগজটা কই আমার?
It's supposed to be demanded within March 2024.
No, Milord, may I clarify? The time given to the four joint commissioners was to do whatever is necessary by March. And at the initial stage itself, I had pointed out that it may not be possible within March. So his lordship has said, you all right, you take it for the time being till March. And if it's not completed, you come back, I will extend it. I will extend it.
The report would have helped us, I think. The final report.
Make my submissions on this.
Regarding, my lord, the regarding order, on respect of the order dated 2011, I have respectful submission before your lord, because facts and circumstances in order and the legislative positions of the judgment of the Supreme Court does not permit the private respondent number 3 to raise his question at the belated stage. Law does not engage. Supreme Court discourage these principles, my lord. Supreme Court has said, when the matter is already entered, then court is to record all the issues on the finding all the issues. And law order 14 rule does not permit. It is contrary to the law to hear the my lord. So kindly see the order, my lord.
The issue of maintainability will be dealt with along with the writ petition.
No, your lordship, no, your lordship on the first occasion, your lordship raised the question and put me question whether your lordship has territorial jurisdiction over the matter.
Yes.
On that day, what they did, private respondent did not appear. My lord, they received the summons. Your lordship kindly see the order. Conduct of the parties. Among these conduct of the parties, not only they are debarred, they are waived the right to raise this objection at this belated stage.
This is
Kindly record this, my lord. And you, your lordship, see the first date, order of the first date, they did not appear. They remain as just like a watchdog
That's
to
technical,
see the
but
consequences of the order.
still with the
Second thing, my lord, when the state of Assam did not raise the objection, when your lordship passed the order 9-2, after hearing me,
and other parties, the state government, did not come because any territorial question regarding pecuniary question must be raised in the first instance without wastage of time. In order to wastage of time of the Honorable Court, that should be raised in the first instance as per order 14 rule, my lord. Your lordship kindly see.
You have made your submission on merits also, isn't it?
No, no, my lord, wait. I am making submission because I will retain these, your lordship has jurisdiction. Still I submit your lordship has jurisdiction. There is no dispute in this matter. I will back to 226.
So let us do one thing. Instead of dealing with the matter only on the jurisdictional issue, maintainability issue, let the petitioner make a submission on merits once and for all.
Petitioner has made a submission on the merits.
I have submission, but they may be allowed to stay on the argument, not on the plenary point, my lord. They may, I have no objection. They may permit it to allow on the merits.
Matter will be heard on merits as well.
Merit, yes, my lord. They question the
Together.
because order, your lordship kindly see the order. They raised this question, preliminary question, to dismiss the application on the 2 grounds.
On merits, sir, to be
Yeah.
decided
So
together.
I have no objection regarding if they argued the case on merit, subject to right of reply.
Anything to add on merits?
Yes, I will say their merit.
You'll have a chance of reply.
Yes, my lord. I'm a merit only I am giving because I order, my lord. Just I will give them, my lord.
Have made your submission on
Yes,
merits.
yes. My still only, my lord. I will should recapitulate again, my lord. I challenge that. I challenge that 2 orders. I challenge 2 orders, my lord. Annexure P4, my lord. 2 orders I challenge, which was passed by the Assam government by infraction of the law, as well as, my lord, infringement of right to property in the pendulate property guaranteed by Article 300A, read with Section 52 of the Transfer Partition Act, my lord. My right was protected. Mine was protected by several orders of the Honorable High Court. Honorable High Court also passed injunction order, including myself. Nobody can
made this submission, I shall answer this.
Yes, yes.
Definitely
Terms of settlement. Terms of settlement, paragraph 45. Your lordship can see. Your lordship can see the paragraph 45 of the terms of you will get
intention.
No. I will allow you. Don't be.
Please allow me.
His lordship is allowing you to argue the case.
No,
So
you are not allowing me.
I am just to remind because order. Because just new thing has come into my notice, my lord. That is why.
What is the new
Thing? Because these private respondents are nothing but a beneficiaries of the order. They are nothing but a beneficiary of the which is affected by rights, and that is a contemptuous order. That is a contemptuous order, my lord. It comes under the Contempt of Court Act.
Contemptuous order?
It is a contemptuous order because 45 is there. So no transaction can be taken without leave of the court when the injunction was granted. If the injunction is violated, my lord, whether it is a fair order, is it not a contemptuous order under the provisions of the Contempt of Court Act? One question may raise there, my lord, that is the jurisdictions of the original High Court, not by this court. Only this question can be. But facts remains. Your lordship is now adjudicating ceasing of the case of regarding the suit properties which is pending in this court. And they violated all records of this case. All orders are lying in the High Court. If the all orders are lying in the High Court, my lord, and they violated, and this order has direct nexus with this, my lord, direct nexus with the order passed by the different order passed by the High Court, and all orders are lying in the High Court. So how they can say the cause of action not aroused within the territorial jurisdiction, and the property itself comprises several my lord, several places, including the High Court. It is a parcel. The property notification is a part and parcel of the suit property, and suit property embraces all properties, including the property of the Calcutta. So if the property is here, my lord, unless it is separated and demarcated under order 20 rule 13, they cannot. It is everybody has a right.
equal right, joint right. It is ancestral property. Because they got the property, their father, but the father is not property. It is his ancestral property. Father has no right to transfer. So on the basis of that, I cannot, my lord. So, my lord, the cause of action, I will say, my lord, cause of actions in applying Article 223 read with subclause 2 of the Constitution, my lord, Supreme Court, as per judgment of the Supreme Court, my lord, this court has got jurisdiction to entertain this petition. So let him allow to on merit.
I'm thankful to my learned friend. আপনি বসুন, আমি বলেন তারপরে আপনি বলুন।
হ্যাঁ হ্যাঁ নিশ্চয়ই।
Well, my points are very short. Your lordship has been pleased to summarize those points, my lord, in your lordship's last order. 2 points I'm going to raise: suppression of material facts, which will come afterwards. First is the court has no jurisdiction. Now, my lord, the issue of jurisdiction, my learned friend says, contains that it has to be raised at the first instance and not after that. Supreme Court doesn't say that. In fact, I've got a Supreme Court decision which says that at the final hearing, the court is to decide, even though court has entertained the matter, the court has to decide ultimately as to whether it has jurisdiction or not. I shall come to that. Well, let's first kindly take the list, the writ petition, on which this entire argument has been made by my learned friend. I take your lordship straight to the prayer. What is my learned friend asking for? Kindly come to page 18 of the writ petition. A writ in the nature of mandamus or certiorari, directing the official respondents and the respondents to show as to why the impugned notification dated 10/10/2022 issued by the Director, Cultural Affairs, Government of Assam, being Annexure P5, should not be set aside. Now, my lord, this impugned notification is at page 80. Kindly take that. Kindly look into that page. This is not a, first of all, it's not a notification. It is merely an intimation by one department of the government of Assam to the other department of the government of Assam. Page 80, the address to the Deputy Commissioner Dhubri, Bodobajar, Dhubri, Assam. Who has addressed it? Director of Cultural Affairs, Assam, Guwahati. Regarding development of the house of late Pratima Borua Pandey, Matiabag Palace at Gauripur, Dhubri, compensation for acquiring the building. With reference to the subject cited above, I would like to inform you that as per Government of Assam Cabinet decision held on 7/1/2022, an amount of rupees 15 crores has been released in favor of the Deputy Commissioner Dhubri for acquisition of land at Motiabag in connection with developing the house of late Pratima Borua Pandey in Dhubri. Therefore, you are hereby required to submit 2 numbers of same estimates / APRs, that is after payment receipt, along with the bank details on behalf of the Deputy Commissioner Dhubri to this end through mail, etc. before 2 p.m. This is for the waiver. That's the only letter which has been challenged. Now, kindly note 2 or 3 things. This particular notice is not a notification, as my learned friend's client has said in prayer A. Prayer B, kindly see at page 19. A writ in the nature of mandamus order directions upon the official respondent from giving effect to the order dated so and so, from taking any further action in respect of payment of disbursement of rupees 15 crores specified in the order dated so and so. Order dated 10/10/2022, which is at page 80. The same thing is there. Now, kindly note 1 or 2 things. Kindly take the cause title. Cause title, your lordship will be pleased to find. Who are the petitioners? Moshumi Borua Roy, now wife of late Robi Roy. I do not know what is the meaning of now wife of. Anyway, then PO, PS, Gauripur, District Dhubri, Assam, at present residing at 1/6 Azadgarh, Kolkata, 7 lakhs 40. Mrs. Orpita Borua Dash, reside now wife of so-and-so, Gauripur Rajbari, so-and-so, Guwahati, Assam. Respondents, Chief Secretary, Dispur, Guwahati, Assam. 2. Secretary, Dispur, Guwahati, Assam. 3. Director of Cultural Affairs, Dispur, Guwahati, Assam. 4. Commissioner of Dhubri, District, Assam. 5. Additional Deputy Commissioner, come so-and-so, Dhubri, Assam. 6. The Joint Secretary to the Government of Assam, Cultural Affairs, Dispur, at Guwahati, Assam. 7. The PS to the Honorable Minister, Cultural Affairs, Dispur, Assam. Then the private respondents. Anubha Badua, Gauripur, Dhubri, Assam. Prokrit Badua, Gauripur, Dhubri, Assam. All of them are in Assam outside jurisdiction, number 1.
Except the added respondent.
Except the, when my lord, they filed this suit, writ petition, at that time, my lord, everybody was outside. And it is the case. Very well. Now, my lord, kindly see, the next thing is, where is the property situated? Which is the property? Which is the subject matter of, my learned friend talked about, my lord, Calcutta properties. What is the subject matter of this writ petition? It is a property by the name of Motiabag Palace, the house of late Pratima Bodua Pandey at Dhubri. This is, my lord, at page 80. So the property is also situated outside jurisdiction. Now this is the order at page 80 which has been challenged. That is also in Guwahati. The government of Assam's order, my learned friend is challenging in Calcutta High Court. And my lord, what is the reason why he is challenging in Calcutta? He says there is a partition suit pending here. Now the partition suit which is pending here, my lord, that in respect of that, what has happened? My learned friend's client has completely suppressed those facts. I shall come to it. That is, my lord, my second point. Suppression of material facts. The court has been led up the garden path. My lord, submissions have been made, writ petitions have been initiated on the basis, my lord, that his suit is pending in the Calcutta High Court. But my respectful submission is so far the Motiabag Palace is concerned, from the documents which, my lord, now my learned friends have, my lord, annexed in the supplementary affidavit, which was not there originally. Well, I am, my lord, I shall be relying upon the documents which the government of Assam has, my lord, annexed. I am surprised why government of Assam has not placed these things before your lordship. This government of Assam, my lord, this particular notification which has been issued, that on 10/10/2022, my lord, it is after a lot of deliberation, lot of discussion with the parties, and thereafter, my lord, the order has been passed. All these have been very scrupulously suppressed from the entire petition. But before I go into that suppression of fact, well, my respectful submission is that the subject matter of the controversy is Motiabag Palace, which is also known as Hawa Mahal, situated at Gauripur in the town of Dhubri in Assam. That is the first point I am making. And my lord, I have said that in the writ petition, the writ petitioner has challenged only stated to be a notification, but is only a letter, which is at page 80. That is the only thing that has been challenged in the writ petition, nothing else. And my lord, this is, what is this document? 15 crores was to be released. This is an intimation. Therefore, you are hereby requested to submit 2 numbers of estimate APRs. And this is being addressed by the Director of Cultural Affairs to the Deputy Commissioner Dhubri. That the entire letter is, you are requested to submit 2 numbers of after payment receipt along with bank details. And that has been challenged, my lord. I respectfully submit to your lordship. First of all, this is something which is not really the crux of the matter. Secondly, my lord, it is a document which has emanated in Assam by an Assam government official to another Assam government official. Nothing to do with the respondent. Nothing to do with the respondent, private respondent, nothing to do with the petitioners. Now, Your Lordship will please to see, so far as Article 226 is concerned, the court is empowered to exercise jurisdiction in respect of a government within its territory. Original, my lord, kindly see. I will make my submission on this. Original 226(1) before amendment. My lord, your lordship has, may I hand up to your lordship? Constitution.
Yes.
Well, kindly see that in so far as the this original provision is concerned, previously, notwithstanding anything contained in Article 32, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government, within those territories, directions, orders. Originally, therefore, the Article 226 as it stood was that the High Court of the territory within which the government is situated will have the authority to pass the necessary order. Now, my lord, by way of subarticle 2, my lord, an amendment was brought in. My lord, this amendment says that the power conferred under clause 1 to issue directions, orders, or writs to any government authority or person may also be exercised. This is an addition to be exercised by any high court exercising jurisdiction in relation to territories within which the cause of action, wholly or in part, arises in exercise of such power. So your lordship will have to consider, when, my lord, your lordship sees that the respondents are all outside, the petitioners are all outside, still your lordship can, my lord, exercise jurisdiction if a part of the cause of action arises. Now, what is the cause of action here? Cause of action is, that is the only cause of action. Nothing to do with any of the properties in West Bengal. The cause of action is that, look, there is a particular property in Guwahati, in Dhubri. That particular property belonged to X. That particular property is sought to be acquired by the government, and the government is going to pay a certain sum of money to the person who is the owner of the property. So, forgetting about the merit of the controversy, I say it is wholly confined to a property situated outside. A decision taken by a government situated outside, affecting parties who are situated outside. Therefore, my lord, on what basis will your lordship, my lord, assume jurisdiction on this matter? That is my first point. My lord, most importantly, had it been, my lord, a suit, look at it from this point of view. Had this been a suit and not an Article 226 application, the property in respect of which you are making this allegation is wholly situated outside. Motiabad Palace, Hawa Mahal in Dhubri. Therefore, the subject matter of the entire controversy is outside the jurisdiction of this court. Wholly everything is outside. In a situation like this, can my learned friend's client bring a proceeding before your lordship on the allegation that, my lord, the partition suit is pending in this court? I respectfully submit to your lordship, perhaps not. Two things are to be seen. In the partition suit, there are properties X, Y, and Z. The writ petition is confined only to X property. X property is wholly situated with outside jurisdiction. Y and Z may be within, may be outside. But we are not concerned with it. Court has to see what is the cause of action in the writ petition. And cause of action in the writ petition is only challenging a particular document which emanated from a government of Assam to a government of Assam in respect of a property situated outside jurisdiction. My lord, on what basis my learned friend's client can, my lord, invoke the jurisdiction of this court? My lord, like, my lord, a drowning man catching at a straw, they have caught at this, that a partition suit is pending in this. I shall show to your lordship what is pending in this court. Now, my lord, on this aspect of the matter, I respectfully submit to kindly see how they have pleaded this. how they have invoked the jurisdiction. This is also very important. And on this basis, my lord, your lordship has been pleased to pass an interim order. Kindly see, my lord, para 26. That is the only paragraph. I asked this question to myself. Will this particular paragraph, if every word of this paragraph had been correct, would it confer jurisdiction before to a lordship? Page 18, paragraph 26. That is the only paragraph in pursuance of which, my lord, jurisdiction is being invoked. That the petitioner state that some of the records are lying in the High Court at Calcutta in connection with partition suit number so and so. So the first contention is some of the records are lying in the High Court at Calcutta. Second, and some of the respondents are residing at Calcutta. Who is the person residing at Calcutta? When this proceedings were instituted, not one of the respondents was in Calcutta. Or each one of them was in Assam, residing at Calcutta. This is a false statement. West Bengal. And some records are lying at the official respondents at Assam. This Honorable Court Calcutta has jurisdiction. Is this the pleading of Article 226(2)? I submit to your lordship, there is not even a pleading in pursuance of which, my lord, they will invoke your lordship jurisdiction. Therefore, my lord, I respectfully submit to your lordship, there is nothing on the record on this writ petition which will, my lord, entitle your lordship to entertain this particular. Now, my lord, on this aspect of the matter, my learned friend has said that when the first application was moved, the writ petition was filed, you did not take the point of jurisdiction. I was not there before the court. When the court passed the order, when if this honorable court was pleased to pass this order, my lord, I was not before the court at all. And the very first instance, I have taken the point of jurisdiction. The first order. Kindly give me 1 minute, my lord. I think. Well, the order is dated 9th February 2023. My lord, kindly take this order if your lordship has got the order sheet.
I have the order.
Your lordship has got it. Can, if I may read it. Mr. Purkasto, Mr. Bhattacharjee, Mr. Malik, Mr. Chaudhary for the petitioners, Laskar and Mr. Bikash Kaur Gupta for the respondent number 1 to 7. There is no, my lord, respondent numbers 8 to 13. Affidavit of service filed by the petitioner is taken on record. It is submitted on behalf of the petitioners that though the land in question falls within their share of the property, kindly note this, on behalf of the petitioner, that though the land in question falls within their share of the property, in terms of preliminary decree passed by this court, this is a misleading statement, and I shall demonstrate on the basis of the documents they have disclosed that this is a misleading statement, absolutely a false statement. And by this court, and
mention matters are scheduled from 12:30 actually.
well,
How long will you take?
I will take some time, my lord. May I continue till 1 o'clock so that I can finish my lord jurisdiction point today before lordship.
Mr. Mitra, please continue till 12:45.
12:45, very well.
12:45. Mention matters 12:45.
Very well. My lord, kindly see this order. It is submitted on behalf of the petitioner that though the land in question falls within the share of the property in terms of preliminary decree passed by this court, and the partition suit is still pending, the official respondent formed a committee on 4th July 2022 for purchase and transfer of the property in question being Motiabag Palace in Gauripur, Dhubri, Assam. The Director of Cultural Affairs, by a letter dated 10th October 2022, which is at page 80, has communicated to the Deputy Commissioner Dhubri that in terms of the decision taken by the Government of Assam Cabinet on 7th October 2022, an amount of rupees 15 crores was going to be released in favor of the Deputy Commissioner Dhubri for acquisition of the land in Motiabaga in connection with the developing of the house of late Pratima Borua. Learned counsel for the respondent submit that during the pendency of the writ petition, the amount has been paid to the owners of the land and possession of the property has been taken by the authority. Learned counsel seeks to submit a report in the form of affidavit in this regard. Let the matter appear so and so. Let there be an order let there be an order of status quo in respect of the nature, character, and possession of the property in question upon both the parties as on this day until further orders. Now, my lord, I submit to your lordship. I shall just now place a few of the decision. And my lord, I conclude my submission on the jurisdiction aspect. My lord, that this order, which was passed by a lordship, my lord, on the basis of misleading facts, my lord, this, my lord, particularly when the property is situated outside, the order which is sought to be challenged is passed by a government outside, the respondents are outside, entire cause of action is outside, nothing has been shown in the writ petition which is within the jurisdiction, then, my lord, the court should not have exercised any jurisdiction to entertain this matter. My lord, on this aspect of the matter, may I just place one or two decisions? My lord, first decision I cite before your lordship is 1985, 3 Supreme Court cases 217. Copy, 217. I'm so much copy. Lordship has got it. My lord, kindly take, my lord. This is an appeal from an order which was passed by this honorable court. The issue involved in this appeal by special leave, first paragraph, Justice A.P. Sen's order, whether the service of notice under subsection 2 of section 52 of the Rajasthan Urban Improvement Act 1959 served on the respondents at their registered office at 18B Brabourne Road. At least there is an indication that something happened in 18 Brabourne Road, Calcutta, by a special officer, Town Planning Department, was an integral part of the cause of action and was sufficient to invest the Calcutta High Court with jurisdiction to entertain a petition under Article 226 of the Constitution challenging the validity of a notification dated 4th February 1984 issued by the state government of Rajasthan under section 52(1) of the Act for acquisition of certain land. Almost similar facts. Acquisition of certain land belonging to them required by Urban Improvement Trust Jaipur for a public purpose, namely for implementation of a development scheme. Well, so in this particular case, the notice was issued by the government of Rajasthan in respect of a property which is situated in Rajasthan. My lord, but the notice was served upon the writ petitioner in Calcutta. So, my lord, the jurisdiction was invoked and this writ petition was entertained. My lord, after discussing, my lord, the facts of the case, see, my lord, what the court said. Paragraph 8 at page 223. The expression cause of action is tersely defined in Mullah's Code of Civil Procedure. Then, my lord, the quotation, the cause of action means every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. That is, in other words, it is a bundle of facts which, taken with a law applicable to them, gives the plaintiff the right to relief against the defendant. The mere service of notice under section 52(2) of the Act on the respondents at their registered office at 18B Brabourne Road, Calcutta, that is within the territorial limits of the state of West Bengal, could not give rise to a cause of action within the territory unless the service of such notice was an integral part of the cause of action. The entire cause of action culminating in the acquisition of the land under section 52(1) of the Act arose within the state of Rajasthan, that is within the territorial jurisdiction of the Rajasthan High Court at Jaipur bench. The answer to the question whether service of notice is an integral part of the cause of action within the meaning of Article 226(2) of the Constitution must depend upon the nature of the impugned order giving rise to a cause of action. Impugned order giving rise to a cause of action. Therefore, my lord, the basis of the foundation of the cause of action is the impugned notice which is sought to be challenged in the writ petition. The notification dated 8 February 1984, issued by the state government under section 52(1) of the Act, became effective the moment it was published in the official gazette, as thereupon the notified land became vested in the state government, free from all encumbrances. It was not necessary for the respondent to plead the service of notice on them by the special officer, Town Planning Department, Jaipur, under section 52(2) for the grant of an appropriate writ, direction, or order under Article 226 of the Constitution for quashing the notification. If the respondent felt aggrieved by the acquisition of their land situated at Jaipur, my lord, kindly apply this, my lord, in the facts of this case. If the respondents felt aggrieved by the acquisition of their land situated at Jaipur and wanted to challenge the validity of the notification issued by the state government of Rajasthan under section 52(1) of the Act by a petition under Article 220 of the Constitution, the remedy of the respondent for the grant of such relief had to be sought by filing such a petition before the Rajasthan High Court Jaipur bench, where the cause of action wholly or in part arose. It is, my lord, this is very important, paragraph 9. It is to be deeply regretted that despite a series of decisions of this court deprecating the practice prevalent in the High Court, passing such interlocutory orders for the mayor asking, the learned single judge should have passed the impugned ad interim ex parte prohibitory order, the effect of which, as the learned attorney general rightly complains, was virtually to bring to a standstill a development scheme of the Urban Improvement Trust Jaipur, that is Civil Lines Extension Scheme, irrespective of the fact whether or not the High Court had the territorial jurisdiction to entertain the petition under Article 220 of the Constitution. This particular Matiabag Palace is sought to be, my lord, acquired for the purpose of development, for the public purpose. And that is being stopped. So here also the same thing has been said, that it should not have been done. Such arbitrary exercise of power by the High Court at the public expense reacts against the development and prosperity of the country and is clearly detrimental to the national interest. Quite recently, Mrs. Chinappa Reddy, speaking for the court in Assistant Collector of Central Excise, West Bengal versus Dunlop India Limited, administered a strong admonition deprecating the practice of the High Court of granting ad interim ex parte order, which practically have the effect of grant of the main relief in the petition under Article 226 of the Constitution, irrespective of the fact whether the High Court has any territorial jurisdiction to entertain such a petition, or whether the petition under Article 226 was intended and meant to circumvent the alternative remedy provided by law, or filed solely for the purpose of obtaining interim order and thereafter delaying and protracting the proceeding by one device or the other, particularly in matters relating to public revenue or implementation of various measures and schemes to undertaken by the government or by the local authorities for general public benefit. Although the power of the High Court under Article 220 of the Constitution are far and wide, and the judges must ever be vigilant to protect the citizen against arbitrary executive action, nonetheless, the judges have a constructive role, and therefore there is always the need to use such extensive power with due circumspection. There has to be, in the larger public interest, an element of self-ordained restraint. We hope and trust that the High Court will determine the extent of its territorial jurisdiction before making such interlocutory orders. My lord, this is loud and clear. Here, my lord, in this particular case, in 1985, 3 Supreme Court cases, at least the notice was served on somebody who is within jurisdiction. And my lord, the petitioner was within jurisdiction. In our case, my lord, everybody is outside. The property is outside. Notification is outside. And my lord, the pleading of cause of action is paragraph 26. Nothing has been pleaded. So, my lord, it is quarter to 1.
Please continue on the.
My lord, when, my lord, if your lordship kindly gives the time.
Because learned counsels come from Delhi.
Yeah.
Come back, sir. Yes. 6th of February. Very good. If possible, sir, you can come for a couple of days or so that we can
Sixth and seventh, my lord, kindly fix its concern. I shall finish my argument.
You have not finished.
No, not at all. অনেক সময় লাগে। Would your lordship fix a time on 6th and
11:30.
11:30?
Since 12:30, I can mention matters.
Very
You
well.
Hear it out for one.
On both days, madam?
On both days.
Sixth
Sixth and seventh from 11:30.
Very well.
Our learned counsel for respondent numbers 8 to 13.
Yes. 8 to 13. 8.
30. Paragraph, let the matter appear under the same heading for further consideration on 6th February 2023 and 7th February 2023, marked at 11:30 a.m.
On both days, my lord.
Yes, I have mentioned.
Well,
both
because
the
there will be there will be noise and screaming and shouting from that side that you mentioned only on 6th and not on 7th. My lord, I want to avoid that. Lord, I think my learned friends.
Rajiv Lal is sailing in the same boat of
Yes, obviously.
Not to separate.
I have to sail in the same boat. I can't be in his boat. My lord, added respondent number 13.
14 is retired.
14, my lord.
Yes, my lord, my advocate.
Your lordship will kindly record that.
Supplementary affidavit submitted on behalf of the petitioners is taken on record. Yes, mention that.
Your lordship will kindly record the withdrawal of the added respondent.
Residing at Calcutta or Arham.
He's appointed as senior.
I'm sorry, my lord.
Residing at Calcutta.
Senior, I believe.
No, my lord. There was an official order that he was to be added as a respondent number 14.
He's not the advocate on record.
No, my lord, he's here. The advocate
He's still there.
My lord,
Appointed as senior.
Oh, I see.
My lord,
Counsel was withdrawn.
my lord, he is a party to, he is residing in Calcutta.
Withdrawn
He is residing at Calcutta.
No, they are both withdrawing, my lord. In other words, my lord, that addition fails, then there is nothing remaining in that application.
Yes, kindly record.
Respondent then.
Nobody.
No, nobody.
The person, my lord, unfortunately, unfortunately, the person concerned who is here, the added respondent, is the plaintiff in the suit. Even in the suit, they're not appearing. So, your lordship, the game is very clear. We are.
My learned counsel for the supplementary reporting. Learned counsels for the added respondent seeks to withdraw from the writ petition. Stop. The added respondent is not represented.
Such has your lordship allowed that? Has your lordship allowed that prayer?
Allowed the?
Allowed that withdrawal?
Yes.
Kindly, let's have
The court cannot reject withdrawals.
No, absolutely not.
Accordingly, seek to withdraw. That's
And your lordship will kindly add, subject, of course, to your lordship. The same prayer is allowed. Otherwise, I'm being very apprehensive about certain things, and I'm being very upfront on it. Right.
Why there is no other alternative?
I'm sorry, Miller.
When there is no other alternative of the court, it cannot necessarily be recorded.
No, I understand, but
It is at their own.
very well. If this situation arises in future, I will take care of it, subject to this order.
Rajiv, until I go then, friends.
6th and 7th, 11:30. I'm much obliged. Great.
This is not a prayer. For
Very well. Mother time for the petition in this matter.
I am appearing on behalf of the
Affidavit of service be kept with the record, lordship. Do together. Now, I have challenged the notice followed by one proceeding which took place before the National Highway Authority. Kindly come to page 63.
Serve the private respondent.
Yes, private respondents, lordship, the private respondent.
My lord, I am appearing on behalf of the Union of India, my lord. Just yesterday I have received this brief, my lord. My
Now,
lord,
lordship, the only thing is that
National Highways, I am appearing on behalf.
All of them, yes.
now, lordship, this notice,
There are several private respondents I find.
lordship, these private respondents are, lordship, the 7 and 8 9 and 10, they are the promoters,
No,
developers.
instruction is required. My lord, kindly
They
take
are
it about 1 day, my lord.
developers. So far the interim relief is concerned, I have nothing against them. Lordship, the only I am seeking a protection for the, kindly see the notice, page 63.
I do not know whether you've served all of them. Service is not complete, sir. How do you
Private,
mention-
any National Highway Authority is served.
Private respondents not served.
Private respondents are, Lordship, they are the developers. They are not,
How well come back when you have.
they have changed their address, we have seen their, those have come back.
You have to either expunge their names or.
I will expunge their name from this.
All of them?
All of them.
7 to 10?
7 to 10. All of them.
My lord, I have instructions is required, my lord. Just yesterday I received this brief, my lord.
Now, Lordship, let him take the instruction. By the time, Lordship, let
My lord,
him not
if,
proceed
if
with
your
this.
lordship passed any interim order, my lord.
Apprehension is that kindly come to the notice once, Lordship, kindly. Page 63. That such and therefore you, such and such, take notice that you are hereby required to remove such unauthorized occupation
Have you
within
filed
7 days. I filed a representation. Thereafter, the hearing took place. We went there. We have not received the outcome of that, but it was orally told that we can't do anything.
Already
You
7
have
days
to-
already over, my lord. In the meantime, they did not take any step. 7 days. Yeah, from the
They have given the reply. Kindly come.
well, already.
Petitioner has given a reply also.
Yes,
Can
my
you see
lord.
the next page, my lord?
Discuss on the, because I have own documents, the building plan, occupancy certificate, etc., which states that my occupancy is.
January 2024.
This is the representation, isn't it?
This is the reply.
Four.
Against, representation against member.
Yes,
That is at page 63.
he was directed to file a representation. This is the representation. Has this been considered?
Well, there are proceedings going on, my lord, and without instruction, how can I submit before your lordship?
Please give instructions that no further steps should be taken.
Yes, my lord.
For the representation.
All right, I shall inform to the authority, my lord. He will come or whatever.
Please inform the authority that no coercive steps be taken till the next date. Yes, since you're not ready with instructions today.
Yes, my lord.
Can I take it from the bar? I'll not record anything.
Without instruction, how can I?
Then there should be an interim order.
Also, let it be there. But I shall inform my lord that they will not take any coercive action, my lord. But do not record it.
My lord is asking.
Yeah.
That is what
Yes,
exactly
yes,
I'm saying.
yes.
I'm not recording anything.
All right, all
Please
right. Yes, yes.
instruct them not to take any
Yes, yes,
coercive
yes,
steps.
yes,
in
yes,
the
yes.
The on prayer of the petitioner, liberty is granted to expunge the names of respondent numbers 7 to 10 from the cause title of the writ petition. Paragraph the affidavit of service. Paragraph learned counsel for the notice issued by the National Highways Authority of India on 29th December 2023 under section 26 within bracket 2 of the Control of National Highways within bracket Land and Traffic bracket closed Act, 2002 is assailed in the paragraph. The National Highways Authority of India seeks to take instructions in this matter. Paragraph, let the matter appear under the heading root one motion on.
Lordship, in line should be recorded that his submission. Otherwise, Lordship,
I don't
if anything happens, Lordship, then
nothing will happen.
and Lordship, in a similar matter, Lordship, your Lordship is pleased to 30th January.
I'm grateful, my lord. Yes.
Please come back with
Yes, yes, my lord. Double.
Next.
Grateful, my lord.
নাম্বারটা লিখে দিয়েছো তো? I'm grateful.
For 522.
Next matter.
Millard, in this matter, Millard, I question, Millard, the propriety of a notice issued by the Millard National Highway Authority while making the acquisition. Millard, the bad points against me, Millard, when I moved this petition, that I have taken the compensation. Now, Millard, I made an objection. I said, Millard, that the law provides in terms of section 3, Millard, A and 5, 1, 4 and 5, Millard, that certain periods, Millard, must be mentioned, Millard, it is a 60 days. So far as the notice to vacate is concerned, Millard, this has been, Millard, grossly violated. They have given me 3 days notice. Second, Millard, after the promulgation of the Millard Resettlement Act 2013, Millard,
there was a guideline, my lord, framed by the competent authority, which says, my lord, that the principles followed, my lord, in the, my lord, the Settlement Act 2013, my lord, with regard to payment of compensation and solatium, that must be followed religiously. Now, my lord, this has not been followed. But the amount, my lord, that was paid, my lord, through the to my bank account, my lord, that has been made. My lord, I said I have 2 points, my lord, to argue before your lordship. First of all, my lord, whether at this stage, after taking compensation, my lord, whether I am entitled, my lord, at all, my lord, to, my lord, pray for an interim order. Number one. Number two, my lord, the second point is, my lord, that if the court is desirous of admitting my writ petition, then what is the eventuality and what is, my lord, the balance of convenience, my lord, which propels my prayer, my lord, to pray for an interim order. My lord, my respectful submission before your lordship, the word envisaged, my lord, the word deployed consciously, my lord, by reason of the, my lord, legislative wisdom is, my lord, the determination of the amount. My lord, determination means, my lord, lawful determination. Determination means, my lord, determination in accordance with law. If, my lord, there is a gross violation, my lord, whether irrespective of the fact I have taken money or not, my lord, when I recorded my objection, whether the authority under the statute is duty bound, my lord, to redetermine indeed, my lord, by taking recourse, my lord, to the Resettlement Act 2013. And before the determination is made, my lord, whether I am liable to be evicted, despite the fact, my lord, the notice at the face, my lord, it clearly states, my lord, only 3 days time were given on 29/12/2023. So, my lord, on the first code, my lord, the notice must go. Second, my lord, even if it's allowed to stand, my lord, then, my lord, the other part of the determination, my lord, has to be followed. Now, my lord, your lordship's court, my lord, with regard Justice Vivek Chaudhary order কোথায়? Now, my lord, in this, in the similar ground, my lord, your lordships, my lord, 29 page 102.
My lord, the notice has been issued by the Land Acquisition Competent Authority, not the National Highways Authority. What my learned friend lordship relying upon?
The competent authority.
Miles.
Mr. Day is appearing.
For Union of
My lord, but my
Mr. Day, my lord, in his usual fairness, when, my lord, there was a resolution, my lord, he, my lord, had said, my lord, that the notice, my lord, apparently, it seems, my lord, that it is not in consonance with the line of, my lord, the dictum of 3G34. My lord, the notice, I take my lord's kind attention to, my lord, the National Highways Act. My lord, only, my lord, in order to show, my lord, why I am aggrieved. 3-4, my lord, I read for my lord, my lord. Section 3, C. They are to consider my objection. They are to consider my objection. Every objection, my lord, 3C2, every objection under subsection 1 shall be made to the competent authority in writing and shall set out the grounds thereof, and the competent authority shall give the object an opportunity either in person by legal, and may, after hearing all such objection, after making such further inquiry, if any, as the competent authority thinks necessary, by order either follow or disallow the objection. Any order made. Now, my lord, in this case, my lord, they have said that they have determined the amount. Now, my lord, 3E, my lord, if your lordship kindly comes, my lord, to 3E, power to take possession. May I read for my lord, wherein a land was vested in the central government under subsection 2 of section 3D, the amount determined by the competent authority under section 3G with respect to such land has been deposited under subsection 1 of section 3H with the competent authority by the central government. The competent authority may, by notice in writing, direct the owner as well as any other person who may be in possession of such land to surrender or deliver possession thereof to the competent authority or any person duly authorized by it in this behalf within 16 days, which Mr. Day, my learned esteemed senior friend's client, has done of the 60 days of the service of the notice. Now, my lord, first of all, the time, my lord, 102, admittedly, my lord, 3 days, 29/12/2023, which, my lord, causes a grievance. Second, my lord, if there is determination, if I show your lordship, my lord, the guideline. First of all, my learned esteemed junior friend, my lord, if she says that there is no such guideline, my lord, if she can prove in the court of law, then I have no case to make out. I'm out of the court. But I have a document to show, my lord, these guidelines have been framed. National Highway Authority is duty bound, my lord, to go proceed. Now, my lord, your lordship knows, my lord, when it is a question of computation of damage, my lord, the governance demands, my lord, which is a part of, integral part of constitutionalism, my lord, that citizens' right, my lord, has to be considered. Nobody denies under the sun, my lord, that the National Highway project, my lord, it carries a paramount public interest. Keeping in view, my lord, this importance, my lord, the legislature in its wisdom thought fit and proper that these are the procedural safeguards given to the citizen and the authority must adhere to it, my lord, rigorously. Now, my lord, there is no scope, there is no option for the authority, my lord, to, my lord, bypass the mandate of the statute. So 3 days goes and, my lord, the determination, my lord, is absolutely, my lord, a determination which is unknown to law. Now, my lord, 38, I take my lord's kind.
Taken recourse to 3G5.
My lord, if amount determined by the competent authority under subsection 1, subsection 2 is not acceptable to either of the amount shall on an application either of the parties be determined by the arbitrator to be appointed by the central government. My lord, the question is, my lord, if 3E
The arbitrator.
yes, my lord, but I can also, my lord, but if and provisions of Arbitration Act, I am entitled to make an application under section 9 also, my lord, if the principle is there.
G5 is that.
G5, my lord, apply. But prima facie, my lord, that this notice, my lord, which, my lord, violates,
Notice is in violation of 3E. That is.
my lord, that must go. And there,
There, my lord, my submission, lordship, can be recorded, this lordship. It is, lordship, 60 days from the date of the amount deposited by the
Please come to 3E.
My lord, kindly see 3H1, my lord. As per subsection 1 of section 3H, with the competent authority by the central government, the competent authority may by notice in writing, my lord. That is the 60 days from the date the amount has been deposited.
You're at section
3E, my lord, has been deposited under subsection 1 of section 3H.
Yes.
my lord,
3H1, my lord, the amount determined.
Please continue.
My lord, in 3E, my lord.
Competent authority may by notice in writing direct the owner.
on the-
Last 4 lines.
yes.
My lord, the 3E, my lord.
Yes, my last 4 lines.
May by notice in writing direct the owners as well as any other person who may be in possession of such land to surrender or deliver possession thereof to the competent authority or any person duly authorized by in this behalf within 60 days of the service of the notice, my lord. The notice, yes, my lord, as per section 3(1), subsection 1 of 3H.
3E notice.
Yes, my lord, 3E, lordship, that is mentioned subsection 1 of 3H. That is the amount, lordship. My lord, remember, lordship, a few days ago, lordship, on the same issue that has been raised by the another lordship, the learned advocate, and my submission on the same.
What does 3H1 say?
The amount determined under subsection the 3G shall be deposited by the central government in such a manner as may be laid down by the rules made in this behalf by that government with the competent authority before.
Taking possession.
Yes, my lord. Yes.
Before taking possession, the amount is deposited, then a notice is issued upon the person interested to vacate within 60 days. of
My lord,
receipt
that
of
60
notice.
days, lordship, that 60 days comes from the date of the deposition, lord.
Where
It is
is
not
that
from-
stated that it comes from the date of depositing them?
My lord, that is clearly written as per
That is not
subsection
clear
1.
at
And
all.
my lord, my humble submissions, lordship, in this entire writ petition has been given regarding the agreed lordship regarding the enhancement of the compensation. This entire writ petition, lordship, the one valuation report has been considered by the independent valuer. Lordship, they said this, their valuer agreed the amount has been, total amount is more than that has been valued.
That can be dealt with under 3G5.
Yes, my lord. And his case is totally on this, my lord. He's never said
But the
regarding this.
notice is on its face illegal.
My lord, that lordship, that is notice has been issued by the learned,
Yes.
and lordship, the payment notice, my lord, this payment notice. Lordship, they're asking for the set aside the payment, that cannot be done, my lord.
They are asking for setting aside the notice for delivery of possession, not the payment notice.
Yes, my lord, they said the set aside the payment notice, my lord. How can the lordship, after, lordship, only see the prayer? The 13 October 2023, they're asking for the settlement of the payment notice.
Payment, the first
How
prayer
well-
becomes redundant, I think. Because you
Milord, let her complete. I will take 3
And
minutes.
lordship, there is a provision, lordship, no, lordship, the 3G5 is there for the enhancement of the compensation. And the post 3 year notification, because their amount of calculation, lordship, they are asking for the 3 year notification, lordship, that is the payment notice, that is on 13th October. And the 3 year notice, lordship, has been issued on October, lordship, that is January, lordship, on 2022. That is post 3 year notification. As per 3G7 subclause A, lordship, the amount should be calculated on the date of determination of the publication of the notice. That is 3G7A, lordship. So they cannot. That is one part.
of the
Yes,
petition. The
and
other
lordship,
part is
these
this
60
notice.
days, lordship, these 60 days, lordship, that should be calculated from the date of the amount deposited by the
That is
central
that
government.
stated in so many words. Please show.
My lord, that has been mentioned, lordship, in the competent authority under say, subsection 3G with respect to such land, lordship. That is 3G is mentioned, lordship. That has been mentioned, Lordship.
It's for depositing the amount, not for delivery of possession.
No, my lord, that has been mentioned where any land vested in the central government under subsection 2 of the section 3D.
Where are you reading?
My lord, 3E power to take possession.
Yes.
Where any land has vested in the central government under subsection 2 of, my lord, after vesting, my lord, that is a law, my lord. He cannot ask for any.
After 3H1, 3E is applicable.
Service of notice.
3E comes into operation. So after all that, a notice from 60 days of notice, it has to be vacated. The language
My lord,
is
this
very
thing-
clear.
my lord, kindly appreciate, my lord, this enhancement of proceedings of any enhancement, lordship, cannot, lordship, stall the possessions, lordship, cannot stall the possession. My lord, there are several judgments is there.
In terms of 3E?
Yes, my lord, kindly, lordship, kindly allow me to.
I think Mr. Day has to reply on the other part.
My lord, may I, before Mr. Day responds, my lord, I bow down to my lord. My lord, I tender my apology, unqualified apology for not being armed with, my lord, the 2 copies of the unreported judgment. My lord, if I am to respond, my lord, that Mrs.
With judgment করো না।
No,
Your lordship, he comes, my lord, only for the notice.
I am saying, my lord, there are 2 parts only, my lord. Since I,
One enhancement, one
yes, my lord, Mr. Day's client has given the notice. Mr. Monica Shaha's Roy's objection, my lord, that 3H, my lord, is clear that after determination, it has to be, my lord, with the date of 60 days from the date of service of the notice. So, my lord, you got it. Now, my lord, 73, my lord, in your lordship's brief, why Mrs. Roy, my lord, is so apprehensive? 73, my lord. This notice, my lord, depicts, my lord, the amount of compensation. If your lordship kindly takes pain, my lord, to turn page 73.
This you received admitted.
I received. So at the outset, my lord, even if when she was absent from the court for certain reason, I told your lordship that in absence of, my lord, I received the money. No doubt of it. My lord, this 73, my lord, it takes into account a Suna land without taking a structure. 71 page, I clearly stated categorically, page 71, paragraph 14, that your petitioner and their family only depends upon the income of the hotel and restaurant mentioned herein above, Messrs. Gitanjali Hotel. The authority, my lord, has clearly ignored, and that is why the determination is wrong. Determination is wrong. It only takes about the land, not a structure. I pointed out, my lord, right. Now, my lord, if your lordship says, now, my lord, only one indulgence. Your lordship's court had said, the learned, my lord, Justice Chaudhary, as his lordship then was, my lord, the learned advocate for the petitioner also submits that under the provision of section 38 of the right to fair compensation and transparency in land acquisition rehabilitation 2013, no acquisition of land is before payment of compensation as well as rehabilitation, and resettlement entitlements are paid or tendered to entitled persons. It is also submitted that the petitioner is not only entitled to get compensation for the land which is intended to be possessed, but he is also entitled to compensation for the structure which has eventually been lost due to such acquisition. As per second schedule of the 2013 Act, the petitioner is entitled to get an alternative house, land or land if the land in question is under development, cost of development of the land, choice of entitlement and infrastructural amenities as provided in the third schedule of 2013 Act. The said entitlement of the petitioner is beyond the scope of the determination of the compensation by the arbitrator under section 3G5 of the National Highway Act.
These are all submissions.
These are all submission until such determination. So, my lord, I will take your lordship, my lord, to pay section 38. My lord, the next page, sorry, my lord, the last. Since section 38 of 2013 Act creates a bar against taking possession of the acquired land before the payment of entire compensation amount, if the land in question is in possession of the petitioner as on this date, status quo in respect of such possession shall be maintained by both party till 15 December 2023. What happened ultimately, I do not know. My lord, page 3 and page 4. My lord, so, my lord, 38. Your lordship has taught us, my lord. No, my lord, I leave it to your lordship's wisdom. I will not destroy your lordship's time. I will only say my understanding, humble understanding, that section 38, if your lordship kindly takes pain to turn section 38 of the 2013 Act. My lord, this power is unfettered, not unfettered. Power to take possession of the land to be acquired. The collector shall take possession of the land after ensuring that full payment of compensation as well as rehabilitation resettlement entitles are paid or tendered to the entitled person within a period of 3 months for the compensation and a period of 6 months from the monetary part of rehabilitation and resettlement entitlements listed in the second schedule commencing from the date of the award made under section 30, provided that provided that the components of the rehabilitation and resettlement package in the second and third schedule that relate to infrastructural entitlements shall be provided within a period of 18 months from the date of the award. Provided further that in case of acquisition of land for irrigation or hydel project being a public purpose, the rehabilitation or resettlement shall be completed 6 months prior to submerge of the lands acquired. The collector shall be responsible for ensuring that rehabilitation and resettlement process is completed in all its aspects before displacing the affected families. So, my lord, this particular section of the Act, my lord, within this paragraph, my lord, it creates a clear and unequivocal message, my lord, so far as, my lord, the legislative intention and wisdom is concerned. If your lordship says that 3G5, my lord, will supersede, my lord, to the section 35, my lord, possibly subject to correction, my lord, the reading and understanding of the statute, my lord, will take us to elsewhere. Subject to correction.
Section 38 says they have to ensure full payment of compensation.
Right. Taking of possession. The collector shall take possession of the land after ensuring, shall take possession. It is subject to, my lord, the ensuring. Who will secure, ensure? They have to secure. My lord, ensure. My lord, ensure comes, the question ensure comes when there is a determination. Determination means, my lord, determination as per law means 2013 settlement.
If you are
Subject
not
to-
happy with the law, determination.
No, I am not. No, yes, my lord, I have a recourse. I said, my lord, that today, my lord, there are two ways of looking into the matter. If your lord,
There is no determination.
no, determination. Now, my lord, what is the, my lord, subject to correction, I put this question to myself. If the law says that certain things has to be made in a particular manner, then this has to be made in that manner or not in other way. If that is, my lord, the proposition of law which creates a climate of certainty, now, my lord, then the proposition, the deductible factor is, my lord, that whether this compensation determination has been made in terms of this act. It is an admitted case of both the sides that recourse to the parameter of 2013 Act has never been resorted to. Then under these circumstances, one is, my lord, it has been resorted to, there is a mathematical error, there is an arithmetical error, then I am out of court. But when the question is that there is a complete non-adherence, my lord, there was no resorting to the method, my lord, computed under the scheme of the 2013 Act, never. Method, my lord, that is 2013 Act, my lord, it says that
It's about computation.
computation. Now, my lord, today, when
Method of
no, my lord, but question is, my lord, the authority, first of all, prima facie, I have shown that Shuna land schedule kindly turns to, my lord, second schedule and third schedule. Second schedule. My lord, I take my lord's, my lord, kind attention to, my lord, second, first, my lord, it says, I'm sorry, compensation for landowners. Market value, my lord, kindly the first schedule. Second, my lord, factor by which the market value is to be multiplied. 1, 2, based on the distance of the project of the urban area. Factor to which the market value is to be multiplied. Value of an attached to the land or building. Here, my lord, building has never been considered. Page 73 clearly states, I objected to page 71. Value of then solicium equivalent to 100% of the market value of the land mentioned. Final award in the rural areas. Second, my lord, final award in the urban areas. Other component, if any. Next, my lord, the provision of housing units in case of displacement. If a house is lost in rural areas, a constructed house shall be provided. Now, my lord, second, the benefits listed above shall also be. Where are those? I put this question. That means a determination has never been made in terms of the act. So there is no determination in the eye of law. It is just like a proposition which a lordship applies in a case of limitation. In a first appeal, my lord, order 41 or any first appeal, if there is an application for limitation, appeal is not registered. Today, my lord, the question, my lord, comes, my lord, when there is a determination as per the dictum of the legislature, that means where is the determination? Question of 3G5, my lord, only comes, and 38 will not come in the way when there is a admittedly determination following this rule. Then your lordship could have said that there is a following, they have followed the procedure, and if you have any grievance, go to 3G5. The question is when
that report needs to be called for from the
Ma'am,
a report needs to be called for.
Call for. আরে চুপ করো না,
With
চুপ
regard
করো,
to the
হ্যাঁ,
details.
চুপ করো, একটা শব্দ করবে না কিছু। Call for my lord. The interim order may kindly be extended, my lord, till the next week.
My
MD,
lord, in
may I
this
take
case,
my
my
lord's
lord,
kindly?
regarding this interim order, lord, I have to say something, lord, regarding this notice, my lord. As per section 3E, it is not mandatory, but subject to under senior submission, my lord. It is a may. The word is may is there, and in this point, lordship, our honorable High Court of this has already agitated this issue. This regarding this may point is there, my lord. Kindly allow me, lordship. This is the judgment, lordship.
My lord, kindly, my lord, ask her to file. My lord, I will not, I will,
No, my lord, because of this, lordship, because of
kindly,
this-
if she's ready with the file, kindly ask her to produce by 18. I will not evade.
No, my lord.
I
regarding
know.
this, lordship, now, lordship,
The
this-
19?
this installation of the process, lordship, that is our lordship, that is our prejudice.
My lord, who is the state? State is a welfare state. It is meant for the people under the constitution. It is not meant for the some businessman and the political leaders.
Public interest. Public interest is large.
You are pointing out to May, all the.
How can you prove it?
No, my lord, kindly allow me, lordship, this lordship, this is the judgment, lordship.
Tomorrow she will come with the bulldozer and destroy my building, and that is the intention of the legislature. I put this question to myself.
No, it is not.
What she is arguing?
Lordship. May I read, lordship?
Is it a welfare state or autocratic state?
My lord, the last line, the next contention of the.
My lord, then my lord, kindly, my lord, kindly ask her, my lord, to produce the records 24 hours. Oh, sorry, my lord.
The next contention of the writ petition is that the respondents were required to take actual physical possession of their lands in terms of section 3E of the National Highways Act 19. So thereafter the section is there. Section 3E of the National Highways Act 1956 deals with the power to take possession. Such authority and or the liability and or duty to take actual physical possession of the land would arise on the occurrence of a twofold event. The land is required to have vested under section 3D2 of the said act, and the compensation as declared by the authorities is required to be deposited with the disbursing authorities. It is stated by the National Highways that the same has duly been done. The said requirement to take physical possession as per section 3 of the act, according to me, is not mandatory. Is not mandatory in view of the use of the word may by notice in writing direct the owner. Thereafter, lordship, the aforesaid interpretation, according to me, is further fortified by the fact that where the land losers have raised a dispute with regard to the quantum of compensation decided by the authorities and have refused to accept the same. Deposit of such money may be an exercise of utility. In cases where the land losers have accepted such compensation without prejudice to the rights and content as regards as the quantum thereof, the sums of money may be required to be deposited. But even in such case, the discretion is left to the authorities to take the actual physical possession of the properties or not. There is another aspect of that. Where once a notice under section 3D is issued, the land in question automatically vests with the National Highways authorities. Any continuation of the possession by third parties to the detriment of this vesting, that is the National Highway Authority, would become void ab initio. There is a de jure position in favor of the National Highways authorities upon a notice under section 3D is issued, my lord. I am therefore of the view that section 3E of the National Highways Act, substituted Act of 16 of 1997, with effect from 24th January 1997, is not mandatory and may arise in other circumstances. In view of the above, the second contention of the petition, according to me, does not hold water.
So it may arise in other circumstances. The entire fact situation has to be looked into.
Right.
My
Here
lord,
the compensation
my
was
point is,
deposited.
lordship, regarding lordship, it is an admitted fact, lordship has received the compensation. As per, এরকম যদি করতে থাকেন স্যার আপনার মতো সিনিয়র তার খুব অসুবিধা হয়ে যাচ্ছে।
In this case, compensation was not deposited at all.
My lord, he has received the compensation as per section 3G1. He has admitted.
This case, in this.
Well, in this case, he has received the compensation as per 3G1.
In the judgment that you are
My lord, regarding lordship, the 3E case is there. 3E case is there, lordship, once he has received the compensation as per 3G1, the award and determine the compensation by the competent authority Kala. After that, lordship, how he asked for the stay of the stall of this process, lordship, because it is very clear from section 3D. It is free from all kind of.
The person who has issued the notice assails the notice. It is Mr. Dey's submission that the notice is not in accordance with law.
My lord, that is my learned
have
senior
no domain
submission.
over the notice.
No, my lord, my submission is because of this notice, my lord, because lordship, they take this notice because of from our purpose. If it has been stalled, Lordship, our entire project will be stalled.
Your counterpart is not supporting you, Ms.
My lord, that is my Lordship, that is my unfortunate part is here. My lord, that is I am not on that. But the situation is the law is different, Lordship, because the section 3D is very much clear.
We'll deal with it.
Keep your blessing.
My lord,
Till the adjourned date, it will be.
My lord,
I'll fix it.
my lord, as there is a allegation, my lord, against me, my lord, I must. My lord, if your lordship will come,
Allegation আমি করেছি।
if your lordship will come, my lord, last page 102.
102.
Yes, my lord. My learned friend said that is a valid notice. If your lordship will see. Yes.
This type of submission
You
on
should.
sealing on the same. Submission is-
My lord, if your lordship will see. In deference to the above, this is to bring to your notice that the above land has been acquired for elevated corridor of Atho for which land compensation has already been paid to you. But the said land has not yet been vacated by you. Hence, you are hereby directed to vacate the land with structure, if any. There is a structure, if any. They filed one application. That application was not, my lord, considered. Before issuing this notice, my lord, they filed an application before the authority. That application was not considered. Without considering that notice, this, my lord, structure, if any, that is, there is a doubt of the competent authority that my client, my lord, he should not write this line, my lord. If land with structure, if any, my lord, that is
That,
very.
Mr. Dev,
Yes,
if
my
there was no notice, that was one issue. When a notice has been issued, it has to be under the provision of law.
Yes, my lord.
If that is
Only for
if under the
only,
provision, my lord,
only,
statute.
এইবার দাঁড়াও তুমি তো বলেছো only for that reason, my lord, that notice should be, my lord, to us. And my lord, another, my lord, my learned friend said, my lord, there is a TG one is there, my lord, he received the money. That is the another, my lord, he's, my lord, now my lord, relief is 3G5. Or he filed an application, that application will be considered by the authority, my lord, in terms of the provision of law.
My
That is,
submission is
that
very
is
clear
my
in terms
submission,
of
my
this
lord.
judgment, my lord. Once lordship, the 3D is there. Lord, it is free from all kind of information. It is
This judgment is in the fact situation of this particular case.
Lordship,
And
regarding the
judgment
lordship, this
also-
point is lordship, the main.
The judgment also says that 3E is applicable in other circumstances. The judgment also records that
Yes,
line.
my lord, my lord.
So this is a different circumstance altogether.
My lord, in this judgment, lordship, I'm produce another judgment,
Let's
lordship.
continue on some other day.
Yes.
My lord, tomorrow, my lord.
22nd or 18, 19.
No, my lord, tomorrow, lordship.
90 tomorrow হবে না।
By this vote.
হবে না।
My lord,
90,
I am
90,
excuse my lord.
My lord,
But
give some
learned
short date, my
counsels
lord.
for the parties.
22nd.
Paucity of time intervenes. Paragraph, let the matter appear under the same heading on 30th January 30.
My lord, so much, lordship, kindly give a short date, my lord.
I have to release the matter in that case.
My lord, 8 short
Shorter date is not possible.
My lord,
after 22nd, my lord, any date, my lord, after
So many holidays next.
Yes.
my lord,
my lord, they are enjoying the lordship, that is what affected them, lordship.
And you will enjoy my property.
Yes, yes, I am enjoying your
Paragraph, the interim order granted earlier is
That's the
executed
farm.
in the adjourned date.
So welfare.
my lord, I am vexed to excuse my mentioning under compulsion, my lord. 521 matter, I am appearing on behalf of the Union of India. And I am not appearing on behalf of the National Highway Authorities, my lord. My learned friend is present, my lord. This is my wrong submission. I am extremely sorry. Lordship,
Next date.
my lord, I am extremely sorry, my lord. My wrong instruction. My lord, I am appearing. I am appearing for the petitioner. I am very humbly excuse my. Nobody, I do not know. I am appearing on behalf of the Union of India.
I missed you with the earlier matter.
My lord, I have no brief, lordship. I have not been briefed, my lord.
I'll regularize your appointment. Appear on the next day. Please serve a copy to her.
My lord, if there is any stay, lordship, that I will.
Not necessary.
No.
None appears for the National Highways Authority of India. Deputy Service করুন, none appears for the National Highways Authority of India. Our learned counsel for the Union of India. Instructions. Union of India.
Lordship, kindly, lordship, then tell my learned friend that not to take any.
She'll be in difficulty, not necessary.
My lord, I am I will intimidate them, my lord.
No,
I'll
lordship,
not-
kindly,
I'll not give any direction. You can do that if you want.
lordship, kindly, regarding my protection, lordship, the
Everything else is there. I have already recorded that the National Highways is not.
no, lordship has not recorded the submission of my learned friend that he will be taking the instruction.
Because he has given, he has undertaken
Yes.
for this.
Now he is saying that he is not representing National Highway.
National Highway, my lord. I am appearing on behalf of the only on Union of India.
back, come back on the next day.
My lord, in the meantime, Lordship,
But that's not possible.
no, Lordship, then Lordship, Lordship, kindly visualize my situation, Lordship. I'll be in a real difficulty if anything happens now. My learned friend said,
Difficulty mention the matter, I'll consider. It's a
No,
December-
Chakru.
I think it's a December order, till now nothing has happened.
হ্যাঁ, কিন্তু আমি সাবমিশনের সময়
my learned friend
submission
will
করার বলেছি
communicate,
তো।
at least
Let
tell,
us see,
tell her
let
that.
us see. Yes.
Urgency, my lord, item 562.
I'm good.
This is
Called, sir, so many.
the extension of Sanmani, my lord.
Yes, correct.
Group 7 contempt application 575.
Madam, I am for the petition.
I am also contempt.
Madam, affidavit of service, madam.
There is a, I am not going to any, I am not going into my lord controversy. There is a communication to the petitioner regarding he date for hearing to appear before the authority. But
Of the I'm
the
body.
date later has been returned back.
From the petitioner.
So I am not controversing, my lord. Lordship kindly disposed of.
But kindly come
I
to
think to
page,
comply with the order. I will in 15 days. I shall next hearing.
page 24 is the impugn order, madam. Page 24.
No, no, I am not gone into my lordship anything. Lordship,
But I have no
that's
object.
the matter.
I have no objection to that effect.
Well,
But the order has not been complied with.
Yes.
order has not been complied. I have in the letter to the petitioner for an hearing on 22nd August 2023 at 1 p.m.
So let it,
But letter is returned back.
so please send us another
Yes,
letter.
definitely. That is why, my lord, I in the letter and
Let there be some time.
no.
Cannot be disposed of.
Lordship.
Has to be complied with.
Yes. Has to be.
Affidavit of service. Learned counsel for the alleged contemner seeks accommodation to comply with the order under contempt. Paragraph, let the matter appear under the same hearing 1 month
1 month.
on 20th February.
Yes.
Paragraph, affidavit of compliance be submitted on the adjourned date.
28th February.
28th, 20.
20.
Deep double.
20, no?
576.
Yes.
576 and 577 are the singular matter.
তুমি কোনটা আছে?
576.
I'm appeal.
Yes. Is this a hearing matter?
My lord, affidavit has been completed.
So let it appear under the heading hearing.
It was appearing under
Not get into the motion.
hearing is hearing last occasion it has appeared in
So I'm not taking up hearing matters till the 22nd because of the other determination. So let it appear as a hearing matter. Didi, it's a hearing matter. Hearing matter.
Why it was appearing in the first matter in the hearings under the caption hearing.
Hearing is চলছিল হঠাৎ মোশনে চলে এসেছে
Hearing এর
Let the matter appear under the heading group 7 hearing.
The next possible date, my lord. Next possible date, my lord.
30th January.
30th January.
576 and 577 same order.
Same man.
For the affidavit has
I've seen. That's why it struck me that it's a hearing matter.
in the last occasion it was
Come back, let me deal with it.
578.
For the repetition.
Respondents?
Yes, respondents, my lord, there are two respondents. One is the principal respondent, that is the railways. And another one is Mr. HON'BLE is appearing. Pioneer. Ashwin, and Mr. Sen is appearing on behalf of the legal metrology.
Mr. Rudra.
Well, so far legal metrology is concerned, my lord, I think, my lord, a report has already been filed.
He's appearing for the railways?
No. He is only
I don't
appearing.
know.
Now, my lord, on the previous occasion, Lordship has seen the previous order, has directed the railways to come up with the women report. Because, my lord, I have alleged that the overloading has taken place One of the possible reasons, my lord, among others, is that the speed at which the wagon ought to have passed the in-motion weighbridge that has been demarcated by the legal metrology and also by the railways commercial manual, saying that minimum speed of 10 to 15 km per hour, and the commercial manual says within 10 km per hour.
My lord, your lordship directed me to file a affidavit along with the computerized print. But that has been prepared but could not be affirmed. My lord, kindly let.
You have to annex the weighman sheet and the
Yes,
weighman report.
yes, yes. I shall annex.
On the date when the incident occurred, my lord.
Yes.
So,
on that day.
and even if
My lord, the train passes through the, although I have mentioned that the speed is not the factor, but whenever it passes through that weighbridge, it passes 4 to 6 km per hour.
Speed is
And I have-
a factor. It's a legal metrology saying. Who are responsible for maintaining the in-motion weighbridge.
They maintain the speed. That I have seen in video also,
And
Please
they,
come back with your report.
my lord.
and they have said,
My lord, by next week, please send it next week.
actually next week, my lord, February, my lord, interim order may be extended.
বাবা হয়ে গেল তো
Learned
ফেব্রুয়ারিতে
counsel
হবে
for the
কত
railway authorities
আর তো 2 মাস আছে
seeks extension of time to use the supplementary report as sought. Paragraph, let the matter appear under the same heading on 13th February.
Lakshmi, interim order may be extended.
My lord, in their report, so far the railway is concerned, my lord, let them also, if they think fit, they will let them also, my lord, take note of our report. If anything they would
Yes,
say,
yes. Please.
otherwise, my lord, there will be again. না না আমাদের রিপোর্ট আপনাকে দেওয়া আছে
There is a apparent contradiction, my lord.
No, no,
As on presented.
no contradiction.
contradiction, they have not yet filed
In,
report.
in reality.
Not be any contradiction for the.
That is why I am,
For the reason.
that is why.
Mr. Sen is asking to,
Yeah, to get rid of all that.
No, no, I have seen the computerized.
please
Video.
go through the report given by the legal methodology.
Oh, his report. Yes.
Legal metrology, my lord, has high.
কিছু থাকে আমাদের report.
It should not be contradictory to, I mean, the.
Yes, yes.
Because in our report, it has been stated that there is a regular checking in terms of the act and the rules. So if there is anything they have to say, let them deal with the same also.
Yes, 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 absolutely.
তাহলে আপনি exception পাই।
13th of February.
ঠিক exception নয়, যদি
Paragraph,
কিছু
the
বলা থাকে।
order granted
I'm not telling that
29th
exception.
February or under. 2024 order.
Good. Advance,
হ্যাঁ হ্যাঁ দেবো
advance.
Please serve an advance copy.
এই কবে হবে?
30, Lordship has fixed it on 13th of
13th
February.
13th February.
And I say, my lord, only 2 months is left for the period to get over. 2 to 3 months is left. This is a contractual period is coming to an end by April, May.
Let us see. if we can dispose it over the next.
579.
Petition. Report.
Only day before yesterday I have to take.
Appearing for quite some time.
My lord, your lordship, your lordship. This is my lord appearing since my lord, July 2023.
Yes.
And my lord, then your lordship,
Only day before yesterday.
each and every day, when the last occasions also, your lordship's observation,
Some
it has
other
to be.
counsel was appearing in this matter.
Yes, my lord, Supratim Dhar was appearing.
আমি বললাম যেটা, আমাকে রিকোয়েস্ট করে যে চিপে যে তুমি এটা ইয়ে করো, যে অ্যাসিস্ট করো কোর্টকে, তা নাহলে এরকম ইয়ে।
Only your lordship, on what basis your lordship?
My lord, I am
Copy page?
A copy big sir.
My lord, I will hand over him a copy. My lord, I must type.
Serve a
But
copy and please come
the
back with the report.
issue, my lord, your lordship is aware, the issue relates to the director has given, my lord, the memo in which he has given a observation distinct and different with the battery given. And my lord, the additional secretary has given a memo there. He told that they have no such expertise to determine whether this, my lord, this will completely different with the according to hierarchy.
This
No.
additional secretary.
Also intimated that in terms of the course of.
No, that subject.
Subject.
No, that is the subject.
They are
No,
the subject.
that the observe. I will. No, that has not been. That is my respectful submission. The observations in paragraph 6 and 8 of the director, that has to be modified to the extent that.
Contradictory.
Yes.
That has,
That has to be
I have not gone
One
through the
authority says it's distinct and different. The other authority says we do not have the expertise to make out whether it is distinct or different.
My lord. My lord.
So there is a contradiction.
There's the contradiction. So that should be modified.
Learned counsel for the respondents.
At a copy.
Seeks for an extension of
Asking copy.
the report in the form of affidavit as so. Paragraph, let the matter appear under the same heading on 7th February.
Mine. আমি সবাই ফোনে বলেছে তারপর লোক একটা কপি দিয়ে দিচ্ছি।
Yes, yes.
7 তারিখ।
যদি ওনাকে দিয়ে দেন না।
580.
কত আছে পরে?
Lordship, I'm the petitioner. My senior is sick today suddenly. On his behalf, I'm paying for now.
Service upon the respondents.
Yes, Lordship.
Where is the service?
The service is one of the.
On prayer of the petitioner, the matter is adjourned. Mr. Devra, petitioner is not there. Let the matter appear under the same heading on 16th February.
16th.
Next. Next matter.
Exception.
581.
Exception.
The only issue relates here, my lord. The only thing is that the notifications which says, my lord, the quota of the particular rate is 50. And my lord, the response to the RTI subsequent to the notification, it says that 22 to 20 and 22 has been filled.
That is in reply to your RTI.
Yes. And the notification is earlier one.
50.
Yes, earlier one, then subsequent RTI response is that
That's in
22.
20.
Yes, my lord, that has not been dealt with in my lord, Mr. Devrai's report. That particular issue has not been dealt with. And my lord, the other thing is this, my lord, the invitation which has been come, my lord, the notification of May, I think, May 2023. That by a notification, the authority asked to submit the applications for 3 categories. One is those who haven't any registration and permit of the vehicle. Second is the registration of the vehicle is there, but the permit is not there, but they are operating. And third category is those who have the permit and the vehicle, and the permit has been given to one route, they are operating in another route. These 3 categories asked to submit the application so that they can be accommodated. That is the, Lordship, kindly come to this, only the notification. Your Lordship will find that is page 63 of my writ petition. This is the policy. This was a policy, and the policy, on the basis of the policy, on page 63, P5. These 3 categories has been asked to apply. Page 63.
Yes.
Your Lordship will find that
One is autos physically plying on a road since 31st March 2019 to 31st March 2022 with engine number, chassis number, without having any valid registration number. One, but I think I am in serial number 3. Registered autos not possessing serial number 2. Registered autos having permit but the auto has been registered but physically applying on a road in different routes since so and so so and so. But I am plying a vehicle with a permit but in a different route. They also apply for that particular route where they are plying. Note that according to that their invitations I applied, and the routes where I have applied according to the notifications it is 50. And according to the response given by the authority itself, that is 22 has already been filled up. So that part has not been dealt with in the report. What about 28 vacancies?
Page 66 is the notification.
Yes. No. Notification. No, this page 66. No matter, page 66 is not the notification. I am giving this. Notification is at page 44. Page 44 and the 45. But these are the routes. Page 44. Serial number 8. Your lordship will find Howrah Station to Sipur, Ramdivo, the 50. This notification is of, my lord, 21st March.
Present number of permits is 50 and modified number of permits is 50.
Now your lordship kindly see. This of 21st March 2023.
There's no vacancy.
How can it be? Your lordship kindly see that is my issues. That has not been dealt with. Now your lordship kindly see the page 64. Your lordship kindly see the page 64.
Yes.
This is the response to my application under Right to Information Act. Page 64. It is dated of August.
Here they say 22.
22.
But here it is said 50.
So this is earlier. Now it is on August, it is appearing that there are 28 still vacancies. Because of 22, they have filled up. So out of 50, 22, according to them, even in August, this has been filled up. That has not been explained in his report. I have gone through this report, and in the exception, I have given this also. That has not been explained.
May I submit one thing? So, I think that confusion arises. The scheme framed by the government regarding unauthorized auto rickshaw regularization. That is the main intention of the government.
3 points. You have also
Yes.
stated in your report.
Yes. I am coming. There are 3 points. Auto rickshaw physically plying on roads since 31st March 2000, paragraph 7 of my report, page 3.
Yes.
Paragraph 7. Admitted with the auto rickshaw physically plying on roads since 31st March 2019 to 31st March 2022 with engine number so and this is number without having any valid registration number. B, registered auto rickshaw having permits but physically plying on different routes since 31st March 2019 to 31st March 2020.
The petitioner has applied under this category.
It is an appeared this way. So this is a change of route. He has already obtained enjoying a permit. He has to change of route.
Yes.
That is, first of all, change of route that is not permissible in view of the scheme. Our contention is that, and Lordship kindly see, paragraph 8. A bare perusal of the representation made by the petitioner number 3 being annexed P8 to the representation page number so and so. The petitioner number 3 has applied for change of his route permit A11 to and so, though the representative made by the other petitioner have not been annexed to the petition, however, the fact remains, petitioner 1, 2, and 4 have also applied for change of other route permit AR 4, 9, and AR 11 to AR 8. From simple comparison to subject to of this scheme, representation of the petitioner, it would be evident that the petitioner do not come within the purview of the said scheme, and hence, considering the application of the petitioner and allowing the same is not permissible under the law. Next, my lord, furthermore, the petitioner have sought to make an application, the application made under section 88 subsection 3 Motor Vehicles Act. In this, it is submitted that the second proviso of subsection 3 of section 80 of the Motor Vehicle 19 clearly specified that in case of variation, the termini shall not be altered and distance covered by such a, this is not very important, my lord, that main intention is this, my lord, it is placed without record the honorable court that for a better transport management, paragraph 12, none of the RTA allow transfer of permit from one route to another route in any condition. However, if such transfer is allowed, the same will create a precedent, and all existing operators of less profitable routes shall fervently apply for transfer of their permit to a more profitable route, which would result in gross suffering of the inhabitants and commuters of the area due to lack of transport.
Have you recalled your notice at page 63? You have invited such applications for transfer of route.
And that too, my lord.
It is your notification, it is your
And
delivery.
subject to, my lord, that too also, my lord, your lordship will find the notice which refer, my lord, the notification dated 21st of March. That is that notifications. These invitations followed by an earlier note, that notification.
Yes. Page 63 of
29 May 2023.
this is your document.
Yes.
You have invited, the petitioner has applied.
But physically applying on road in different routes since
Point number 2.
point number 2. Yes, yes. That's correct.
So your report is contrary to this notification. It is an incorrect report.
Then, my lord, is moreover, my lord, I have submitted before your lordship, that is my specifically instruction. There is no vacancy at present on the routine question. If any future vacancy arises, he may apply for same.
Nothing in your report. Please come to the earlier notification at page 45, 44. Page 45 is the relevant page.
Page 45.
50 vacancies.
My lord.
And now page 64.
Serial number 8.
Page 64,
then-
it says 22 permits issued.
That is till date. But till date means
Correct, I think.
August 2023.
August.
How the officer-
And my lord, that next page, your lordship kindly see.
Well, I have to
If
take
it is
further
not correct, your
instruction
lordship
regarding
kindly
vacancy.
see next page. They have annexed the number of the vehicles. Yes, that they have given the number of the vehicle, number of the permits presently plying. That is given also. This is very particular on these issues. They have given this.
I shall take my last further instruction regarding this point is concerned, regarding RTI report is concerned. Why the vehicle number is 22? Now they say that there is no vacancy. It is not possible, man.
And not only that, your report is a
Different,
An
different
inquiry
aspect. There is a
it's contrary to your own notification.
government says the change of route, but they are
It's
not changing.
permissible.
Policy.
And you have invited applications. And when they apply, you say you are not eligible.
No vacancy. This is not the correct. Tomorrow I shall take further instruction, and also, my lord, vacancy position in respect of this routine question. Now,
that.
number of vehicles also there. I shall. Any day fixed, my lord?
Now, your lordship, another thing. The notifications, my lord, the invitations come. My lord, there last line, your lordship kindly see. The application should contain all the relevant paper in support of his or her claim. The last date of submission of the application 20th, my lord, September. And by that period, I have applied for. If anything happened after that, or if it is filled up behind my back,
Let there be a further report to this.
This way.
20th September 2023.
Yes, I have applied before that. That is the last date, 20th September. I have applied prior to that on the basis of your invitation. That your lordship will find that date of my application. They have received it 24th August.
Exception by the petitioner is taken on record. Paragraph. The report in the form of affidavit submitted on behalf of the respondents is contradictory. The notice dated 29th May 2023, which invites applications from registered autos having permit but physically plying on road in different routes from 1st
Or the 88.
March 2019 to 31st March 2020. Also, the number of vacancies reflected in the notification dated 21st March 2023 differs from that of the reply given by the authority to the application made by the petitioners under the Right to Information Act 2005. Stop. Paragraph. Learned counsel for the respondents seeks to take further instructions in this regard. Paragraph. Let the matter appear under the. These are the two specific issues.
2 points are there.
Not only one.
First, 2nd February.
29th.
Next
No, next second after that in any date.
7th.
Right.
Huh? After March, after May. Yeah.
And Malad
7th February.
and Malad one indulgence, Malad, whatever be the instruction that should be filed by OFN affidavit. Because if I have to. No, but
Yes, because it has to be on record.
I'll say.
Next.
582.
582 मला दाखवतो.
Oh, এটা কত সম্পদ 595.
मला यार मला
Mr. Devroy, instructions.
I think it's full.
My vehicle मला carrying below the मला.
That was initially when blacklisted, therefore the RTO requested the RTO to delete the blacklisted person. Lots of them. Possibly direct the RTA to act on the basis of the. দেখে না release the vehicle from the bound quota so that the owner can do further transactions.
You are against the blacklisting, is it?
Blacklisting.
Only one. আমার গাড়ি হয়তো সেখানে ঢুকেছে।
এই তো
আমি বুঝেছি
W59C 8206 wrongly চলে গেছে।
হ্যাঁ wrongly চলে আমি সেটাই বলছি।
It's erroneous blacklisting.
Erroneously blacklisted.
Affidavit of service. Petitioner has challenged
Page 21.
Impugned blacklisting search report of his vehicle bearing number WB59C 8206 dated 25th April 2022. Stop. Paragraph. Learned counsel for the respondents produces a letter issued by the additional regional transport officer, Islampur, Uttar Dinajpur. Issued by the to the regional transport officer, Raiganj, Uttar Dinajpur on 16th October 2023, requesting release of the vehicle in question from the Vahan portal in order to enable the owner of the vehicle to carry on further transaction. Stop. The letter records that there was erroneous blacklisting of the vehicle. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent to act in terms of the
Third respondent, regional transport officer.
second respondent
Who is telling? Oh, sorry. Extremely sorry, madam.
act in terms of the letter dated 16th October 2023. 16th October 2023. Within 1 week. Within 1 week from the date of communication.
Date of communication. Much.
Paragraph. There shall however be no arrest to costs, since no affidavit has been set forth.
Much obliged.
Lordship, in 583, I appear on behalf of the respondent number 5 in the writ petition. Lordship, I filed a can for recalling of the order dated 16th of October 2023.
It's appearing for the petitioner.
Lordship, basically on 4 grounds. A, that your Lordship was, the matter was taken up by the urgent determination without any notice to us. So the respondent number 5 was not represented when this impugned order dated 16th of October 2023 was passed. B, on the fact that there were suppression of material facts. C, on the ground that there was no urgency to move the urgent determination bench. And 3, that the order itself of 16th of October 2023 has not been complied with. Lordship, may I first take your Lordship to the first ground that the matter was taken up with by the urgent bench without any notice to us. Lordship will file in my can.
Prejudicially affected.
Lordship, I am prejudicially affected because your Lordship, today the finance company has already sold it to someone else and the order is restraining me to do so. But before this order was passed, it has already been done. Lordship, may I first take up your Lordship, let them show that any notice was served upon me before the urgent determination was moved, because there was no notice, and B, there was no urgency to do so.
Can that be a ground for recalling of an order?
Your Lordship, the other grounds are there. If your Lordship,
Unless you show that you are prejudiced.
Your Lordship, I am prejudiced in the, your Lordship, may I take your Lordship through the order, page 16 of my application, your Lordship.
Mr. Mukherjee, have you received a copy of this application for recall?
I have not this.
Have
Can.
you served copy?
Can.
Yes, ma'am.
Have you served the state?
Lordship, I have served everyone.
I have not received.
Then I have to serve him and
Serve
come
and
back.
But this
Order.
order,
Has to file a report.
there is they, I can say the great respect, I can say my learned friends having no puttings only to that effect, they are the financer, they admitted they sold the vehicle. Now my issue was there. This is a vehicle covered under hire purchase agreement with the financer. Now they seized the vehicle owing to default.
No matter two issues were there. It has been, when it was taken up, when it was seized, the registered owner died. I have annexed the document, the registered owner died. No matter they sold and it has been possibly transferred. Now the vehicle has been sold and transferred at the instance of the private respondents with the financer. With the connivance, my issues were there with the connivance of the state registration authority. Because the provisions, your lordship is aware, section 51 subsection 5, there is a provision. The original registers has to be sent a notice by registered post in the last address given in the certificate of registrations 1, and the format has already been given in the Central Motor Vehicles Rules, Rule 62, Sub Rule 2, and the format which has been given, that is
Lordship, I'm
Form
sorry to interject, but I
37.
have not placed my case. My learned friend is, Your Lordship, since Your Lordship
That only my grievances
I have
in
not placed
respect
my
of not on the base, not upon the financer.
I stopped because it was to be
The
served.
application has to be heard.
Yes, Your Lordship.
This is an application for recalling. Please serve.
Number the
Yes, Your Lordship.
only
I'll serve and
application
then
for
come back.
recalling and
I'm not got into
modification.
the merits.
Yes.
I need to also file because the order, Your Lordship, kindly see the order.
You want to come back with an affidavit to this?
No, because not that, because the order which give some there is, Your Lordship will find that
So with all due respect, I have not opened my case since my learned friend has not received the copy. Let me serve him and come back.
Directs to they pay the due installment so that the vehicle cannot be sold. It is the contention of the financer, it has already been sold. There the modifications required, the questions of payment of the due installments to the financer at present case. Because Your Lordship kindly see.
So then in that
Subject to Your
event,
Lordship kindly see the last paragraph.
so then in that event, I believe my
Page
learned friend is
18.
on the same
Yes,
page.
you are right. Page 18. The instant writ petition is admitted for hearing subject to payment of admitted
Actually,
areas.
still do not understand how you are prejudiced because you say that you have already transferred prior to this order.
Lordship, 1 year prior, and the
Have
petitioner,
to show that.
Lordship,
You're not
it's,
bound. Right?
Lordship, I am not bound, but even though, Your Lordship, when the writ petition was heard, this was not placed before before the Honorable Court, and thus this order was passed. Your Lordship, if the learned court was apprised of the fact that 1 year prior, this last letter on the basis of which my learned friend,
Why don't you?
Your Lordship, then the order has to, Your Lordship, then the order has to be modified subject to what falls from Your Lordship, because there is a specific direction on me.
It has been transferred, you say.
Your Lordship, 1 year back, even before the writ petition was moved.
File a report and say and give the documents.
Your Lordship, that
Delaying the matter unnecessarily.
no, Your Lordship. Your Lordship may kindly to not take me up.
Serve the copy.
Yes, Your Lordship. I'll serve and come back.
It's another date.
Yes, Your Lordship.
You want
So
to
while-
file an objection to this? No.
No.
The
I
recalling
need to.
application?
This is actually this recalling and modification. I need to file an affidavit to the effect because it has to be clarified because they have stated that they have yes they have
Let
stated
him-
that it has been
let
sold.
him come.
It was my apprehension they might have sold the vehicle, but it is appearing from there they have already sold. Now they have a right to sold. They sold it. Now I have to.
So my learned friend was aware, and this could have been found on the net itself.
No. You have
2023 letter of September was only to create a cause of action.
I am not on the private respondents.
Your Lordship, without going into merits, Your Lordship will direct me to serve it, and if my learned friend wants to use an affidavit.
The applicant is directed to serve copy of the application along with
Subject for objection
file affidavit of service on the adjourned date.
Paragraph
Paragraph learned counsel for the petitioner seeks to use an affidavit in opposition to the application. Paragraph affidavit in opposition be filed within
The shortest period possible.
2 weeks,
1 week, my lord. It need not be.
within 1 week from date.
Every
Stop affidavit in reply, comma, if any comma be filed within a week thereafter.
Grateful.
Paragraph, let the application be taken up for consideration on 9th February.
Grateful, Your Lordship.
Please serve in the meantime.
Lordship. Grateful.
Next.
Private court.
But I am for the private respondent number 4.
This is my video, sir. The subject matter of challenging the writ petition is cancellation of my permanent stage carriage permit under the threat of a contempt proceedings arising out from a writ petition where I was not made a party. Resolution has been adopted for cancellation of my permit without any notice to me behind the back of my knowledge. All on a sudden, I have been intimated. The brief facts of the case is that, my lord, I am a permanent stage carriage permit holder in respect of route number 71. Now, plying my vehicle from Howrah Maidan to Salt Lake. My initially permit has been granted to one Pradeep Singh in the year 2005. This year is very important, 2005. Subsequently, in the year 2010, in the month of March 23rd, this permit has been transferred to me with the condition that I have to replace a new vehicle following the BS norms. I replaced the vehicle within 7 days on 30th of March 2010 after hiring a vehicle from the West Bengal Infrastructure Development Corporation under the Jawaharlal Nehru scheme. Then all on a sudden, on 9th of November 2023, I have been intimated that my permit has been cancelled by virtue of an order passed in a contempt proceedings. If your lordship straightway kindly turn up to page 109 of my writ petition. 109. This is the communication made to me on 9th of November 2023. Kindly see address to my client Rahul Chandra, reference WPA number 17233. My lord, I was not a made a party. I have already submitted. Shobha Singh is the writ petitioner. My learned friend is appearing on behalf of the private respondent. Pursuant to the order passed by the Honorable High Court, Calcutta, dated 31st of March 2023, in connection with the writ petition mentioned above, the decision taken by the Regional Transport Authority Board meeting on 10th of October 2023 in respect of the above writ petition, application is being communicated for information. The extract of the resolution of the Regional Transport Authority Board meeting dated 10th of October 2023 has been enclosed. This is for your kind information. Kindly turn up to the resolution. Next page. The first two lines says the meeting held on 10th of October 2023, then members present. Kindly turn up to serial number 4. WPA number so-and-so, Shobha Singh, that's data West Bengal. That's the client my learned friend is representing. An order has been passed by the Honorable Justice so-and-so, Calcutta on 31st of March 2023, directing the Regional Transport Authority, Kolkata, to comply the order 9th of April 2019 in WP number so-and-so, in its letter and spirit within possibly it will be within 2 weeks. From the date of communication of this order in respect of the application of the offer letter submitted by the petitioner in the route number 7. Petitioner means the Shobha Singh, not my client. I was not made a party. The applicant Shobha Singh applied on 13th of October 2017 for offer letter in this route. She was called on hearing before the Regional Transport Authority Board on 16th of November 2017, and she was duly heard. The RTA Board considered her application and rejected it on the ground of the vacancy in the Route 71 at that point of time. So there was no route on that material point type, on that ground matter, his application has been rejected. The petitioner was requested to appear before the Regional Transport Authority Board meeting held on 10th of July 2023, filed memo number so-and-so for hearing in respect of the above mentioned writ petition. The petitioner appeared before the Regional Transport Authority Board meeting on 10th of July 2023 and she was duly heard. The Regional Transport Authority Board discussed the matter and decided to give the performance for offer letter to the petitioner when vacancy will arise in the Route 71. Contempt letter has been received by this office on 29th of August 2023. In view of the initiation of the contempt of court proceeding, bearing number so-and-so filed in Honorable High Court, Calcutta by Shobha Singh, the RTA Board has decided to look into the matter afresh, and for that a fresh resolution decision will be taken by the RTA Board on the matter of WB number so-and-so, Shobha Singh by so-and-so, in the next board meeting when subject to leave of the Honorable Court, Calcutta, a fresh decision will be taken by the board with regard to the direction contained so-and-so. But pausing for a moment, it transpired that only for filing the contempt application under the threat of contempt application, fresh decision has to be taken by the RTA. And these all are behind my back. Kindly turn up to the next page. Subsequently, a show cause was issued against the existing permit holder, Rahul Chandra. This is my client. Before the secretary on so, he appeared and was duly heard. He submitted written declaration requesting the board to allow him to continue with the permit until 21st of February 2025. But this is the date, validity of my permit. So I have submitted, my permit is there, you cannot stop it. Next, to take a decision accordingly. Resolution, RTA board scrupulously discussed the matter and decided to comply the direction contained in the order dated 31st March 2023, passed by the Honorable Court, Calcutta in WP number so and consequent upon order of the Honorable High Court, Calcutta, the RTA board decided to cancel the permit. In a proceedings where I was not party, the decision has been taken that my permit will be cancelled. In respect of the vehicle number so vacate the position 2471 as directed by the Honorable High Court, Calcutta and so. Now, your Lordship, kindly see at page, my Lord, 64. The initial order passed by Justice Talukdar, as his Lordship then was, in the first writ petition at page 64.
What is your prayer?
My prayer is to cancel the resolution. Kindly turn up.
How can this court do that, Mr. Dal?
My Lord.
How can this court do that?
Violation of fundamental right, principle of natural justice. My Lord, there are lacuna of judgment which says if there is a violation of fundamental right, if there is a violation of natural justice, writ court can interfere at any point of time. I can show all those judgments before your Lordship. This is a case where my livelihood has been taken away without intimating me anything.
This court's order.
No, this court never directed. I shall show to your Lordship. The false submission has been raised on behalf of the petitioner behind my back that I am not plying the vehicle. I shall show from my documents that police cases has been filed from 2017 to 2023. Permit has been renewed time and again. I have not been in party a specific submission before the court that I am not plying the vehicle. Even my Lord, section 64 does not say that if I not ply the vehicle, that cannot be terminated. This is a case where, my Lord, my principle of natural justice has been taken away, my livelihood has been taken away without providing any opportunity of hearing. So, Lordship, kindly come up to the order passed by Justice Talukdar at page 64. I shall show how the writ petition has been filed. This is an order passed on, my Lord, 9th of April 2019. What was the allegation in the writ petition? Behind me, kindly see. Party transfer, Mr. Samanto, Learned Counsel appearing for the petitioner submits that the petitioner applied for a permanent stage carriage permit in route number 71, which is notified route between so and so. Under section 71 of the Motor Vehicles Act, the total field strength under the route 40, Mr. Samanto takes the specific point that the petitioner applied to the vacancy created by the 24th permit holder. Well, pausing for a moment, according to him, this 24th vacancy where I am plying, I have stopped plying my vehicle. Next paragraph. However, since one permit was allotted in excess of the notified strength of 40 and the fifth strength was allowed to 40 plus 1, with the 24th vacancy having arisen by the Regional Transport Authority Kolkata by its agenda number so and so, RTA choose to absorb the additional permit 40 plus 1 against the notified vacancies of 40, adjusting the additional permit so and so. Mr. Samanto challenged such action of the RTA Kolkata as unjustified and untenable in law on the ground that an existing illegality by granting a permit in excess of the 25 strength could not be legalized under the grab of lifting the additional permit to a vacancy, fitting a permit vacancy within the total notified number. Mr. Samanto submits that the petitioner therefore has a right to be considered against the 24th vacancy as subsisting within the notified strength of 40, including the additional permit illegally. Mr. Chen, learned additional government leader, takes the stand that it is the total number of notified vacancies within must be reckoned. The RTA Kolkata has treated the total number of vacancies 40, and in view of section 71 of the Act, there is no scope for considering the case of the petitioner beyond the 40 number of vacancies. On the next page. Having heard the parties and considering the materials placed, this court is of the view that the 24th vacancy creates within the notified strength of 40 requires to be treated as a district necessity within the distinct vacancy within the notified vacancy performed. The RTA Kolkata cannot be this stage legalize the 41st permanent holder, adjusting the so-and-so. The petitioner therefore deserved to be considered against 24th vacancy as created, treating the notified strength to be 40. It will be open to the RTA Kolkata to treat the additional vacancy of the beyond the notified strength 40 in the manner as deserving in law. With the above observation, the matter is demanded. This is a direction with the court has proceeded that there is a vacancy. Why court has proceeded on the basis of such vacancy? Kindly take up 2 paragraphs of the writ petition. The first writ petition, kindly turn up to page 45. This is the first writ petition filed by my learned friend.
Before this, please justify that a fresh writ petition lies. You have not preferred an appeal. You have not preferred a review.
I am not on that. Court never directs to cancel my permit. This is my specific case. The RTA board took a resolution behind my back, cancelling my permit. No, subject to lordship consideration. But this is a violation of principle of natural justice. My livelihood is taken away. There are catena of judgments. But subject to lordship consideration. If my livelihood is taken away behind the back of my knowledge, and if my fundamental rights is affected, this is protected under Article 91G. This is protected under Article 21 of the Constitution of India.
Or an appeal lies.
But if there are judgments of Supreme Court which says
A fresh writ petition lies.
this is not a fresh writ petition. This is my first writ petition.
Fresh writ petition.
No, I am filing
Passed by the same court.
subject to lordship consideration. Court directs to consider his representation. Kindly consider. Court never directs to cancel my permit. Under the threat of contempt, my permit.
The court, I think it was a little more of a direction, not only consideration.
Kindly see, where is the direction for cancellation of my permit? Your Lordship, kindly allow me to 2 paragraphs of the writ petition. Suppressing the facts,
That please show me the judgments that you are referring to.
shall keep it on tomorrow.
That this is
Keep it on tomorrow, my lord.
not possible. I have to fix a date.
My lord.
So Devra,
Because, my lord, your Lordship, kindly consider if the proceedings on the basis of that cancellation and grant permit on last occasion, they have paid for an adjournment.
actually, I distinctly remember the other case. That's why I say that I don't think.
I can show from the writ petition, it's a specific appointment that I came to learn that my client has stopped flying off the vehicle. And on the basis of that, court proceeded with the matter. This is a nullity. They have stated in their writ petition that Rahul Singh is not flying his vehicle for last 4 years. I shall show from the document annexed to the writ petition. In every year, I have renewed my license. In every year, there are police cases every day that I have annexed all documents. By suppressing the material facts, concealing the material facts, this order has been obtained, and this is a nullity in the eye of law.
Necessary.
Only one document, my lord, page 76. This is the resolution passed in terms of the court's order, my lord. My lord, below, my lord, the order of the Honorable High Court in connection with writ petition number such and such has been perused by the RT board after hearing the petition and it is decided that. Kindly straightway come to T. It is reported that the vehicle.
You are at page 76.
76.
76 is the last page of the order. Starts with total fleet strength.
So, my lord, 76 of the writ petition.
This is the communication resolution starts from page 73. Starts from page 73. There are 2 marking possibly, my lord. Maybe, my lord. This is the last page of page 73.
73, yes. It
Starts from page 73. Page 76, my lord.
May 2019.
My lord.
Point D.
Point D.
D. But the RTA observed that it is reported that the vehicle bus has stopped flying on the state route. If the above mentioned information is correct, then the permit for the said vehicle is to be cancelled immediately. Well, this is not my observation. This is the observation of the authority.
Yes.
That the vehicle is not flying for a long period.
If
Well, D is important, my lord. It is reported that the vehicle bus has stopped flying on the said route.
the conjunctive D and E. Who has reported it? There is no inquiry.
It is the resolution of the RT.
No inquiry has ever been conducted.
That is
This is reported by the writ petitioner, which I will show from your lordship from the writ petition. Only 2 paragraphs. came to learn he is not plying the vehicle. That is the report before the RTA. There was no inquiry, nothing. No evidence. Let the RTA say,
A hearing notice was issued to you?
no,
Nothing.
no, that's my case.
Violation of principle of natural justice.
Violation of principle of natural justice. This regulation has been adopted behind my back. Last regulation where my permit has been cancelled behind my back.
Mr. Devra, please come back with a report.
But in terms of the offer letter,
Permit has been.
I have purchased vehicle, BS6 new vehicle, my lord, which has been registered
For
on
the
30.
petitioner in the earlier petition?
Yes, yes.
Two petitions, both behind my back.
My lord, I applied, submitted all the required documents to the authority for issuing permit. My lord, by letter dated 5th of January, they refused to issue such offer. Permit.
I'll read it.
Please stay your hand.
Yes.
At the time of Sara moving the petition.
But because my lord, the authority written this letter.
That is why I instructed my client.
Yes.
Independence of matter, I cannot.
This is the case, my lord, where my permit has been cancelled in a regulation where I have not present.
Not taken sub notice.
Please come back with a report, Mr. Devra.
And I shall, on that day, I shall rely on the judgments.
Yes, yes,
Yes.
please.
Your lordship knows possible it's a fundamental, a violation of fundamental rights.
You have the forum of review and appeal both, even review.
But that Supreme Court has
But
says,
not a separate writ application.
no, this is not separate. Why I am telling you, there is a challenge.
Petition.
Regulation of the board where my permit has been cancelled. That resolution is challenged because I was not given any notice, violation of statute.
Resolution was pursuant to an earlier order of this court.
Maybe, but
So
that cannot be contrary to the provision of 68. 68 said notice must be given to the person concerned whose license is going to be rejected. I should have been given a notice. This violation principle of naturals gives me the right to file a petition.
Sure, please come back with the judge.
My
I'm
lord.
not really convinced. I must.
My lord.
The resolution taken by the correspondent authorities on 10th October 2023 is held in the writ petition. Paragraph, learned counsel for the petitioner submits that his permit has been cancelled by the said resolution without granting an opportunity, him an opportunity of hearing. Paragraph, learned counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 12th February.
Only in the meantime, status already your lordship has directed by learned friend. So your lordship can record this one.
Let's continue. There is no direction as such on.
No, verbally your lordship, that will continue. I'm grateful.
No direction.
Taken up. Let us see.
I'm grateful. Much.
Next.
Every side said
585.
My lord, in this matter, my lord, I have filed an application for addition of party ban.
My lord,
The party respondent, my
on
lord.
behalf of Dilip Kumar Samanto, he is, yes, my lord. My lord, I am praying for not today.
Have you received a copy of the application?
Yes, I have served Mr. Samanto, but I need to serve Mr. Sahara. Today,
Can 1 of 2024.
sorry, I am sorry.
Can 1 of 2024.
দিদি আমরা
আর কবে দেবে ভাই?
এটা জেরক্স করতে হবে।
You know, মামলা আর কি?
You want to be added as a party?
Yes, ma'am.
585, I was not there.
My lord, I will need to serve a copy to.
585.
585, you're not a.
585, I am.
There is a review of service.
My lord, my senior is on legs, so he could not come. And
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 16th February.
my lord, next one also same.
My lord, I have filed an application for addition of party. May I serve a copy, ma'am? Today it's appearing for the party. আপনি আছেন স্যার?
আমি নেই।
আপনি
586.
86 ফল করে যেত 86
56, sir.
এই দুটোতেই can.
586.
Can কই?
Deeply obliged.
ওয়েট করুন ম্যাডাম
এদিকে এইটা
5 মিনিটের মধ্যে
587.
16 February.
My lord, I'm appealing for the
By
petitioner.
87.
I'm appealing for the petitioner, my lord.
Have you served?
Yes, my lord.
Special land acquisition officer, why?
Yes, my lord, there is a bit confusion, my lord. My land was acquired by the land acquisition department around out of 10.5 shotaks, 7.5 shotaks were acquired, leaving behind 3 shotak of land. My lord, when I went to fencing my land, there was some obstruction from the local authorities, so that's why we had written a representation to the land acquisition officer, being respondent number 5.
So this is a
For demarcation. No, my lord. For demarcation of my land, unacquired land. Thereafter, my lord, the special land officer, by a letter being annexed to P5, my lord, they have said that the land has been already been handed over to the requiring body, being respondent number 3, the RTO, Purva Bardhaman. That's why, my lord, thereafter I again wrote a letter to representation to the RTO Purva Bardhaman, and after that, my lord, no response has been.
Where is your representation?
My lord, the representation, my letter of the special land officer is the P5, and my representation is page 29, P6.
This is not a representation, this is a demand.
That demand.
No representation.
No, my lord. I'm in this matter, my lord, for the state respondent, your lordship.
Yes.
He made a representation, this is an advocate letter, your lordship. The state has, the special land officer has requested us to make a representation before to approach the requiring body, Regional Transport Authority. So thereafter, we had approached the Regional Transport Authority on 29th of March. So till then, nothing has been communicated to us. No demarcation has also been made. And in the meantime, my land has been encroached.
Regional Transport Authority is being represented by? Should be Mr. Devra. Service made.
Purva Bardhaman.
Your lordship requested me.
So may I request you to please serve a copy of the writ petition to him, and please serve a complaint. Please file a representation before the authority. A demand of justice will not do, sir. Yes. Please file a representation before the authority. I'll direct the authority to consider within a stipulated time frame. Right? Affidavit of service. None appears for the. None appears for respondent numbers 2 and 3. Respite service. Paragraph, Mr. Devra is presenting for regularized code and public service direction. Paragraph, it is. Transmit. Paragraph, it is contended on behalf of the petitioners. Out of 9 decimals of land owned by the. Who is Annapurna Datta? Your predecessor?
Predecessor.
By the predecessor and interest of the petitioners, 7.5 decimals were acquired by the state. Stop. The local authorities of memory tried to encroach upon the unacquired portion of the property for which the petitioners approached the Special Land Acquisition Officer, Purbo Bardhaman, seeking demarcation of the acquired portion of the property. By a letter issued on 23rd December 2022, the Special Land Acquisition Officer, Purbo Bardhaman, requested the petitioners to contact the requiring body, being the Regional Transport Officer, Burdwan, for demarcation of the acquired area, since possession of the plot was delivered to the requiring body long ago. The petitioners seek to submit a comprehensive representation before the requiring body, being the third respondent.
Third respondent.
Being the third respondent herein, prays for a direction upon the said respondent to consider the representation.
Requiring body.
Third respondent.
Very fast, that's the right thing.
Paragraph. Upon consideration of the submission made on behalf of the parties, the writ petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the third respondent within 2 weeks. 2 weeks from date. The third respondent is directed to consider a dispose of the representation within 1 month. 1 month from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of which
I'm appearing on behalf of the petitioners. Filing affidavit service.
Respondents, Mr. Dev.
Respondent, Mr. Well, can you see the page number 18? I applied for grant of permanent stage carriage permit on the route Polerhat to Sambajar. Page number 18. At the bottom one, the receipt copy. But authority did not accept the application fees. So I requested the authority to accept my application fees. So that
Page
was
number 88.
page 18. 18.
Oh, yes.
This is the application. At the bottom, my lord, the application received on 10th May 2023.
Yes.
But fees was not accepted. If the application is not fees, that this is not the valid application. So I requested the authority to accept my application, page number 20, by representation. But that has not accepted. That I compelled to move a petition before your lordship, page number 21. Page number 21 and order, my lord, page number 22. My lord was pleased to direct the authority to consider to accept the application and to take decision according to law within prescribed time period 8 weeks within from the date of communication. Now, pursuant to the direction of this honorable court, I deposited the permit fees and also as per requirement authority, my lord, application form number 1 and class 3 timetable submitted. Thereafter, page number 27, my matter was placed before the RT board meeting, page number 27. And that board meeting was held on 2nd August 2023 at the left side, middle position. And decision was taken. Well, may I read, my lord? Yes. The case was taken up for hearing along with the service returns. Petitioner Sri Sambit Ghosh appear and file Hajira. It has been found that the petitioner Sri Sambit Ghosh submitted an application in form number 1 dated 5th May 2023, but it did not submit any other documents such as proper filled up application form number 1, but it is not the correct accepted authority. Route length, the two copy of photo, route map, class 3 timetable, number of trip, garage address proof, Aadhaar card, bank details and driving license of driver and income certificate. List was supplied to the petitioner. The decision regarding approval of route permit has to be taken by a quasi-judicial authority named RTA board through a RTA board meeting. Last RTA board meeting was held on 16 January 2023. Therefore, the allegation stated by the petitioner was incorrect. The applications not rejected till today. An objection was filed by Sri Nirmal Banerjee on 5th April 2023 for not to issue further permit in the manner. Who is Nirmal Banerjee? But that is disclosed. Identity has not been disclosed. He has no right. But as per the new act, the objection of the existing has been taken under the new act. He has no right. But who is Nirmal Banerjee? Not recorded. As per the direction of the Honorable High Court, Calcutta, next page, petitioner is requested to deposit the requisite fees for offer letter on the online portal along with all related documents immediately. The RTA board not 24 August will take decision on 8th August 2023 in the board meeting whether permit will be issued or not. If petitioner submit everything before it, or the matter will be board decided in next RTA board meeting. But before that, I deposited, except I have trust pledge. Now matter next page. Finally, the matter was placed before the RTA board meeting held on 22nd August 2023.
Yes.
Page number 20. Sambit Ghosh, my lord, name has been here.
3 grounds for rejection.
Yes, he has 3 grounds. College had always submitted. It is very relevant portion. Submitted form number 1, NOC from route secretary, Aadhaar card, class 3 timetable, everything. They got it. I submitted everything, all the documents. Submitted. Yes, my lord had got it. Now can you see the decision? Not submitted class 3 timetable. They have accepted my class 3 timetable.
What is with 16 numbers vehicles? What is that?
16
They're flying at present.
On this route, 60 numbers of vehicles are flying.
So you are supposed to submit class-free timetable of all those vehicles also?
Yes, they accepted the class 3 timetable.
That is only your vehicle. What about the others?
The other vehicles, my lord, what is the law? I have judgment. My lord, at a proposed time will be submitted. That will be approved for a limited period. If there is any objection comes, under section rule 100, that judgment must at least 2 court judgments I have. And next, NOC from Sambajar traffic guard, Kolkata Police, Kashipur, PS House, to be obtained. NOC is required from the police authority, but till date has not required. So before that, they have no right to reject my application. Secondly, thirdly, the route is overlapping the route number 211 of RTA Kolkata is mostly as reported by the existing operators of the state road. But 111, 211 is a separate road. The route is not from the flying by on the road. Haritola to Beleghata, Haritola to Patharghata, there is no connection of matter. This is existing road. There is no local standard. Because this the number of permit has been fixed on 211 under chapter 5. Number of limit of the limit has fixed. So one route has not been declared under chapter 6 in favor of the state transport undertaking. Because if any route is fixed under transport undertaking, no private operator can claim the permit. So all these 3 grounds are vague. Because I have submitted the class B timetable, proposed timetable, that will be accepted. If there is any class, then so at till date, before rejection, NOC has not been taken from the other traffic department, and so by the 211, no connection with it. So kindly set aside and direct the authority to revisit my application according to law.
What is the route of route number 211? Do you have the route?
Yes, I brought this. Not picture. I have brought this one. But this notification was issued under chapter 5 to fix the limit. But this notification was amended.
I would like to see route number 211.
11 at the last page number 39. and serial number 235, my lord has got it. Serial number 235, 211 route number, Haritola to Beleghata Pump, Haritola to Padarghata. As this is the number of permit has been fixed. But so the overlapping is concerned only for the if the route is, my lord, fixed, my lord, issued any notification under chapter 6 in favor of the state undertaking, but no private operator can claim the permit. It is a private operator.
Let us hear the state.
Revisit it. Our existing order no look standard to raise any objection.
Insofar as the rejection order is concerned, I'm not going to the earlier application invited. That chapter is over. Now, when a rejection is concerned, serial number 1, they fulfill the serial number 1 is concerned. Vehicle within superline, no class fee, no submitted. Not submitted class fee timetable.
The clash free
Class fee timetable is to be submitted.
It is submitted. Please see the previous column.
Class fee timetable.
Please see the previous column.
That is the main time, main thing. Serial number 2 is concerned, I some doubt regarding NOC from Sambaja traffic, and that is up to without obtaining NOC, how can they reject it?
Not only that, clash free timetable has been submitted. Please see the previous column. Just before this column. Document submitted.
Class fee submitted.
Same page.
Class fee
Previous
timetable,
column.
same page.
Fine. Same.
Submitted.
Operator.
Submitted.
Submitted. Class fee timetable.
The last is clash free timetable.
Directly
Point number 6.
revisit the issue.
Let this be set aside. It has to be.
Yes,
revisited.
I agree.
Because I am minded regarding NOC is concerned. Unless the NOC is getting NOC or refusing from the police
And
side,
route
how can
number 211 is
The
also
secretary will issue the memo requesting.
No, I have not. Then regarding 211 is the existing operator, they have no right
No right.
to challenge. That is, I have not. When class fee is a vital and police no objection.
Clash free is already there.
Yes.
Affidavit of service. The resolution taken by the RTA board in its meeting held on 22nd August 2023, rejecting the request of the petitioner for grant of permit is assembled in the resolution. The petitioner pursuant to an earlier order of this court passed on 26th June 2023 in WPA 12910 of 2023, 2023, deven na? Directing the authorities to accept the prescribed fees to be deposited by the petitioner within 2 weeks from the date of order and to consider the application filed by the petitioner for issuance of permit, the concerned authority took up the application filed by the petitioner for consideration and rejected the same by the order impugned. Stop. The application of the petitioner was rejected on threefold grounds, : Number one, not submitted clash-free timetable, clash-free, CLSH, clash-free timetable with existing 16 numbers vehicles which are plying at present. Next line, number 2. NOC from Shambhajar Traffic Guard, Kolkata Police and Kashipur PS, South 24 Parganas to be obtained due to traffic congestion observed at starting and terminating point. And number 3, the route is overlapping with the route 211 of RTA, Kolkata, in mostly as reported by existing operators of the said route. Stop, inverted comma closed. Paragraph. The resolution demonstrates that clash-free timetable has been submitted by the petitioner before the authority. Stop. Though the authority has held that NOC was required from Shambhajar Traffic Guard, Kolkata Police and Kashipur PS, South 24 Parganas, in order to consider the application of the petitioner, the application was rejected without receiving any response from the said authorities. Also, it prima facie appears that route number 211 covering an area between Ahiri Tola to Beliaghata Pump and Ahiri Tola to Pathorghata does not overlap with the route applied for by the petitioner. Stop. Objection raised by existing operators is also not enjoined in law. Paragraph, in view of the above, this court is inclined to hold that the resolution dated 22nd August 2023, insofar as the application of the petitioner is concerned, is required to be set aside. Paragraph. Accordingly, the resolution 22nd August 2023 passed by the RTA board in its rejecting the application of the petitioner is set aside. Paragraph. The
Meeting dated 22nd August.
22nd August 2023. Yes. Paragraph. The RTA board being the respondent number.
Respondent number 2. Respondent 2.
Being the second respondent herein, is directed to set aside. Foreign line. Set aside insofar as insofar as the application set aside insofar as the application of the petitioner is concerned. The RTA board, being the second respondent herein, is directed to reconsider the application filed by the petitioner in the light of the observation made in this order and take a reasoned resolution within 6 weeks. Within 6 weeks from the date of this order. You need a hearing?
After giving hearing. Yeah, after giving hearing.
Granting reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
But within 1 week, communication. Fine, deeply obliged. Or next matter also same. Same resolution, same route, everything is same. Mr. Devra is applying. नहीं हम आपने कॉपी दे दीजिए.
Let me call.
Yes, sir.
Where is your service?
Yes, absolutely.
Next matter, oh, it's time.
589.
Civil service. GP office copy service release. On page number 18. Same route, Malo, Polera to Sambaja.
Appearing.
Yes.
Mr. Devra, you're appearing? No. May I request you?
Yes, I said the copy.
Problem?
Yeah, certainly. And resolution also same.
None appears for the
Resolution page number 30.
service. Mr. Devra, service regularized, copy service and direction. Resolution?
30, page number 30.
The earlier order of this court?
Yes, sir. Earlier, my lord, page number
23.
Yes, ma'am, 23.
Earlier order passed on 26.
Yes, 23. Yes, 23 and 30.
12917. 12917. 12917. Resolution?
Is it on page number 30? 30 serial number.
Same date.
Serial number 4. 4 continuation, page number 31.
Suman Ghosh.
Yes, sir.
Same. Yes.
Next matter also same.
So same.
Last, only 3 minutes.
Yes,
I copy this.
Same.
Oh,
Same resolution?
Same resolution.
590.
Last matter.
Same resolution. Same page number 18. Page number 18, my lord, application in page type form. And order of the court, my lord, page number 23, and resolution 30. Page number 30.
Order of the court. Affidavit of service.
Page 30, share number 3.
Number change. 26 June 2020.
100%.
WPA 12915. 915. 12915 of 2023. The same resolution?
It's the same thing. Page number 30, same.
Yes, 600.
It would be kind interest to mention one matter, urgent matter of Honorable Justice Shampar Sarkar.
This is not the
1032.
600.
I am for the
This is my certified affidavit of service matter. The application for extension of interim order has been served. It has been postal report matter. It has been delivered. Malad suit for declarance of right title, interest, and injunction. Malad considering a Supreme Court decision of the relating to Malad Court Fees Act.
Extended for a limited
Yes,
period.
yes. Malad last occasion it was extended on
30th September.
yes, on June it was extended Malad till September.
This will be in January.
No, January Malad only 1 week
Not
is
the regular bench.
at least Malad till February.
I am not the regular bench. Sir.
Second week of February, Malad at least till second week of February. Otherwise, next week, Malad, 23rd, 26th are holidays.
Sorry for
No.
Affidavit of service. Where is the service? This is
Malad,
the
postal
track
report is there. Malad, postal report is there. Last page, Malad, postal report is there.
That is postal receipt, the track
No,
report.
yes, yes. Below that, my lord. Delivered.
Service, none appears for the respondents. Paragraph interim order granted earlier is extended till 29th February.
Ma'am,
Or
I'm-
until further notice. Paragraph the matter in case with Next.
Punjab power
Can to লিখতে হবে না yes next can to লিখতে হবে next
Is not, when I appear for the plaintiff petition, extension of interim order, and I have served notice, my lord. The lordship sees the last order, and I have served notice, my lord. Upon, my lord. The lordship sees last occasion, Justice Patnaik, my lord, extended the order. 16 May. He was Justice.
Have you filed an application for can?
No. No case
Can?
happened.
It's not there any longer.
Pardon, my lord?
It was extended till July.
July, yes, my lord.
After that,
But thereafter, I tried to mention, my lord, the lordship directed, it was not listed. It was pending.
come with a can application, sir. I'm sorry.
And
It is
your
not
last,
existing
your
anymore.
lordship sees the last order, that was also after expiry, you were extended.
Maybe, but I will not consider. You have to come back with an application. Please file an application.
And your lordship can reimpose the interim order and
Not without an application. File an application, serve it and come.
need to follow these practices.
Since the interim order granted earlier has expired in the last week of July 2023. No further order. Next. Next. 602.
Lord, I beg to appear on behalf of the petitioner, my lord. The defendant number 1 petitioner. My lord, the interim order granted, my lord, while the plaintiff fixed a demeanor application under Order 7, Rule 11, which was turned down. In presence of the plaintiff, my lord, the interim order initially passed and extended from time to time. And the last extension was up to, my lord, 31st of December. My lord, immediately thereafter, my lord, since the regular bench, my lord, was not available, my lord, the matter is being mentioned before your lordship, citing, my lord, the ground of urgency for extension.
The regular bench was available after 31st
But
December.
31st December, immediately thereafter, the matter when mentioned before the regular bench. But your lordship knows, my lord, the
This is last week of July. Where is the next? Oh,
no, my lord,
31st
thereafter it was extended. 31st of December. Extend, my lord, for the
It
time
was
being, my lord.
extended. I am for the opposite party almost 6 and 7. When
Let there be a limited extension.
extended, my lord, while fixed a short date, my lord. Because if your lordship kindly see the last order, it was in fixed because continuously extension has
Yes,
been
yes, my
done.
lord, it's not that, but I want to also hear out the
Learned
matter.
counsels for the parties. Paragraph, the interim order granted earlier is extended till 31st January.
As your lordship please,
31st
but
January 2024 or further order.
wait.
Next.
I am for the respondent opposite party, man. Well, the interim order expired 1 year back, my lord. The last occasion where the matter was taken up, my lord, there is no extension of interim order, my lord. Matter was fixed by the regular bench for, my lord, final disposal.
My lord, despite my lord serving, my lord, I have served the notice. The extension is filed within time. This
Give me a minute, please.
my-
I'll just take the file.
2472
ও উইথ আছে 961 এনো দিদি এনো এই যে
Mal, kindly look when the extension was expired, Mal.
Can you see when extension has been filed?
Where is your application? Your file a separate application for extension?
My lord. That I
Where
have
is it?
filed, that is can number 4 of 2023.
Mal, 2022 is served upon us, 2023 is not served upon us.
Well, everything has been served. Kindly
Kindly show me the service.
File also.
It is 2022. You have served me 2022.
Can 4 of 2023 are also finding in the
No, my lord,
appearing in the list also.
File, can name on the-
2022 has been served upon us, 4 of 2022.
Can 4 of 2023 is not in the file, sir. I cannot pass an order. File name.
Appearing in the list. That is
The list has not been sent to this court.
Who is the current? Or respondent? Opposite Parit
Not
1.
listed from the application also.
No, my lord, use not.
It was fixed on the 18th. The honorable court is not going to sit on the 18th because
13th October itself, it was not extended.
Yes, my
it
lord.
was fixed to 18th. So till 18th, we need an extension of interim order.
Interim order was till January, third week of January 2023.
Yes.
So we are in the third week of January
But
2024.
within time my extension was filed, it was submitted on their behalf. They want to do the hearing of the matter.
Yes.
Accordingly, the matter was fixed in this month on 18th. Other honorable bench is not sitting on 18th. It is COD. So my lord, my extension interim order for limited period because I filed interim application.
There is no order at all, cannot be
But
extended.
within time I have
And
filed.
application is also not, in the file.
That is not my fault, my lord. I have submitted. My
The matter says affidavit of service.
lord, may I take that? Because their allegation is that I am not serving on them.
They served a can 4 of 2022.
Take this one.
My,
Amlan?
Huh?
To the company. The matter is placed before the regulator.
my.
Deeply obliged.
Only need to observe that file was not found, my lord, because I have mentioned after finding that everything is in order. my lord.
Can
It's
4 of
appearing in the list, but it is not found in the
4
file.
of
It's not filed.
4, but we have
Can-
served 4 of 2022.
Can 4 of
Can
2023.
4 of 2023 is not in the file.
And my lord, the extension file expired in the month of third week of January 2023, my lord, 1 year back.
The regular basis.
Deeply obliged.
Already uploaded 600. My lord, application is not available. May I give my copy to the for record?
Amlan?
It's a copy.
Original.
600 is the
Copy of the. Original application is not in the file. By the applicant petitioner. Be treated as.
1890.
Yes, 605.
605.
Interim order till 31st January. It may be
You are
extended.
against?
I am appearing on behalf of the respondents in this matter. Yes. Huh? Yes. মানে? বুঝতে পারলাম না। ভালো বাবা, আমি চলো বুঝে যাচ্ছি। ও।
Extend, limited extension,
Yes.
31st January.
No, but up to February.
No, no.
Otherwise, this file will go to the again there. This will be fixed up to February.
Advance.
Hello, my lord. Your lordship can do it.
You can ask me if I got it.
Or you can do file নিজে তো জীবন বেরিয়ে যাবে। So enjoying the interim order more the merrier for you.
Or learned counsels for the parties. Paragraph, the interim order granted earlier is extended till 31st January 2024 or further of this, whichever is earlier.
31st January.
Matter be placed before the regulator.
Well, some Again, some more day, some more day. Otherwise, this file cannot be brought from. No, but if my asks for extension of entry order, then I will request him to deposit the money with us. With the register application.
Back by then.
Yes, yes.
Next up, next.
Lordship.
600K.
May I please your lordship, my lord? My lord, before my lord lordship goes to the order impugned under challenge, my lord, may I please, my lord, why I am before your lordship? My lord?
For the respondent.
My, this is a no caveat matter. What happened, my lord, September 2023, 13th September, I filed a suit against the opposite parties. They are the defendants, my lord. They tried to oust me, my lord. I am doing my business from the suit premises. Now, my lord, an order of injunction was passed. If your lordship kindly comes to page 52 once, my lord. The certified copy, my lord, of that order, my lord, I have annexed. Page 52. Now, my lord, I will not trouble your lordship by reading that entire order. My lord, if your lordship kindly comes to page 55.
51.
55, running page 55. The ordering part, my lord.
Yes.
The prayer for ad interim injunction is allowed at this stage. The defendants and their main agents and associates are restrained from dispossessing the plaintiff from his peaceful possession of the suit premises and also from blocking the free ingress and egress of the plaintiff to and from the suit premises until next stage. So I got the order of injunction. One moment I got it, my lord, I communicated to them. Now, my lord, everything was going well. Even I communicated to the local police station, my lord. My communication is at page 61, my lord, if your lordship kindly comes once. Well, that is the compliance which is required, my lord, immediately after getting the order of injunction, and I did it, my lord. This is the letter, my lord, by communicating the order of injunction, enclosing the plaint and the injunction application. Next page is the affidavit of service, which I filed before the court below, the registry receipt next page, and the very next page, 64, is the track report that they got it. Now, my lord, what they started, my lord, from the end week of November, they again started threatening me for disposition. They did not go to court on the date of appearance, my lord. They did not appear there. The interim order which I got is still 12th of February, 2024. So, my lord, I informed the local police station by writing a letter. Those letters I have annexed that I have an order of injunction. Police did not take any steps. They say you have to go to civil court for direction upon us. No, my lord, order 39 rule 2, I can understand, my lord, that is a cumbersome process. If my possession goes, my lord, where will I stand? Because, my lord, my possession was, my lord, protected by an order of injunction. So, my lord, what I did, my lord, if your lordship kindly comes to page 57, I took out an application under section 151.
Yes.
Now, my lord, if your lordship kindly comes, my lord, to paragraph 7 and 8 at page 58. Those are the relevant paragraphs. Police assistance. Only, my lord, what was my prayer? If your lordship kindly comes to page 59. Yes. Very innocuous prayer. In this circumstance, it is therefore most respected that did your honor make graciously pleased to pass an order, they were directing the OC Maniktala to ensure that the order of injunction is complied with. Now, my lord, under section 151, my lord, I have, my lord, I can, my lord. Rather, I can, my lord, file such application before the court below. If your lordship kindly takes up 151 once.
This
that is the inherent power of the court. It says
this application has been rejected.
No, my lord. That is why I've come. If it had been rejected, I could have understood. I moved it by way of a put-up application for urgent basis. The learned judge took the matter, heard the matter. Now, if your lordship kindly comes to the order impugned. It's a very strange order, my lord.
Where is the order?
My lord, the certified copy, my lord, is attached with this application, my lord. Order dated 11th of December. Record is put up today on the strength of put up petition filed by the plaintiff. Put up is allowed. My put up was allowed. Matter was heard. Plaintiff filed the petition supported by affidavit and praying for necessary order for direction upon such and such Manik Talapi to ensure that the order of injunction passed by the court stated therein. Incident period is taken up for hearing. Heard. The learned judge hears the application. Submission of the learned advocate for the put up with the record on 12th February.
Yes, what is wrong with the order?
My lord, if it is, I can understand. In the meantime, my lord, if that direction is not given to the police and if I am, my lord, every day such threat is coming. Every day. In case, my lordship will kindly gauge the situation, my lord. If I am dispossessed, I have, my lord, order 39 rule 2A, my lord, by suit property goes. Lordship will kindly gauge the situation, my lord.
There has been no direction for service of notice upon the other side.
My lord, the learned judge hears, my lord. It is the
Other side has appeared in the suit.
no, my lord. They haven't.
They've not appeared in the
No,
suit.
my lord. And what I am praying, my lord, I asking this question to myself only to ensure, that's all. No further direction. The order of injunction is already subsisting. In case, my lord, Lordship will kindly gauge the situation. If my possession goes, I've been protected by the court below. But, my lord, the defendants are not ready, my lord, to honor that order. Every day are threatening me, my lord. Even during the pendency of this, my lord, I had to again file an application, complaint before the police, but I cannot annex this because by the time this was done, this application was already filed. My prayer is very innocuous, my lord. Only to ensure. That's all. Nothing more, nothing less, because the order of injunction is subsisting. Now, my lord, if I place section 151, why I have come under section 151? It says nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice, my lord, now, my lord, or to prevent abuse of the process of the court. My lord, in case if my possession goes, it will be a total abuse of the process of the court. That order of injunction, the suit, my lord, everything will be rendered infructuous. Lordship knows, my lord, injunction is everything. It's a suit for possession.
Let the learned court take up the matter earlier.
In the meantime, my lord, till 12th, Lordship will kindly direct. Till 12th, my lord. I'm not saying, my lord, Lordship will dispose of this application by direct, but till 12th. Let the learned judge consider, my lord, on 12th of February. In the meantime, my lord, till 12th, my lord, let the, my lord, local, my lord, PS, my lord, ensure that this order of injunction dated 13th September 2023, passed in this suit, is complied by the defendant. That's all, my lord. My lord, I will be, my lord, this will be a console. At least I am protected.
That will amount to disposal of the writ petition itself, isn't it? The revision.
No, my lord, I tell you, Lordship, my lord, under Article 227, Lordship's hands are very wide. Now, Lordship will kindly consider the situation.
Trial court to dispose of your
Lordship, my lord, I bow down, my lord. But in the meantime, if this, in the Lordship will, my lord.
An earlier date, sir. I'll ask the trial court not to wait till February 12th. Let the trial court consider trial.
কিন্তু পজিশনটা চলে গেলে কি হবে? কালকেই তো ইম্পোর্টমেন্ট দিয়ে
Since no caveat has been filed, comma, heard learned counsel for the heard learned counsel for the defense. Paragraph. The petitioner has assailed the order passed by the learned civil judge within bracket junior division, comma, second court, comma, Shialda on 11th December 2023 in title suit number 337 of 2023, fixing the date for hearing on 12th February 2024. The petitioner filed a suit being title suit 337 of 2023 before the said court. And filed an application under order 39, rule 1 and 2, read with section 1 of the Code of Civil Procedure. Stop. By an order passed on 13th September 2023, comma, prayer for ad interim injunction was allowed, restraining the defendants therein from dispossessing the plaintiff/petitioner from his peaceful possession of the suit premises, and also from blocking the free egress and ingress, and also from blocking his free egress and ingress from and to the suit premises till the adjourned date.
Mala only Lordship will
What
record that
was the adjourned date?
Mala adjourned date was
The
20
next date.
Mala 24th of November 2023.
After that?
It was extended till 12th of February 2020. If your Lordship kindly comes to
Where is that
paragraph 13, my Lord, I have stated that. Paragraph 13 of my application, Mala.
The said order was extended from time to time
Only once it has been extended.
and is in operation till 12th February 2024. Stop for paragraph. Learned Counsel for the Growth has advised that since the defendants, the respondents hearing
Mala, the respondents hearing, Mala.
/ respondents, comma, in violation of the said order, comma, are trying to dispossess the petitioner
And block my ingress egress also.
from the premises in question. Block his egress and ingress. The petitioner filed an application under section 151 of the Code of Civil Procedure before the Learned Trial Court, seeking direction for police assistance in order to ensure strict compliance of the order by the defendants. By the order impugned, comma, now, the Learned Trial Court has fixed the matter for hearing on 12th February 2024. The petitioner apprehends that he may be dispossessed from the premises in question before the said date. Upon consideration of the submission made on behalf of the petitioner, comma, this court is of the prima facie view that the petitioner has made out an arguable case. The petitioner is directed to serve copy of the application along with annexure thereto upon the respondents and file affidavit of service on the adjourned date. Paragraph. The who is the authority to
Mala, the officer, Mala, the court.
the police authority
Mala, the officer in charge, Maniktala police station.
has been impleted?
No, Mala, he's not a party, Mala. He cannot be, Mala, in a suit, Mala.
It's Maniktala PS.
Maniktala, yes.
The officer in charge, comma, Maniktala PS, is directed to ensure strict compliance of the order.
Order dated, Mala, 13th September 2023.
Passed by the order of administrative injunction passed by the Learned Trial Court on 13th September 2023 till the application under section 151 of the CPC is disposed of by the Learned Court. Paragraph, the matter is be placed before the regular bench. Next.
Mala, Lordship has directed me to serve, Mala, the respondents, Mala, the copy of this application or Mala, the 151 application.
No, not 151.
This application. This application. Lordship has kept this matter pending. Mala.
Placed before the regular bench.
Mala. In the meantime, the OC has been directed, Mala. I'm extremely grateful.
The matter is disposed of by the.
I have understood, Mala. I have understood, Mala. I'm extremely grateful to your Lordship.
Next. 607 website.
Well, I'm for the defendant petitioner. Well, your lordship will straightway comes to page 9. That is a deed of lease, my lord, executed by O'Neill, Milon, and Prabhas. Against whom, my lord? Against one, Borjahan Sheikh and Anil Kumar Boydto. My lord, this Borjahan Sheikh, a lease was given to run a brickfield business. Subsequently, my lord, all the leaseholders, my lord, sold the case plot to my client, that is Borjahan Sheikh. And the railway registered deeds. Well, he is running the brickfield as per, because he is the owner. Well, kindly see all the fees have been deposited, necessary fees. That is, I'm not going to all the documents, but page 42, your lordship will kindly see that land and land reforms e-challan, and also, my lord, page 44, that is the tax receipt granted by the Kulpi Gram Panchayat. And also, my lord, kindly see the government has taken money. Kindly see page 46, Juhu's brickfield, Borjahan Sheikh, BLO Kulpi, he has given permission for for CFT art. Well, all these documents are there. But what thereafter what happens, my lord, all the varied documents, but the plaintiff file a suit. In that suit, my lord, I am not served with a copy of the plaint, but anything, but only kindly see page 62, kindly see only a one-page order from the appeal court. After getting this, well, we went to the trial court and obtained the certified copy. This is the order, just type copy of the, not in the form, page 62. Ostain Ishadaka, kindly see Miss Appeal 41 and 23. Only this single page. Now we went to the trial court. But from the trial court, well, we got the order, that is page 65. Page 65. This is the trial court order. But no caveat has been lodged, and it appears from the Sherestadar, learned advocate of plaintiff has moved the prayer for identity order of injunction. Issue notice upon the defendant, that is my client petitioner, directing him to show cause within 10 days from the date of the receipt of this notice as to why the prayer for plaintiff for temporary injunction shall not be allowed. Heard the submission, peruse the injunction application supported by an affidavit, plaint, and the documents. This is a suit for declaration. For the first time, we came to know the case of the plaintiff is that he took lease in respect of the scheduled suit property, and he was running the Kulpi brick manufacture upon it. Subsequently, he gave lease of the suit property to the defendant to run the said brickfield. It was moved that that after expiration of the said lease agreement, the defendant handed over the possession to the suit property to the plaintiff. Subsequently, the defendant started to create disturbance in the peaceful possession of the plaintiff in respect of the suit property. And it has been alleged that the defendant forcefully tried to remove the materials from the suit property. On perusal of the materials on record, it appears before me that the plaintiff has failed to establish prima facie case. Considering the nature of the suit, it appears that for proper adjudication of the matter in dispute, both the parties are to be heard, and if any order is passed without giving the defendant an opportunity of being heard, then he will be highly prejudiced by such order. Hence, the prayer for ad interim order of injunction has been refused. Now, your lordship will kindly see page order number 3. Today, the plaintiff filed a petition for local inspection. The learned advocate moved the petition. It has been stated in the petition that during the pendency of this suit, the defendant has been trying to change the nature and character of the suit property. Under such circumstances, it has been prayed to appoint advocate commissioner for bringing the actual picture of the suit property before the learned court. Hard considered, on perusal of the materials on record, I find no reason to allow the prayer of the petitioner at this stage without giving the defendants an opportunity of being heard. According to the petition, that dismissed. Matter is there. Therefore, the trial court found that I should be given an opportunity of being heard. And he also filed a petition, the plaintiff, for local inspection, but that has also been rejected to bring out the true picture. Now, your lordship will kindly see the order, this order number 2, my lord, has been challenged. My lord, reverse it without giving an opportunity, and limited extension of interim order injunction that has been extended, my lord, on 4th March 2024 on instruction. My lord, I am saying before, my lord.
It is extended till 4th March.
My lord.
What is your urgency, sir?
Urgency, my lord, by virtue of this injunction order, my lord, my brickfield has been closed because they have moved before the police authorities and police are not allowing us to run the brickfield business. That is the urgency, my lord. I disturb your lordship from Monday. That is the urgency, my lord.
Please serve and come back because I don't think an interim order is necessary.
Interim order, my lord, stay for a limited period. No limit, because my lord,
Without service of notice to the other side.
my lord, kindly say I have also showed the documents. Another thing, my lord, that provision has not been complied with. My lord, I have stated on oath before the my lord, before this in case that no copy of the injunction application, no documents, nothing has been served, only this notice. That is page 62.
That would fall with you, sir.
For
Not come to the writ court
but-
for every single reason.
but kindly stay for a limited period. I'm
Serve and come back cannot be stayed on this ground.
at least for a limited period, my lord, because I have shown, my lord, all the relevant documents to show I am in possession. No caveat, my lord. Trial court specifically found, my lord, that order of injunction cannot be granted without hearing us.
Were beyond your, both were at the interim stage without hearing you. Both.
My lord.
The first order went in your favor, so you are not aggrieved. Second order,
Now,
same footing.
So for 3, my lord, order number 3, where local inspection has been made, even that petition has been rejected. How the appellate court?
Time being, the court said they want, you should be heard before any order is passed. Please serve and come back. I don't think there is any urgency.
Then short date, my lord, maybe.
Regular bench. The order passed by the learned additional district judge, Diamond Harbour, South 24 Parganas on 8th December 2023 is essayed in the additional application. On the interim order of injunction granted by the said court has been extended till 4th March 2024, as submitted by learned counsel for the petition. Paragraph. Upon consideration of the submission made by the petitioner, this court is inclined to hold that the petitioner has an arguable case. Paragraph, the petitioner is directed to serve notice upon the respondent. Serve a copy of the application upon the respondent along with annexure thereto. Copy of the application along with annexure thereto upon the respondent. And file affidavit of service on the adjourned date. Paragraph, the matter be placed before the regular bench.
Regular bench or can you mention a date, my lord?
Yes.
Matter will appear 1 week hence.
Regular bench. I cannot fix a date before the regular bench. Next matter.
The impugned order has been passed by the Liner Trial Court.
Saturday.
I appear for the respondent, a copy be served on me. There is no caveat, my lord. If my lord so directs, I'll serve. And my lord, matter be fixed day after tomorrow. My lord, tomorrow I've got some.
There is no urgency, Your Lordship.
No, there is urgency, my lord. For that reason, my lord, I've made my matter was upgraded. Lord, may I submit, my lord? My lord, the urgency is that in the Order 9, Rule 13 proceeding initiated by the opposite party number 1 and 2, who are the judgment daters, the petitioners who had stepped into the shoes of the decree holders by order dated 21st June 23 passed by the Learned Trial Court, application under section 33, read with section 35 of the Stamp Act, read with section 49 of the Registration Act was filed for the reason that the opposite party number 1 and 2 had tendered several title documents which were neither stamped, neither registered. These facts were duly admitted by the opposite party number 1 and 2.
The documents.
For the impounding of the documents, my lord, next date has been fixed on 28th for final hearing, my lord. And these documents, my lord, were being admitted, my lord, in evidence. But if that be so, my lord, the right of the petitioner
Documents have already been admitted in
My lord,
evidence.
my lord, subject to objection, my lord, these documents were exhibited. My lord, in divorce the provision of section 33 read with section 35 of the Indian Stamp Act. If my lord so permits, can I place the provisions, my lord?
No, the law is clear, but then there is no urgency, sir.
No,
It
these
has
are-
already been exhibited, admitted in
Subject to
evidence.
objection, my lord, in my deepest of my lord, submission, my lord, when the objection with regard to the stamp duty is being raised, in terms of section 33, these documents are to be impounded and have to be sent to the collector.
Can wait till the arrival of the regular bench.
My
That
lord,
is one.
my lord, but
This can wait
limited
till
stay I am praying because my matter is fixed on 20th, my lord.
proceed. There is no difficulty.
My lord, then the learned trial court will be looking into these documents, which are neither stamped nor registered. That will
Exhibited, sir, you say.
subject to objections, my lord.
So there is no difficulty in proceeding with the matter.
My lord,
Evidence.
my lord,
The trial court proceed.
No,
They
in
can
the-
come up before this honorable court at any stage after any order is passed.
My lord,
It is agreed, principal agreed.
my lord, my lord, only 1 minute, my lord. Now, since the date has been fixed for final hearing, my lord, these documents, though challenged by presenting an application, will be looked into by the trial court, my lord. Though cannot be looked into in terms of section 33 and 35.
Merits at all. I am on the urgency of the matter. It's not that urgent that it has to be taken up.
I am just only humbly praying that operation of the order be stayed.
The opposite parties are.
Then one indulgence can I pray, my lord? My lord, one indulgence, my lord. My lord, only any order passed by the learned trial court shall abide by the result of this revisional application.
Ask any order at all, sir. Please serve. Let the regular bench come. Move.
The regular bench will be
No,
sitting
then
from
they
next
will be
week.
taking.
He
my
can
lord,
move the
my lord,
regular bench.
they will be taking plea before the learned trial court that there is no stay passed by the Honorable High Court, my lord.
No stay passed.
My lord,
Benjamin for the regular bench. The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the agenda.
opposite party number 1, 2, 3, my lord. Only 1, 2, 3 are contesting. 4 and 5 are the pro.
I appear for respondent numbers 1, opposite party numbers 1, 2, and 3.
1, 2, 3. Oh, they are pro forma.
Perform opposite parties, my lord.
2 and 3. Pro forma. This one number, opposite party numbers 1, 2, and 3. Paragraph, the matter will be placed before the regular bench.
My lord, grateful.
Your Lordship,
Next.
one matter, item number 637, relating to the same set of parties that was appearing.
Grateful.
609.
But I pay for the. My lord, the son is a psychiatric patient. My lord, he got married in 2008.
No caveat.
No caveat. Now, my lord, in 2011, there was, my lord, his wife was subjected to torture, my lord, by the parents-in-law. Now, my lord, she lost a 498. Now, kindly comes to page 46 of my application. My lord, that ended in a joint compromise in which, my lord, the parents-in-law agreed to bring back the son and the daughter-in-law home, and the proceeding was quashed by this honorable court. My lord, page 46. My lord, this is the order passed, my lord, by my lord Justice Shivakant Prasad, as his lordship then was, but quashing the proceedings on the account of compromise. Now, my lord, in that order, my lord, the parents-in-law admit that the son and daughter-in-law are back in home. My lord, thereafter, the father-in-law lodges a complaint before the sub-divisional officer Kollani. My lord, the SDO, my lord, kindly comes to the order impugned, directs eviction of the son and the wife. Now, my lord, my point is, my lord, whether under the Maintenance and Welfare of Parents and Senior Citizens Act, if the father has not claimed for maintenance, because if your lordship sees the order passed by the SDO, the impugned order, my lord, it's the original certified copy. Now, my lord, kindly comes to the second paragraph. During hearing, it was known that the petitioner and the opposite party resides in the same house. The petitioners didn't claim maintenance. Now, my lord, they only prayed for eviction. Now, my lord, whether under this Act of 2007, the SDO has the power to pass an order of eviction. Now, my lord, this honorable court, my lord, had the occasion to go through this issue. My lord, the first, my lord, kindly has a look at this order passed by my lord Justice Shobboshachi Bhattacharya, in which it has been held that the sub-divisional officer under this act has no power to pass an order of
The
eviction.
baby is born.
My lord, the baby is born.
No urgency.
But kindly, my lord, the only urgency is, my lord, the
Undertaking before the court that you leave the house after the baby is born.
the only thing is, my lord, my lord, the father-in-law, my lord, he has filed a writ petition praying for execution of that order. But if the authority, the SDO, does not have jurisdiction even to pass an order, well, the order by itself is a void order. Kindly as a look at the order, copy that. Well, it has been held that the SDO has no authority to pass an order of eviction. But even if I give an undertaking, my lord, that does not suffice. Because the SDO could not have passed this order. And my lord, the order in that matter, my lord, directing eviction was set aside. But the other conditions were kept the same. Only the order of eviction is set aside. Because my lord, in terms of the act of
This side has not appeared. Let this be stayed for a limited.
lordship.
An order passed by the, since no caveat to me. An order passed by the subdivisional officer.
But he is the tribunal under the act.
Comma, President, comma, Maintenance Tribunal for Kullani, comma, Nodia, under the Maintenance and Welfare of Parents and Senior Citizens Act 2007, on 2nd June 2022, is assailed in the application. Stop. Paragraph, learned counsel for the petitioner. The single petitioner.
There are petitioners. There are two petitioners, the son and the daughter.
Petitioners, son and the wife.
And the wife.
Petitioners submits that the subdivision officer had no authority to direct eviction of the petitioners from the property in question in an order passed under the Act of 2007. Paragraph. Upon hearing learned counsel for the petitioners, comma, this court is of the view that the petitioners have been able to make out an arguable case. Paragraph. The petitioners are directed to serve copy of the application along with annexure thereto upon the respondents and file affidavit of service on the adjourned date. Paragraph. Since legality and propriety of the order dated 2nd June 2022 is under challenge, comma, the said order be stayed till 29th February.
Grateful.
Paragraph, the matter is
Regular bench.
next.
In this matter, I have instruction to appear for opposite party, my lord. I filed Vagadatam with the department in course of the day, my lord. Kindly direct my learned senior friend to serve a copy, my lord.
Yes.
I have the petitioner, defendant petitioner, to serve a copy and come back.
And come back, please. The opposite parties are represented. Opposite party number
All opposite party, one.
The opposite party is represented. Huh? Paragraph, the petitioners are directed to serve copy of the application along with annexure thereto upon the opposite party and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the regular bench.
Returnable on date.
Regular bench.
The difficulty is, we mentioned this matter because the trial court is not granting adjournment. Matter has been fixed on ex parte board. This order is my petition for taking the matter off the ex parte board has been.
The next date is 15th of February, my lord.
Maybe, but yeah.
Back by then.
Appearing before your lordship, my lord.
February, next day.
Tomorrow, can I take up tomorrow? I'll serve a copy today.
It's 15th February. The
True,
regular
Lord,
bench
but-
will be back by then. You can mention before the regular bench. Next,
If you-
not prior to 20 seconds.
I lost my chance. Anyway.
Well, may it be in the regular bench. May it be in the regular bench. Yes.
I am
I am
opposite this application.
in the regular.
Yes, I am.
You have received copy?
Yes, I am on caveat, my lord. Copy has been served upon me.
The matter be placed before the regular bench.
Grateful.
Next.
Please, Your Lordship. কোনটা আছে? Now, there are two matters. Your Lordship is taking CO number 97.
CO number 97.
Yes. My Lord, 97, that. My Lord, kindly have a look at the order, my Lord,
There is
passed.
caveat?
There is no caveat, my Lord.
There
It's
is a caveat note in these applications I do not find.
At the back, my lord.
at the back. Backside, Lordship.
Back, my lord, there's an endorsement from the advocate on record, my lord, no caveat.
The department doesn't endorse.
And after that, the department used to
Accepts. Accepts.
Yes,
But
carry on.
kindly have a look at this is an order passed by the arbitral tribunal. Lordship knows, my Lord, the issue regarding the jurisdiction, my Lord, can be raised in section 11 stage. If I don't, it's not a dead duck. I'm not a section 16 stage. If I even don't do there, it's a section 34 stage. These are the three stages. Now, 11 stage, my Lord, it was not disputed. I'll be very candid to me, Your Lordship. Now, my Lord, in the section 16 stage, this was, my Lord, brought to the notice of the learned arbitrator. Lordship will find the impugned order of the learned arbitrator, which is, my Lord, page 24 of your Lordship's brief of CO 97. Why, my Lord? Something is, my Lord, courts have held, my Lord, that if there is a clause like may go to arbitration, can go to arbitration, then, my Lord, after you file a defense, naturally you cannot do that. But if there is no clause at all, then that point, my Lord, it's become, my Lord, a quorum non juris, my Lord. Kindly have a look at the clause at page 25.
Page
25 of your Lordship's brief. Heading is only arbitration. Look at the clause. Jurisdiction for any arbitration matter is limited to Kolkata. This is forum selection. Like anything to do with us, it has to be filed ABC laminate. It can be Bombay, Nallur, Salem. All legal disputes, if arises, will be limited to Kolkata jurisdiction only. And in case of any litigation under this contract, the courts of law in the city of Kolkata shall only have jurisdiction. This is the only clause. There is no arbitration clause. Now, my Lord, the heading, if a clause has a heading arbitration, it doesn't make it an arbitration clause. Judgment adopted. This is, my Lord, held, my Lord, by the Delhi High Court judgment, my Lord, 2022, SCC online.
First line says the jurisdiction for any arbitration is limited to Kolkata.
Where is the clause? The arbitration clause is section 7. Any disputes and differences by and between the parties shall be settled in arbitration. Where is that, my Lord? Kindly have a look at, my Lord. Kindly take page 19 of the agreement. Page 35, Lordship takes the clause itself. Page 35, forming parts of special conditions of contract. Page 35, arbitration, jurisdiction for arbitration limited to Kolkata. First, there should be a clause. Then, in case of any dispute, limited to Kolkata jurisdiction. In case of any litigation under this contract, 14.
It's recorded there.
Yes, the same thing. So, my Lord, there is no arbitration clause. Delhi High Court is judgmental. In fact, my Lord, the Honorable Delhi High Court, my Lord, construing, my Lord, this clause has, my Lord, said, my Lord, that this is not a arbitration clause. This is 2022 SCC online Delhi 843. Copy down. The issue whether the use of the arbitration in the heading of an agreement would entail an existence of an arbitration agreement was decided by such and such. Now, my Lord, kindly take, my Lord, where, my Lord, arbitration, same clause has been there in Avant-Garde versus Engineer versus India Suite Limited. Kindly have a look at, my Lord, that clause 15, my Lord, is, my Lord, clause 5. The court is taking
In Bernard Consultancy versus Indo Synergy Limited, the term which was set out as an arbitration agreement contained in clause 14 reads as follows. The parties agree that jurisdiction in relation to the matters under or in connected with the MOU shall be subject to jurisdiction of court at Hyderabad. Arbitration, if any, shall be at Hyderabad. Same here, Millard. Lordship has seen, Millard. The parties have confined the jurisdiction to Hyderabad court and also having jurisdiction in the matter, the parties also shall be prevented from moving to the court other than at Hyderabad. The Chief Justice of Andhra Pradesh has rejected the petition and observed that follow. Although the heading of clause 14 above mentioned is arbitration, the same is not an arbitration agreement within the meaning of the act. It merely provides that the court of at Hyderabad shall have jurisdiction to entertain any suit. It merely adds that the arbitration, if any, shall be at Hyderabad, but to the reasons thereof only, it cannot be said the arbitration agreement has been entered into, which was enforceable under section 11 of the act. So, Millard, the court follows. Now, Millard, other judgments, Millard, are quoted. Kindly have a look at, Millard, that page. In light of the aforesaid decision relied upon by the parties, it appears that to me that clause 11 contained in the work order dated does not tantamount to an arbitration agreement. The said clause merely uses arbitration in the heading. However, in the main body, completely contra. কাগজটা দাও না কপি হয় কোথায় গেল I'm very sorry, Miller. In light of the relied upon, it appears to me that clause 11 contained in the work order dated such and such does not amount to an arbitration agreement. The clause merely uses arbitration in heading 11. However, in the main body of the clause, completely contra indicates existence of any arbitration agreement, since it provides that the disputes, if any, arising of the agreement shall be subject to the exclusive jurisdiction in the city of Kolkata. In my view, the present much a clearer case, even those considered, Miller, these cases are given. The expression arbitration has been used in the heading and the clause. In the present case, the expression arbitration or arbitrator has not been used in the main body. Clause 11 does not contain any term of the clause, remotely shows the parties agreed to constitute a private body. And the agreement finally in burden consulted case inter alia provided arbitration, if any, shall also be at Hyderabad. Even this clause was not accepted by the court as being an binding arbitration agreement on account of using of the court. In the present case, mere use of the expression arbitration in the heading of clause 11 would not mitigate against the substance of the clause, which is unambiguous, states that the dispute arising of the agreement shall be the jurisdiction of the court.
What's your urgency in this matter?
Millard, the matter, Millard, is fixed, Millard, and fixed today. And Millard, kindly have a look, Millard. Very well, Millard. He could have, Millard, very well hold, Millard. That
to serve, we'll go a step ahead. Serve the other side.
kindly, Millard,
It's
stay
separate
this
for the
portion of the order, Millard.
not necessary because it is stated that if no cost is paid, it will be added to the award.
Kindly, Millard,
We do not have an urgency. The
Millard.
regular bench can deal with this.
No, Millard, there is an urgency, Millard. There is no clause. The matter is fixed. There is no arbitration clause. Prima facie, Millard.
It's today.
Yes.
When is the
Millard,
next
they
date?
had, Millard, kindly, Millard, takes, Millard, the recent view of the Supreme Court, Millard, on this context,
I'm not
Millard.
on minutes at all.
Yes.
I'm on the urgency.
Yes. The urgency, Millard, the matter is fixed today. Lordship will kindly, Millard, stay it for a limited period. That's all.
This is fixed once a month, I find.
No, no, it's, Millard, it's
It
fixed
was in December, then it
today at 4:30, Millard, it's fixed. So, Millard, no, it will be held now, Millard. Now, Millard, this, Millard, Mahanadi Coalfields also says the same thing. If there is no clause, no point, Millard,
That is
dragging.
on merits. That is on merits. I cannot stay the entire proceedings for them for now. And
Only,
the
Millard-
cost part also need not be stayed because there is a clause here.
Yes.
If you do not pay, it will be added to the award. If
Yes.
at all the arbitration proceeding
Absolutely.
continues.
Absolutely.
Urgency, let it be placed before the regular bench. Serve the other side, let it be placed before the regular bench.
He could will.
It doesn't really prejudice you at the moment.
Subject to correction, it's fixed for cross-examination. They have to go for the entire button of cross-examination. That's the problem.
You can take an adjournment for a day.
Millard, no further adjournment may not be given there.
Recorded in the order.
No, that's not recorded. Millard, kindly look, Millard. I had taken a point.
The matter has been taken up today, so I don't think the arbitrator will deal with it today. It's pending
Because-
for this court.
Lord-
It's pending before it's subjudice before this court.
Yes, Millard, it may not.
he may not, he may proceed without a stay. And my lord, there is an express, my lord, decision of 2022, which my lord considers this
Asking
clause.
stay of the cost part, isn't it?
Yes.
Which will really not affect you at the
Or
moment.
lordship said me to cut short the matter.
Cannot be stayed at the moment without hearing the other side, right?
It's a 227.
Serve your purpose.
Well, it's a 227, my lord. Normally in a civil suit, we come and get a stay on the suit. Kindly, my lord, appreciates.
Not normally when there's an urgency.
Yes. My lord, my lord,
Not
first day there is no
finally
caveat.
first day.
Because there is no, the reason is, my lord, there is no arbitration clause at all. I have showed, my lord, and the courts have categorically held, my lord, this is the recent view of the Supreme Court also, my lord. Section 16, this point.
Learn counsel for the petitioner.
Kindly have a look at page 29, only one, page 29, have a look at page 29.
29, yes.
29, have a look at page 29. My lord, any adjournment is asked, my lord, I have been awarded as a cost, my lord. That's the problem I am facing.
Where is it recorded?
My lord, page 29, my lord.
Yes.
Mr. Berry contended adjournment was sought for, knowing very well the witness of is coming from Delhi, incurring travel. He has also prayed for granting exemplary cost under the circumstances. I am the view application of the respondent has been held to be an afterthought. Exemplary cost should be awarded for 64 application not been filed with
Stay
the
of the cost part, isn't it?
Yes.
Nothing more.
Yes.
And that doesn't affect you at the moment.
Second stage, my lord, there will be further cost if I go for a ask for an adjournment there.
Doesn't remain, then no question of all these costs and all. I'm only on the urgency part, sir, nothing else, not on merits at all. Petitioner prays for stay of the portion of the order in dated 14th December 2023, imposing cost of rupees 50,000 on the petition.
Section 16.
Correct.
Section 16.
The cost is
In
in
order. Yes.
cost is imposed because, my lord, according to the learned arbitrator, my lord, his application was filed as an afterthought.
Afterthought, I've seen that.
Yes.
By the said order, an application filed by the petitioner under section 16 of the Arbitration and Conciliation Act, common has been turned down upon imposition of costs. The order records that if no cost is paid by the next date, which is fixed on 16 January 2024, such costs shall be included at the time of passing the award in the matter with appropriate interest from this date. Stop inverted comma. Paragraph. The petitioner has made an arguable case. Paragraph. The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite party. File affidavit of service on the adjourned date. Paragraph. The matter be placed before the regular bench. I'm sorry, no assistance.
Well, the next matter is also same.
The same.
Same.
For it to the
13.
A different petition.
It's a different. It's two reference, my lord, same, my lord, before the arbitration. Same rejection. Same parties.
14th December 2023. This is also cost of 50,000, the same.